Thank you all so much for being here. My name is Everett Stanley, and I'm the editor-in-chief of Emory Law Journal. And I take great pleasure in joining the editorial board and welcoming you to the 2023 Randolph W. Thrower Symposium, our first in-person symposium since 2020. It's terrific to have so many students, practitioners, professors, all joining us here, whether in person or via Zoom, to honor the life and legacy of Randolph Thrower and to join us in the discussion that's sure to be timely, engaging, and informative. The Emory Law Journal has hosted the annual Randolph W. Thrower Symposium since 1995. The event bears the name of a highly distinguished alumnus from Emory Law, Randolph W. Thrower, who was a partner at Sutherland, Asbill, and Brennan, and served as commissioner of the IRS from 1969 until 1971. After graduating from law school in 1936, Mr. Thrower served in the Marine Corps during World War II and returned to private practice post-war. Among his many accomplishments, Mr. Thrower served on the ABA's Commission of Women in the Profession, was president of the Atlanta Legal Aid Society, and was chair of the Georgia State Bar Committee on the Involvement of Women and Minorities in the Profession. Mr. Thrower was also one of the founders and first president of the Court of Federal Claims Bar Association and was a founding trustee of the Lawyers Committee for Civil Rights Under Law. Today's symposium is entitled "The Future of America's Efforts to Promote the Rule of Law Abroad." The rule of law is one of those towering ideals that ascends above politics and aspires for universality. All persons, the powerful and the powerless, the haves and the have-nots, are equal under law. All laws should be clear, non-contradictory, predictable, in sum, obeyable, to merit obedience. And law, not violence or caprice, should govern the day. These principles, which only partially capture the idea of the rule of law, have long been principles that America, at least in rhetoric, if not in reality, has aspired to uphold and promote optimistically. The arc of the moral universe bends toward justice, many Americans proclaimed with Reverend Martin Luther King Jr. The end of history is near, many Americans exclaimed with Francis Fukuyama, celebrating the dream and draw of liberal constitutional democracy. Indeed, for decades after World War II, and then again after the fall of the Berlin Wall, there was a sense and a hope that the rule of law and its correlates of democracy and human rights were spreading worldwide with America and its allies at the forefront. But whatever end of history, arc of justice optimism America did have, it has been confronted by powerful and concerning challenges, many of which have blossomed across the past decade. China, led by President Xi since 2013, has increasingly projected its economic might and model of governance, what some call rule by law, across the Asia Pacific and beyond. President Vladimir Putin and Russia has gradually transitioned to an autocracy, invading Ukraine on February 24th, 2022, in flagrant violation of international law. Time and again, as Dr. Kimberly Shepley has explained, democratically elected leaders have engineered the unraveling of their country's constitutions, dismantling the rule of law step by step, law by law. And on January 6th, 2021, armed mobs violently stormed the United States Capitol, incited by rhetoric deeply undermining the legitimacy of our very own governing institutions, prompting the rest of the world to ask, this is the nation aspiring to promote the rule of law abroad? In light of these sobering trends and recent downturns, the Emory Law Journal has found it very important to revisit, wrestle, and wrestle hard with questions about the rule of law and America's role in shaping it moving forward. We sincerely hope that you find this symposium to be edifying, constructive, and even inspiring. And we invite you to engage with all of our speakers in their scholarship, whether here or beyond. What you hear today and the insights will be memorialized in volume 73 of the Emory Law Journal, and this issue will benefit from your contributions. I would like to take a moment now just to thank the people who made today's symposium possible. First and foremost, thank you to the Thrower family. Your generosity is truly incredible, and the symposium is only possible because of you, and it is a testament to your support that we've been able to host this great event for decades now. Thank you to the Thrower Committee, who has helped the Emory Law Journal to shape this idea and make it possible today. In addition to the Thrower Committee, thank you very much to the Emory Law and faculty and administration, Dean Babinski, our Emory Law Journal advisors, Professors Whitty and Smith, and the Emory faculty participating in today's symposium, including Professor Dudziak and Professor Smybert, as well as our Emory Law moderators, Professor Tulabaka and Professor Lutzen. Thank you also to the members of Emory's event planning staff, particularly Tiara Copeland, our events and student support manager. And finally, I'd like to just recognize the members of the Emory Law Journal. Enrique, Grant, and Taylor, our symposium editors, have gone above and beyond to make sure that every detail is accounted for today and that everything just runs smoothly. The two L's on Journal have been working hard all year, and especially in the last week, to make sure that every cog in this machine is running properly, from organizing lunch and the reception to manning registration tables. They're the next generation of Emory Law Journal, and I trust that the next volume is in very good hands. Thank you for your hard work. And last, but certainly not least, my good friend and executive symposium editor, Eric Wang, who came up with the vision for this and has spent truly countless hours making sure that you can enjoy these insights on the rule of law. Eric has put in more work than I have seen anybody put in the past year. And this is truly, congratulations, you've done a fantastic job. And we are very much indebted and grateful to have you on our team. And now it is my pleasure to introduce Dean Babinski, Dean of the Emory Law School.
So I'm delighted to welcome you to Emory Law today on behalf of the law school, our entire community. I also have people to thank, many of them the same people who've been thanked so eloquently by Everett a moment ago. But I just want to take a moment to recognize what really makes this event special. We always hope as a law school place of engagement with law in our society, that we can be a place that brings together expertise, questions, the challenges that our society faces, and work together with honesty and integrity toward solutions. But nothing exemplifies this so much as the Thrower Symposium over time. And it's, I think, truly special that it's led by our students who are just at the beginning of their journeys in law, but who have the foresight to look ahead at what issues face us, what challenges face us, and to bring together the experts that we need to consider these issues together. So I just want to say how proud I am of our Law Journal for having carried out this special event for so many years, and this year in particular for tackling the issues that you'll be addressing today. So I also want to welcome all the students here, the faculty, staff, and alumni, attorneys, judges, people from nonprofits, different human rights organizations, and many others. This topic, as you've heard about, is incredibly timely, selected by students, advised by the Thrower Symposium Committee, but advised in the sense of cheering them on and cheering Eric and his colleagues on as they developed this topic. And as it was selected last year, it was clear that the rule of law was an important issue. It's always an important issue, but Eric made a persuasive argument that it was all the more important today for us to wrestle with. And certainly the events that Everett has flagged in his opening remarks emphasize and reemphasize the timeliness and importance of this topic for us all today. I also want to just acknowledge the journal itself. The Emory Law Journal has been a flagship journal and represented Emory Law School across the country and around the world as a center for bringing together leading scholars. And this issue, volume that will contain this symposium, is sure to add to that, to add to the weight of the journal's leadership and reputation and the reputation of the law school in the years to come. It's already a journal that's quite important to the law school. It's received over 1,000 submissions for volume 72. It's a sobering number for law school faculty members in the audience who are thinking about how to get their work published anywhere, that the Law Journal received over 1,000 submissions. 170 students competed in the write-on competition to join the journal this year, the highest number that have competed in a number of years. This marks the 10th anniversary of the Law Journal's innovative online forum, which provides a opportunity for quicker, responsive type comments on key issues. Of course, want to thank the editor-in-chief, Everett Stanley, Eric Wang. The symposium editors have to be thanked again, Enrique Chalhoub, Grant Schwabrow, Taylor Fay, and the second-year students who I know have been working so hard on this symposium. And I also want to thank some staff, Tiara Copeland, who, as you heard, is the events person who helped make this possible. Bruce Douglas, executive assistant to the dean, Kenyatta Greer, who's the senior director of communications, Grace Joan, the Law Journal Program Coordinator, and also all the digital communications, AV, and design staff who are going to be involved in making today's event successful. Tayo Fayeme, Brandy Williams, Allison Friedley in particular. And I too would like to echo the thanks to the Thrower family. This event would not be possible without the Thrower Endowment, which allows us to carry out this event with such high quality speakers in such a fine setting. And we want to thank in particular Patricia Barmeyer, daughter of Mr. Randolph Thrower, Wilson Barmeyer, grandson of Mr. Randolph Thrower, the Honorable Frank Mays Hall, Mr. Joseph Blanco, and others involved in the advisory committee, including the Vice Dean, Joanna Shepard, and the journal advisors, John Whitty and Fred Smith. Finally, I have to thank all the experts who we will be hearing from today, the speakers, distinguished speakers, the moderators, those who will be setting forth for our consideration their views on this important topic. At a dinner held about, in relation to this symposium last night, Patricia Barmeyer suggested that we actually engage in ideas and vigorous debate. And she requested all the speakers to not be shy where disagreements are present and to highlight them for the audience so that we can really get into what the conflicts and challenges are that lie ahead for us in our society. So for those who don't go to academic events, if somebody says, with all due respect, that means you lean forward eagerly and hear what comes next, because that's what the conflict is. And there are some other cues as well. But we do want to create an atmosphere where we can address these challenges directly together. And I'm very grateful to the speakers and their moderators for the wisdom that they'll be providing today. So with that, I will turn to Eric, and thank you all for being here.
Well, welcome everyone. Thank you for making it here, for joining us on this rainy day that complements the state of the rule of law worldwide. We're very grateful today to be joined by our panelists and moderators, some flying in through winter weather, others driving in through Atlanta traffic, all pouring time, energy, and passion into the symposium. It is our joy to have you with us today. Thank you to the Thrower family, especially Patricia and Wilson Barmeyer, for your faithful generosity in making everything here possible. We are grateful to honor Patricia's father and Wilson's grandfather, Mr. Randolph W. Thrower. Thank you to the members of the Thrower Committee for your wise guidance and warm support every year. Thank you to Dean Babinski and to the Emory leadership and staff, in particular, Tierra. You've worked with me very closely throughout all the logistical puzzles this year, and because of you, we're able to do this once again in person. Bruce Douglas, you've been very efficient, so kind, and always ready to solve problems, including at 10 p.m. last night at our dinner. And of course, thank you to all the other incredible leaders and staff, Kenyatta, Grace, Tayo, Brandy, and Allison, who have made this symposium possible. I want to also thank the members of the Emory Law Journal. In particular, thank you to our editor-in-chief, Everett, for your committed leadership of the journal, for always responding within minutes, if not seconds, and for your judgment, authenticity, and friendship. Our 2L staff, we know this is the busiest time of the year with your comments and spading assignments crying out for attention. So thank you for your diligence in staffing this symposium. And finally, thank you to my team, the symposium editors, Grant, Taylor, and Enrique. You've been so reliable and constructive at every juncture, never once complaining, always doing and doing well. Thank you. Today, we gather to discuss the future of America's efforts to promote the rule of law abroad. The rule of law is a rich concept, and brilliant minds have illuminated different aspects of its substance. The Athenians highlighted equal treatment before the law and protection from arbitrary power. Lon Fuller famously presented 8 criteria that enabled and merited obedience for law, that laws must be general, public, prospective, clear, stable, and so forth. Ronald Dworkin emphasized the need for laws to embody and enforce rights, that the actual content of law matters. And today, our panelists, through theory, history, empirics, and practice, further flesh out what the rule of law means. Though its exact contours aren't always clear, the rule of law is something that most of us find essential, worth promoting, worth protecting, worth preserving. Perhaps the meaning and importance of the rule of law grows when we sense that it is threatened, whether abroad or at home. From the rise of right and left-wing populist movements across Poland, Hungary, Turkey, and Brazil, to the persistence of authoritarianism in China, Russia, North Korea, and Iran, to the deeply disturbing capital attacks and rhetoric at home. Many of us sense that even if laws are in place, the rule of law is unsettled as laws become dismantled, delegitimized, or weaponized for purposes other than the public good. Are recent trends and events just ebbs and flows of political history? Or, given the continued decline of American credibility, are we rapidly falling into another era, a worse era of history? We don't know, but I do know that our deeper existential concerns need not discourage us, but rather invite us to live more intentionally as members of a broader polity. As you listen to our speakers today, we invite you to ask, what are our baseline commitments that should rise above partisan divides? The rules of the game that should stand even when the game itself changes. If variants of American exceptionalism might be harmful, are there aspects of the rule of law that America can and still should promote? How might our unique vocations as students, lawyers, faculty, judges, and nonprofit leaders, and so forth, positively play into the bigger picture? These are only a few questions that you might chew on here and after, and we invite you to not let these questions go. All of this then leads us to our expert speakers, beginning with our keynote speaker, Ms. Elizabeth Anderson, whom I have the privilege of introducing. Ms. Anderson is currently the executive director of the World Justice Project, where she directs its efforts to analyze and advance the rule of law through original research and data, public forums, and a wealth of publications, including policy briefs, country reports, journal articles, and the famous annual Rule of Law Index. Ms. Anderson grew up in a small town in Western Michigan, where perhaps like many Midwesterners like myself, became curious about the wider world well beyond the Midwest. And thus, Ms. Anderson went to Williams College, where she studied history and Russian studies as an undergrad, and from there worked as a journalist and press secretary. Equipped with these experiences, she then went on to obtain a joint degree in law and public policy, her JD from Yale, her MPA from Princeton. Following law and public policy school, Ms. Anderson clerked at the Southern District of New York and then the International Criminal Tribunal for the former Yugoslavia. It was there at the tribunal, Ms. Anderson recalls, that she found her professional passion, the role of law and legal institutions in curbing violence, strengthening governance, and supporting peaceful, prosperous, and successful societies. Pursuing this passion, Ms. Anderson joined Human Rights Watch, where she served as a researcher, director of advocacy, and ultimately the executive director of its Europe and Central Asia division. Building on the expertise she gained at Human Rights Watch, she then became the director of the American Bar Association's Central European and Eurasian Law Initiative for several years, and after that, the executive director of the American Society for International Law. Then Ms. Anderson returned to the ABA to serve as its Associate Executive Director for Global Programs and Director of its Rule of Law Initiative, a program working in over 50 countries to advance the rule of law. Finally, in 2018, she joined the World Justice Project as its Executive Director, where she has been since. Throughout her career journey, Ms. Anderson has taught as an adjunct professor, served on the boards of Williams College and numerous global nonprofits, and has been honored by a host of prominent awards for her powerful contributions to the international rule of law field. Today, Ms. Anderson shares with us her wisdom, the fruits of a lifetime of passion, research, service, advocacy, teaching, scholarship, leadership. And we are absolutely honored that she joins us here today. And so without further ado, please welcome our 2023 Randolph W Thrower speaker, keynote speaker, Miss Elizabeth Anderson.
Thank you, Eric, for that wonderful introduction, and to the journal and all the folks who've been involved in convening the Thrower Symposium for the honor of an invitation to be with you. I'm really looking forward to a full day of insight and discussion about this really important topic. I'm struck seeing my friend Bill Ide as I came in today and reflecting on the last time I spent a fair bit of time here in Atlanta. It was with Bill when I was working at the American Bar Association running its Central and Eastern European Law Initiative, and Bill was the chair of the board. And we had the ABA annual meeting was here, I think it was 2005. And we had the honor of welcoming then President Misha Saakashvili from Georgia here to receive the Rule of Law Award from the ABA. And he had, as you know, come to power in the Orange Revolution and Rose Revolution, and was ushering in many reforms in Georgia in that period. And reflective of the sea change that we've seen in rule of law since that time, I read in the paper yesterday that Misha Saakashvili is on death's door in detention in a hospital in Tbilisi. He's 55, but he is, they think, not going to live long. He is there held on trumped up charges by the Russian-backed government of Georgia, and his counsel and advocates claim that he has been poisoned while in custody and tortured. So indeed, times have changed in very challenging ways. And I really want to commend the journal leadership for selecting this topic of the rule of law. The challenges are significant, they are mounting, and they are consequential. And yet, while we see much discussion of democracy and the rise of authoritarianism among policymakers and scholars in the media, the foundational importance of the rule of law per se to successful communities and to democracy is too often neglected and overlooked. We see the rule of law tacked on to other objectives in a kind of throwaway way. Too often in these conversations, we hear about democracy and rule of law, accountability and rule of law, human rights and rule of law, without serious consideration about the work that the rule of law is doing in those equations, what it means, why it matters, and how we get it. So this conference is a really welcome antidote. In my remarks today, let's see if I can, there indeed it is. Okay. I'd like to begin with an overview of the state of the rule of law, drawing on data from the World Justice Project's Rule of Law Index, and highlight some of the trends that we have seen in recent years. While the overall picture is quite concerning, I will focus on some bright spots and promising developments. And in the bulk of my remarks, I will outline 3 key strategies for taking advantage of those developments and opportunities and turning the tide on the negative rule of law trends. So let me begin with the state of the rule of law. It is well known that we are in the midst of a global rule of law recession, characterized by closing space for media and civil society, declining trust in institutions, and the increased prevalence of authoritarian governance, even in established democracies. Data from the WJP Rule of Law Index provide powerful evidence of the scope, scale, and particular dimensions of this problem. For those of you who are unfamiliar with the index, and I have some copies, which I will share with those who are interested after the talk. This is an annual quantitative measure of the rule of law, now covering 140 countries and jurisdictions. We start with a definition of the rule of law that is largely consistent with that that is promoted by the United Nations. Our definition is a system of laws, institutions, norms, and community commitment that delivers accountability for public and private actors. Number one, just laws that are consistent with international human rights standards, open government that provides citizens with access to information and opportunities for participation and decision-making, and finally, impartial and independent dispute resolution. We'll have a panel later today that will dig into all the very tricky and stimulating rule of law definitional questions. Suffice it to say, for the purposes of measuring the rule of law with the WJP index, we use a more thick and comprehensive definition of the rule of law. Moreover, in measuring the rule of law, we focus on outcomes. We want to know not just what laws and institutions are in place, but how are they working in people's everyday lives. So how do we do that? The WJP index breaks that definition down into 8 factors reflected here on the screen. Constraints on government powers, that's the checks and balances that we hear about in grade school. Absence of corruption, open government, and fundamental rights. Those 4 are elements of the rule of law outcomes that we are measuring that really constrain government and what it can do to citizens. And then 4 more factors: order and security, regulatory enforcement, civil justice, and criminal justice. And these 4 elements are constraints that the government imposes and duties that the government has to its citizens. Each of these factors is in turn broken down into sub-factors. Illustrated here, there are 44 sub-factors in all under each of these 8 factors. For example, the factor number 1 on constraints on government powers is broken down into 6 sub-factors: limits on the executive by the legislature, the judiciary, independent audit agencies or inspectors general type organizations, institutions. 4th, whether officials are sanctioned for misconduct. 5th, the checks from civil society and the media on the executive. And finally, whether the transition in power is governed by law. So that's illustrative of the sub-factors, and we have those for each of the 8 factors. Now, how do we measure those elements? We measure the outcomes in each of these areas through 2 sets of surveys: a survey of ordinary people, a representative sample of 1,000 households in each country, and a survey of practitioners in 4 areas: civil and commercial law, criminal and constitutional law, labor law, and public health. All told, we ask more than 550 questions through these surveys, and the answers are assigned a numerical value and aggregated into scores and rankings for each jurisdiction on each of the factors and sub-factors of the rule of law and overall. The questions we're asking are questions about experience and perception of the rule of law in people's everyday lives. Have you had any interaction with the police in the last year? Have you, and then follow-up questions about that. Have you been solicited for a bribe in registering your child for school? What is your expectation of what would happen if a prominent public servant was found to have stolen public funds for personal benefit? Would they be held accountable? And so on. The methodology generates globally comparable data that is used to inform reform efforts and decision-making by a wide range of actors in government, civil society, international development agencies, and multinational businesses and investors. We've used the same methodology since 2015, so we also have longitudinally comparable data since that period and can see the trends and directions of the rule of law measured in this way. So what do those data show? The headline is not surprising, as many have remarked today. Globally, the rule of law is in decline. Between 2021 and 2022, 61% or 85 of the 140 countries that we studied saw rule of law decline, with declines depicted here in red and improvers in blue, with the darker shades seeing bigger change over that period. This is not just a one-year trend, it's a multi-year trend. Between 2015 and 2022, 64% of countries have seen rule of law decline. And 2022 was the 5th year in a row in which we saw a majority of countries worldwide experiencing declines. You can see that here, with the red line being the percentage of countries with a declining rule of law, and the blue line being the percentage of countries with improving rule of law year over year. The pandemic was particularly hard on the rule of law, as governments asserted emergency powers, rights of assembly were curtailed, courts closed, and justice delays mushroomed. Between 2020 and 2021, 74% of countries studied saw declines in the rule of law. That's that big jump in the red line there. While rule of law erosion was not as prevalent this year, between 21 and 22, we have not seen it rebound as we hoped either. Indeed, 2/3 of the countries that we measured that had a reduction in the rule of law between 2020 and 2021 further eroded between 2021 and 2022. The decline in the rule of law has been evident in every region of the world and in rich and poor countries alike. Moreover, it shows up in almost all dimensions of the rule of law that we measure. Between 2015 and 2022, reflected in this chart, in 7 of the 8 factors, excluding only regulatory enforcement, we saw a majority of countries declining in their index score, with the most prevalent declines in 2 factors, factor 1 and factor 4. Factor 1, 68% of countries declined in constraints on government powers. And factor 4, fully 76% of countries saw erosion in this area. Over the period, we've seen dramatically widespread declines in core fundamental freedoms, particularly freedom of expression and freedom of association, 81% of countries and 85% of countries, respectively. And since 2015, 67% of countries have seen a decline in the sub-factor measuring whether transition of power is subject to the law. So this is a sobering picture indeed. And when we see these negative trends year after year, it can seem as though we are stuck in a permanent rule of law recession, that those hopeful times that Everett referred to earlier are never to return. Yet there are some bright spots and some countries that seem to be bucking the global trend and making persistent rule of law progress. Indeed, although we're much preoccupied with the dire rule of law circumstances in Russia and how that is overflowing in its neighborhood and globally, it's also striking to see that there are some former Soviet states that are taking a very different path on rule of law, reflected in this chart here, or map here. Since 2015, 5 of the top 10 Improvers in the WJP index are former Soviet states: Kazakhstan, Uzbekistan, Moldova, Ukraine, and Estonia. There are countervailing forces to rising authoritarianism. And we are reminded by these examples that there is nothing inevitable about the rise of authoritarianism. There are indeed developments and strategies that we can harness to turn the rule of law tide. And I want to take the remainder of my time today to elaborate 3 such approaches that I think hold promise for the future of rule of law efforts. The first strategy is standard setting and accountability. It is important that we are clear about what the rule of law means and requires, that standards are established at the global, regional, and national level, and that these are effectively monitored and enforced. When we look at the WJP index data, it is true that we have seen the rule of law decline in every region of the world. Yet, as we look more closely, we also see a concentration of progress in one region, Europe and its neighborhood. And this is not a coincidence. I call it the European Union effect. The EU has written rule of law requirements explicitly into its founding documents, laws, and regulations. And in recent years, it has become more serious about monitoring and enforcing compliance with these standards, particularly in the face of blatant violations by 2 member states, Poland and Hungary. The jury is still out on whether those enforcement efforts will work, but it does seem that holding those states accountable, particularly by holding up much needed COVID relief funds and tying those funds to stipulated reforms, may be beginning to reverse the democratic erosion in those EU member states. Meanwhile, EU standards serve as a powerful incentive for rule of law progress in countries that hope to join the club. This year in our index, 2 of the top 5 performers were Moldova and Kosovo. Globally, very much motivated by their hopes for EU membership to undertake meaningful reforms. Critically important to the success of such efforts is clarity about the definition of the rule of law and the specific standards that it entails. Rule of law rhetoric is very much in vogue these days, frequently and sometimes cynically, I would argue, invoked by all sides of various policy and political divides. Everyone wants to claim that the rule of law is on their side. This capacious and complex concept is vulnerable to being co-opted and even weaponized in ways that are actually quite harmful to the concept, that undermine it. It's very confusing to the public. Thus, we can see, for example, China's President for Life, Xi Jinping, has published Xi Jinping Thought on Rule of Law, by which he means fealty to the Communist Party. Hungary and Poland responded to European Commission and rule of law infringement measures by announcing that they would establish their own rule of law institute to define and measure the rule of law in their image. Against this backdrop, it is imperative that international organizations, donors, and rule of law reformers articulate clear standards and educate the media and the general public about the meaning of the rule of law, what it is and what it is not. While the European Union's explicit and prominent focus on the rule of law has been particularly effective, it is not the only standard bearer in this area. Indeed, we see rule of law conditionality by international development organizations such as the Millennium Challenge Corporation, the World Bank, the IMF, all proving a powerful stimulant for reform. And it's not just public sector investment that matters. Increased attention to rule of law concerns by the private sector, for example, the U.S. Chamber of Commerce's new Rule of Law Coalition. These efforts can also drive important rule of law progress. And this brings me to my second strategy for turning the tide on rule of law, harnessing the private sector movement to embrace environmental, social, and governance, or ESG, concerns as core business interests. The past decade has brought a dramatic sea change in the private sector's orientation to rule of law and governance concerns. It's hard to overstate how significant this shift has been from a time when facilitation payments were considered part of doing business, indeed even tax deductible in some jurisdictions, to today's reality of global compliance programs and anti-bribery enforcement. Or from a time when only a handful of companies took seriously the human rights or environmental impacts of their operations, to today's mainstreamed efforts at impact assessments and mitigation plans, driven and enforced by socially minded investors. Increasingly, global businesses across diverse sectors see the rule of law as a bottom line issue, no longer just a nice to have, but a need to have. And this gets the attention of governments and policymakers who must embrace systemic reform. Again, we see this in WJP's index and data. The progress we see in some surprising places, Uzbekistan and Kazakhstan, for example, both show up as among only a handful of countries that have globally that have improved their rule of law index score year over year since 2015. They still have a long way to go to shake off their totalitarian past, but we see tangible progress across many factors in the index. And we know from dialogue with these governments that this is an intentional effort to implement reforms that will show up in these data. Uzbek Minister of Justice Ruslanbek Davlatov explained his country's reforms at WJP's World Justice Forum last summer. He said, "I think the rule of law is the single concept that can really change the lives of people. Even if you don't have proper economic development, a proper economic development plan or natural resources, rule of law itself can make your country develop." The ESG movement has driven home this connection between the quality of governance and investment and economic development. And this is an enormous opportunity for the rule of law movement, but much needs to be done in order to make the most of it. First, the case must be made for prioritizing the rule of law among the ESG objectives. To date, much of the emphasis in ESG efforts has been on the E, the environmental side of things, with S and G relatively neglected. Little attention has been paid to the governance requirements for effective environmental protection, and social and governance considerations have largely focused on labor practices and diversity in hiring and in the boardroom. Don't get me wrong, these are important to be sure, but they are only the tip of the iceberg of the rule of law considerations that businesses should be taking into account. Related, most ESG metrics monitoring and reporting focus on the enterprise level, sometimes encompassing the full stream of operations along a company's supply chain, but rarely engaging the systemic factors in the broader society that affect those operations, not looking at issues like the broader quality of the rule of law in society. Now, this is understandable. Companies will focus on what they can control, the conduct of their own operations and those of their suppliers and business partners. Certainly, that's an important start. But it is not a long-term or sustainable solution, because it is difficult for a business to truly insulate itself from rule of law and governance gaps in the broader environment in which it operates. Human resources policies that promote diversity, equity, and inclusion are undermined if a company's employees or would-be recruits face systemic racism in the national education, healthcare, or justice systems. Even the best corporate compliance program will provide little comfort where local labor laws are unenforced or public corruption goes unpunished. And a company's efforts to green its own operations will fall flat if regulatory enforcement of environmental standards along its supply chain is weak. Unless they take on the broader rule of law conditions in society, individual companies' ESG efforts risk falling short. And they ultimately let governments off the hook, essentially privatizing responsibilities for good governance that states should assume. In order to realize the rule of law potential of the ESG movement, we need to develop mechanisms for companies to address governance concerns beyond their direct operations and supply chains, to become advocates and supporters of broader rule of law progress in the societies in which they operate. Urging government action on corporate governance concerns is, of course, difficult for any one company to undertake. But working together, businesses can articulate their expectations and spur governments toward international best practices. Through private sector organizations and platforms, businesses should emphasize that ESG issues are not just corporate concerns, but they expect governments to support progress as well. The private sector should encourage governments to take seriously their international commitments and to demonstrate meaningful progress toward implementation. Businesses should support research to identify effective governance approaches and advocate and support uptake of promising reforms. And businesses should make clear that they monitor government performance and that it affects the decisions they make about where they invest and where they operate. WJP has seen this approach in action when global investors publicly rely on our index and say that they're doing so in making decisions. Suddenly, ministers of finance, ministers of justice come calling to talk to us about the data, to understand what it tells them about the reforms that they need to implement. Finally, international development actors, such as USAID, should develop public-private partnerships in the rule of law arena. Such partnerships have been particularly prevalent in areas of health and agriculture and food security. But a 2016 study of over a decade of public-private partnerships found that just 7% of them were dedicated to democracy, rights, and governance. As ESG takes hold, we've seen some more public-private partnerships announced, but again, these have largely focused on the environment. So much more can be done to engage the private sector in global rule of law efforts. Now let me turn to my third and final promising strategy for turning the rule of law tide: advancing a people-centered approach to the rule of law and to justice. This is one of the most exciting recent developments in global efforts to advance the rule of law, in my opinion. It is a paradigm shift from evaluating and engaging justice systems from the perspective of institutions, courts, and judges and lawyers, to doing so from the perspective of the outcomes that those institutions deliver for people. This shift has emerged in the context of the Sustainable Development Goals, the commitment to leave no one behind, and SDG 16's promise of access to justice for all. WJP has been pleased to contribute to this global policy conversation by drawing on the tradition of legal needs surveys and undertaking a study that globally maps people's unmet legal needs, understanding What kinds of justice problems people have, how do they resolve them, and what consequences do they have in their lives? Through this work, we have developed an estimate of the global justice gap to be filled to realize the SDG promise of access to justice for all. This research, we undertook these legal needs surveys in 101 countries. The research yielded 4 key findings. First, that legal problems are widely prevalent in people's lives. Half of the 100,000 people we surveyed reported that they had a serious legal problem in the past 2 years. The most common problems are consumer, housing, money, and debt issues. Second, these unsolved legal problems produce negative consequences in people's lives. 29% experienced a stress-related or physical ailment or illness as a result of their legal problem. Legal problems caused job loss or relocation requirements for 20% of respondents. The third finding is that poor and marginalized people are disproportionately affected, both by the prevalence of these problems and the consequences in their lives. And finally, most people, this is most important, most people do not turn to courts and lawyers to solve their legal problems. Only 29% obtained information, advice, or representation to address their legal problem. Approximately 1 in 6 said that legal costs were a problem. But the biggest obstacle preventing people from obtaining relief was lack of information, lack of awareness that they had rights, that the justice system offered solutions to their problem. So understanding justice systems in this way, from the user's perspective, radically changes the way in which we work to strengthen those systems. Take, for example, the use of technology. International development agencies have in the past 2 decades spent billions introducing state-of-the-art case management systems and automizing courts around the world, all with an aim to strengthening the rule of law by increasing transparency, accountability, efficiency, and access to justice in courts. The pandemic has accelerated progress and focus in this area of using technology in justice systems. And certainly this has improved court functioning and the lives of judges, lawyers, and litigants. But if less than 1/3 of people are taking their legal problems to courts, those interventions are missing the vast majority of the need. This approach is like focusing a health intervention only on making hospitals run more efficiently and neglecting public health interventions like vaccination or sanitation. Our technology efforts might better be focused on information resources in the form of an app or an AI solution that would guide people with legal problems to the solutions that are available. A people-centered approach to justice prioritizes prevention. When we map people's justice journeys, the kinds of problems they have, how they develop and mushroom, cascade one problem into another, we see the need for early preventative interventions. We might prioritize, for example, solving the problem of the 1 billion people globally who lack proof of legal identity. Imagine how many times a week do you use your legal identity to navigate some need? And if you have no proof, what impact that has in your life? We see in the data how this problem shows up in a number of related problems, from land and housing issues to access to formal employment, family and migration challenges as well. On this and many other justice problems people face, an ounce of prevention is certainly worth a pound of cure. The good news is that this kind of people-centered approach is catching on. It was kickstarted by the Task Force on Justice, led by the governments of Argentina, the Netherlands, and Sierra Leone, and advanced through a global civil society campaign called Justice for All. This approach is now being championed by international development organizations such as the OECD, UNDP, and the International Development Law Organization. And now a new group of 18 countries is standing up the Justice Action Coalition to sustain people-centered data collection, research, identification, and implementation of best practices in this area. The United States is also getting on board. At the upcoming US-hosted Summit for Democracy in March, the United States is expected to join the Justice Action Coalition, and USAID is due to launch a new rule of law policy, which explicitly turns a couple of decades of USAID rule of law development efforts on its head and embraces a paradigm shift to people-centered justice in its rule of law work. That the United States will take these steps in the context of the Summit for Democracy is important. It drives home the critical relationship between people-centered justice on the one hand and turning the tide on rising authoritarianism on the other. One of the most disturbing and challenging aspects of the recent turn to authoritarianism is that it has occurred not just in countries with long-standing authoritarian tendencies or in fragile states with governance gaps that allow authoritarians to seize control. But we've seen this trend also in established democracies where would-be autocrats have skillfully exploited popular dissatisfaction with and mistrust of democratic institutions. Institutions that people perceive as corrupt, self-dealing, and ineffective, unresponsive to their needs. Against this backdrop, a people-centered approach to justice that helps people solve their everyday legal problems is an important part of rebuilding trust and demonstrating that democracy can indeed deliver. In promoting people-centered justice, as well as the other strategies that I've outlined today, it is important that US efforts to advance the rule of law around the world begin here at home as well. We cannot expect to be able to lead a resurgence of the rule of law unless we are credibly working to strengthen our own norms, institutions, and practices. And on this, there is much to be done. We have seen a marked deterioration in US performance in the WJP Rule of Law Index since 2016, particularly with respect to our metrics of constraints on government power and on fundamental rights. Erosion in these two areas has compounded long-standing weaknesses in our measures of discrimination and access to justice, landing the United States in our index at a middling rank of 26th out of 140 countries. The US justice system is decidedly not people-centered. Indeed, in the WJP index, the United States ranks 115th out of 140 countries for the accessibility and affordability of our justice system. And it ranks 121st out of 140 countries with respect to discrimination in the civil justice system. As legal academics, lawyers, and soon-to-be lawyers in this room, we need to own that failure and its implication for trust in institutions and our democracy. I know that today's conference is focused on the future of US efforts to promote the rule of law around the world, but I do think that we can only credibly lead in this area if we are seen to take seriously our own challenges as well. With that, let me conclude and invite your comments and questions and the friction that we were challenged to generate last night. I hope that I've laid some useful groundwork for our deliberations at this conference, highlighting the scope and scale of the challenge of promoting the rule of law against some very significant headwinds. I hope I also have underscored the urgency of doing this and identified some promising strategies that I look forward to developing with all of you. And I welcome your insights and ideas, and I think we have a couple of microphones there that folks can line up for, and please let me know if you have any questions about the data or the strategies that I've outlined. Thank you very much.
Yes, and yeah, if you could stand up at the line up at the mics if you have questions, and they will be turned on for a few minutes of questions first.
Yes, here.
Oh, there we go. So my question is kind of adjacent to your talk, not directly on point, but I want to get the benefit of your experience and your opinion on war crimes in Ukraine. So there are about 60,000 or maybe even more now open investigations. And it's kind of a mess deciding who is going to have ultimate authority to investigate and prosecute. I mean, I think my preference and a lot of people's preference would be the UN, given that Russia's on the Security Council, they have veto power. I don't know if that's going to happen. The International Criminal Court, a lot of people have lost confidence in. It's been fairly ineffective. And then I know that Ukrainian prosecutors want to take responsibility. But I'm wondering what your thoughts are on whether that would basically get the respect of the world community if they are prosecuted internally. Ukraine has had its own problems with criminal justice in the past. And so I just want to know what your thoughts are on what the best tribunal mechanism for bringing those war criminals to account for their actions, how you see that playing out.
Thank you. Well, you're absolutely right. It's a very complex question, and I'll betray my my bias in this, which is as a rule of law development person, I think about accountability in terms of the impact it will have in the long-term development of rule of law and justice in that context. And I often think about this as thinking about not just transitional justice, but transition to justice. And so I think it's quite important that these exercises be developed with that lens. And that tends to prioritize local accountability efforts that are locally owned, and that by pursuing that accountability locally has the parallel effect of strengthening local justice institutions. So that leads me toward a preference for accountability in Ukraine, though of course that presents some of the challenges of legitimacy that you flag. A very, I think, promising model are hybrid tribunals that we've seen in a number of contexts where there's international expertise that's brought to bear. Maybe sometimes it is an international accountability exercise that is located locally. We saw that in Sierra Leone, for example, as particularly productive. So I would encourage that direction. Let me take a couple of questions.
Good morning. How damaging has the Patriot Act been to the rule of law in the U.S.?
Okay, I'm going to take one more.
So was that a pass?
Yeah, I'll take a couple and then I'll answer them both. Yeah.
I'm actually interested to hear that answer before. That's okay.
Well, one of the things I tend to shy away conclusions that any one piece of legislation or any one court decision makes or breaks the rule of law. And I tend to suggest that we think more in terms of trends and tendencies. And certainly the recent legislative acts in the United States, including the Patriot Act and court decisions and rhetoric from public officials have all contributed to the erosion that we see, particularly in factors 1 and factors 4 in our index, constraints on government power and fundamental rights. But we have not, in our surveys, because we want the data to be globally comparable, we don't ask specific questions about specific legislation and its impact, but we can see in the broader trends the impact. Yeah.
Does your methodology take into account variations from state to state of, say, media influence on public perception, since it is so reliant on perceptions of
so our data is both perceptions and experience. So it's a mix of those. And the way in which we really control for the maybe misperceptions that are generated by media coverage is by having large sample sizes that give us more statistically robust outcomes. But you're right that if it is pervasive, the media misinformation can have an impact in the data. Yeah.
Hi, so I'm curious what you make of the fact that a lot of or several of the leaders that have presided over rule of law erosion in their countries have been democratically elected and in some cases reelected. And I guess in particular, do you think that that signals that citizens might be, willing to trade a little bit of rule of law for economic prosperity, military security, what have you?
Yeah, I think as I mentioned, I think that's one of the most alarming aspects of this trend, that rule of law erosion appears to be, at least in some contexts, popular. And that's a really important thing for us to absorb. And I think the answer is multifold, but among the things that we need to do is make sure that rule of law institutions and norms are broadly understood. I think civics education that makes that clear to people is really important, so that people understand what's at stake and what rule of law does and delivers, and what it's like not to have it. And that's one. I think we also, though, need to look honestly at how well our rule of law is functioning for people. And, as I mentioned, is our justice system actually delivering for people, helping them solve their everyday problems? And if not, then maybe it doesn't deserve the trust that we think it does. And so we need to roll up our sleeves and work on that, make sure that the justice system does indeed deliver. Yeah, another question here?
Yeah, just curious, would you say that the United States' historical influence on sort of global development of rule of law has been positive, negative, neutral? How would you characterize that?
Very hard to generalize. I think it's probably in some contexts been decidedly negative, but I would say overall, still the United States model, even if we don't always live up to that ideal, has been a powerful force for the rule of law globally. And I do think that U.S. Development efforts have made meaningful difference in many contexts.
You join me in thanking Ms. Anderson for
And anyone who's interested, do come take these books off my hand so that I don't have to lug them home in my bag.
There will be coffee and tea in the atrium. Please enjoy. And then we'll be back at 10:30 for panel 1. Thank you. So without further ado, welcome back to panel 1, Contemporary Threats to the Rule of Law. I would like to welcome our moderator of the panel, Professor Magdalena Tulibacka, who is here with us. She is a faculty lecturer here at Emory University School of Law, and has a strong expertise in international and comparative law and European Union law, and she will be moderating this first panel. So please join me in welcoming Professor Tulibaska.
Thank you very much, Eric. First of all, I'd like to thank the Emory Law Society and all our wonderful students for organizing this splendid gathering of thinkers and doers, and for inviting me to join. I'm honored and humbled to be chairing this panel on contemporary threats to the rule of law. If you haven't yet managed to trace the accent, ladies and gentlemen, I am Polish. I have lived through two very dramatically different eras in my country's history. Communism, and then since 1989, the newly born democracy and the rule of law. Some of my earliest memories are my father, who was a member of the Solidarity movement, which was the opposition party at the time, reading secret newspapers and other papers in our small apartment. The members of the secret police searching my flat for those secret papers and newspapers, and they didn't find them. We hid them really well in a little clock hanging on the wall. Then the martial law in 1981, when I was 6 years old, and I was terrified that my father would be arrested and taken to jail and taken away from us. And then in 1989, my father crying tears of joy because communism was over and we were now free. And then in 2004, both me and my father crying tears of joy because Poland has joined the European Union. Never in our wildest nightmares would we expect that 20 years on today, Poland would be one of the subjects of the symposium such as this one, where we have concerns about the rule of law. The rule of law will once again be threatened in Poland. But of course, Poland is not the only country where the rule of law and democracy have suffered setbacks. And I can definitely say rule of law and democracy are fragile, living mechanisms. They need our care, they need our attention. And I am so glad that we're doing this today. Now, having thought that we got to the end of history, haha, Mr. Fukuyama, joke's on you. We're now facing threats to liberal democracy and to the rule of law, while in some parts of the world, those threats can come with autocratic, authoritarian leaders supported by a loyal, or at least if not loyal, well-paid armies of soldiers. In other parts of the world, they come with populist leaders supported by, again, armies of loyal or at least well-paid lawyers. Plenty of authoritarian leaders use the law as a tool to maintain power. So what I wanted to emphasize here today is that when we're talking about the rule of law, I think it's probably stating the obvious, but the law has to rule, but the law has to be good. The law has to be just. I think that's one thing we need to pay attention to. And just to take this back to what Miss Anderson was talking about earlier, I'm so glad that there's so much emphasis on access to justice, because even if we have a good law, if we can't access the law is of no use. This is just my little introduction to the topic of this panel, which is contemporary threats to the rule of law. And just a little bit of housekeeping rules. So we have now about an hour and 25 minutes for this panel. We have three wonderful panelists that I will be soon introducing. Each panelist will speak for about 20 minutes. And I will be quite vicious in keeping the time, because it is important that we also have time for questions and answers. So I have this magic pen that I've received from my children for Christmas, and I will be waving that pen once the time is up. So I apologize in advance. So I'm planning to have about 30 minutes for question and answers. That is the plan. So now, without further ado, let me introduce our first panelist. It's Professor Monica Nalepa. Professor Nalepa is Professor of Political Science and Director of the Transitional Justice and Democratic Stability Lab at the University of Chicago. Professor Nalepa is focusing on post-communist Europe, and her research interests include transitional justice, parties and legislatures, and game theoretic approaches to comparative politics. Her first book, Skeletons in the Closet, Transitional Justice in Post-Communist Europe, was published in the Cambridge Studies in Comparative Politics series and received the Best Book Award from the Comparative Democratization section of the APSA. Her next book with Cambridge University Press, which was published just this past year, 2022, is entitled After Authoritarianism, Transitional Justice and Democratic Stability. She has also published articles in many scholarly journals. She's also director of the Transitional Justice and well, I've mentioned that already. Professor Nalepa, the floor is yours.
Thank you so much. And it's a pleasure to have a chance to speak here, despite the fact that I cannot be there in person. And I apologize for that. The work I'm going to be presenting today is a joint project with Katerina Chiopri, who is a PhD candidate at Harvard's political economy program. And we're going to be talking about some experimental evidence that we have been analyzing as an extension of a project on closet autocrats that was started some time ago in joint work with George Vanberg. And the work with George and Katrina also was motivated by, well, no, it was not motivated, but it's well illustrated by this cover from The Economist magazine, which shows a wolf in sheep's clothing. And we've adopted this as a mascot of a series of papers that we've been collaborating on. So let me, I'm a political scientist, so political scientists also always have to be motivated by a puzzle. So our puzzle is, how do we explain authoritarian backsliding in democratic settings? And specifically, how is it possible, as Professor Dolipatzka very eloquently presented in her introduction, how is it possible that countries that seem to be so attached to values of rule of law and democracy are actually witnessing backsliding? Or in other words, how does it happen in countries where citizens actually express very strong support for democratic values? So again, to motivate this is a graph showing, comparing in 2019, peace voters, so people who voted for the Law and Justice Party in the previous elections, with non-peace voters, according to their answers to a series of standard questions that are used by political scientists and social scientists in general to assess democratic attachments of citizens. So they include indifference between democracy and authority, agreement with the statement, sometimes an authoritarian rule is needed, authoritarianism is better than democracy, and strongman rule is better than democracy. And the key thing to take away from this is there's virtually no difference between peace voters and non-peace voters, according to these questions. Our work is, of course, not isolated in discussing democratic backsliding. Even within the field of political economy, there have been some breakthrough articles that were published just in the last few years. So it includes, most importantly, work by Milan Svolik, work by Adam Przeworski and his student Xiaoqian Luo, Carlo Prato and Edo Grillo, as well as several American politics scholars, among them Ken Shepsley and Will Howell. So our approach builds on these contributions, but what distinguishes it from these contributions is that we believe that backsliding is a dynamic process, that it's something that unfolds over time, very gradually, and that typically there's some uncertainty about what the ultimate intentions of governments are. So very frequently what happens is institutional reforms are adopted, that are both compatible with some ordinary policy goals, as well as potential autocratic power grabs. So when I teach this paper to my students, what the example I like to give is actually from tightening restrictions on reproductive rights. So even though policy-wise, one might not agree with tightening of reproductive rights, most frequently, like such actions are not anti-democratic per se. And therefore, when we observe, for instance, an executive's attempt to meddle with the staffing of a constitutional court, what the ultimate goal behind that might be a policy change, such as tightening reproductive rights. But another byproduct of that could be having that same constitutional court that has been staffed by this executive then undermine the result of elections. So citizens might often tolerate certain institutional reforms conducted by an executive in hopes that their goal is to change policy, as opposed to stay in power forever. I'm going to just summarize the model from my previous work with Katerina Chiapri and George Vanberg in the key graphic from that model, and then I'll tell you about the experimental evidence that we collected in Poland in 2019 to corroborate it. So again, to substantiate our claim that authoritarian backsliding, or democratic backsliding rather, is a dynamic process, we posit that there are two dimensions in politics. There's a policy dimension, and that's the horizontal axis here. And then there's an authoritarian dimension. And on the policy dimension, citizens have preferences, and we can actually think of a sort of median or typical citizen as having preferences like right here in the middle of this policy space, and he's marked with XC. Then we can think about an opposition candidate who is challenging an incumbent, and his preferences are at 0 on the policy dimension. And we're going to assume for the purposes of this exercise that this opposition challenger is definitely not somebody with autocratic intentions. And then there is an incumbent, and this incumbent's preferences are represented here at 1 on the policy dimension. And it's unclear where this incumbent is on the authoritarian dimension. So game theorists represent this as an incumbent of 2 types. On the one hand, the incumbent could be an ideologue. So he could only be interested in conducting institutional reform for the sake of implementing his policy preferences, such as tightening reproductive rights. But he could also be a type who is a closet autocrat, meaning he wants to introduce institutional reform, but only so that in the next period following his re-election, he can undermine democratic procedures even further. So the second type of incumbent, which we call the closet autocrat, or the titular wolf in sheep's clothing, his preferences are represented over here. And the way that our game unfolds is that in the first period, before the election, the incumbent gets to implement an institutional reform, and that is represented here by I. And the key thing about this institutional reform is that it opens up a space on the authoritarian dimension that could be, but doesn't have to be, exploited. So once this institutional reform is implemented, policy can be changed on the horizontal dimension, but it can also be moved in the authoritarian dimension. And the crux of the problem is that the citizen doesn't know if the institutional reform is coming from this ideological incumbent or from the closet autocrat. And he has to infer or update what kind of politician he's dealing with after observing this institutional policy choice. And following the institutional reform, he decides whether to re-elect the incumbent or to choose the opposition challenger, of whom he knows for certain that he has no authoritarian elections. And then in the second period after the elections, whoever was elected to office implements policy. So the closet autocrat is going to try to move policy as close to his ideal point as possible, which is here at 1-1, the institutional ideological incumbent is going to try to move policy as close to his ideal point as possible, and then payoffs are collected. So in political economy, this kind of model is called a signaling model, or a game of incomplete information with updating, and it's solved for equilibria. And in general, there are two types of equilibria, to put it bluntly. There are separating equilibria, in which the two different types of the incumbent take actions that are different enough that the citizen is able to tell them apart. So after observing the institutional reform, he can tell whether he's dealing with an ideological incumbent or a closet autocrat, and those are known as separating equilibria. Or on the other hand, there are pooling equilibria, which for our purposes are really dangerous, because these are equilibria in which the two types behave exactly the same way. So the closet autocrat actually mimics the behavior of the ideological incumbent in hopes of getting the citizen to re-elect him. So even though typically in signaling models, analysts focus on the separating equilibria because they're interested in learning or when updating takes place, what we use from this apparatus of political economy of signaling models is actually helping us understand how the gradual process of democratic backsliding unfolds. So in summary, there are three types of, well, actually there are 5 types of equilibria, but we can group them into 3 types. The first type is, given the institutional reforms that are adopted, the citizen replaces both the incumbent and the opposition. This is actually also a pooling equilibrium, but the incumbent gets replaced and the opposition comes to power, no backsliding happens. The second type is that given the institutional reforms that are adopted, the citizen only re-elects the ideologue and replaces the closet autocrat with the opposition. This is that separating equilibrium, where after observing the action taken by the incumbent in the first stage, the citizen is able to tell the two apart and makes the right choice. He elects the ideological incumbent, who maybe is very radical in his policy preferences, but at least won't make authoritarian paragraphs. But he spots the closet autocrat and refuses to re-elect him and replaces him with the opposition. And then there's this third type. So this is the type where the institutional reforms are adopted and the citizen chooses to re-elect both the closet autocrat and the ideological incumbent because they actually choose the same institutional reform. So the citizen is not able to tell them apart. And this is the scenario that we argue played out actually in Poland, among other places. This is where these equilibria occur. So this is a space that's characterized by the preferences of this representative citizen. So note that in the graphical representation that I showed above, I fixed the preferences of the citizen. I said that they're somewhere in the middle of this policy space, but they could be anywhere from 0 to 1. So that's what we allow to vary here on the horizontal axis. And then there's this parameter alpha, which is very important because this is the parameter that represents how much uncertainty the citizen has about the type of incumbent he or she is facing. So even though, as I said, the citizen doesn't know whether he's dealing with an ideological incumbent or a closet autocrat, citizens have beliefs about this. So we can think about this as follows. In established democracies, where there are few incidents of undermining democratic rule, citizens probably attach a very low probability to the fact that they're dealing with a closet autocrat. But in fragile democracies, fresh after the transition or with a long history of coups, maybe they attach higher probability to that. And we use these two parameters to map out when these different equilibria occur. So again, the equilibrium that we're particularly worried about and that we focus our paper on is this pooling equilibrium where both the closet autocrat and the ideological incumbent are re-elected. And when does this happen? Well, this happens when the citizen has pretty extreme preferences or preferences that are distant from this opposition challenger and has a pretty low belief that he is dealing with a closet autocrat. Okay, so let me now summarize the implications. So the implications of the model are that as the citizen is less concerned about authoritarian backsliding And as he believes that it is less likely that he's facing a closet autocrat, the pooling equilibrium, so this dangerous equilibrium, become even possible even for fairly moderate citizen preferences. As a result, authoritarian backsliding is easier to achieve. Now, as the citizen's ideal point moves to the right, it's easier for the incumbent to pretend to be the wolf in sheep's clothing and easier for the citizen to tolerate the closet autocrat. There's also another implication, which is that as the citizen is less concerned about authoritarian backsliding or believes that she's less likely to be facing the closet autocrat, the pooling equilibrium becomes, sorry, this is what I already said. Let me move to the third implication. There is an environment where citizens' preferences are closely aligned with the opposition. And in that case, the two types of incumbents separate by proposing different institutional reforms, and only the ideologue is reelected. So no authoritarian backsliding occurs. So what this suggests is that citizens' preferences are relevant here. And the way that we interpret these citizens' preferences is that if the typical citizens' preferences are far from the anti-authoritarian opposition, this is consistent with a polarized society. So in a sense, our work also corroborates work that says that polarization contributes to democratic backsliding. Let me move now to Poland. This is a quote from our Prime Minister Morawiecki. And it actually comes from, as I gleaned from the conversation over break, from a neighborhood pretty close to where Professor Tulibacka comes from. So this comes from a speech given actually to a high school, and there were crowds of protesters gathered and chanting "Constitution, Constitution," alluding to the fact that President Duda was failing on the job of enforcing the basic law. And Duda remarked, "You are allowed to protest only because I respect the Constitution, but rest assured that a majority of people living on the coast feel threatened by the fact that there are justices on the Supreme Court who pronounce sentences on members of the opposition during martial law." So this quote is supposed to highlight that the government in its rhetoric was, when it was implementing far-reaching judicial reforms in Poland, so forcing into retirement constitutional Supreme Court judges, increasing the number of Supreme Court judges so that it could pack the court with its preferred candidates, and undermining the ability of the National Council of the Judiciary to propose candidates. It was trying to lead citizens to believe that it's only doing that as a part of its broader decommunization program. So because decommunization politics and lustration politics failed to reach the judiciary, because they were in every instance struck down, the way to deal with the fact that Polish courts are full of people who practiced law under communism is basically to implement these far-reaching judicial reforms. And by propagating this rhetoric, what we argue is that they created this uncertainty among citizens, where it was not clear whether the goal of these judicial reforms was indeed the policy goal of completing decommunization, or whether the goal was actually weakening a Supreme Court, enabling the executive to stay in power longer. So what we test is that when the conditions of this pooling equilibrium obtain, so when the re-election of the incumbent by citizens who are uncertain whether they are about to elect the closet autocrat or the ideological incumbent is more likely, this should happen when the ideology of the citizen shifts to the right, the probability that the incumbent is in fact a closet authoritarian is lower, and the importance of avoiding authoritarian rule is sufficiently high. So this is a summary of the reforms that had been implemented by PiS since 2015. And as we know, these reforms were then sent to the EU Court of Justice, who finally, in the year of 2019, was supposed to rule whether these reforms comply with the EU treaty. And this happened within just weeks of the opportunity that Polish citizens had to re-elect the PiS government. So what we used in our experimental setting is we used this the coincidence of the election and the decision that was coming out of the EU Court of Justice about the legitimacy of the peace reforms as an opportunity to see whether revealing this additional information about the probability that the peace incumbent is indeed a closet autocrat decreased the willingness of Polish of peace voters to re-elect the incumbent. So we conducted a survey with peace voters from 2015, and the people who were classified as peace voters were classified on the basis of their vote in 2015, but the survey was conducted in 2019, just after the EU CJ ruling. And we wanted to see how their readiness to re-elect peace changes with the following treatment and control. So we divided these respondents into two groups. The treated group received information about the decision of the Court of Justice of the European Union. And this was actually a correct statement of what this judgment said. So it said that the law is incompatible with the Charter of European Union law for the following three reasons. It shortens the terms of judges over 60 years old in the case of women, 65 years old in the case of men. It allows the Minister of Justice to extend the retirement age of judges on a case-by-case basis, so arbitrarily, and it treats men and women unequally. And then the other part of the survey respondents received this control treatment when we basically just told them a story about the health risks associated with tobacco consumption in the European Union. So it was also a true statement, but it had nothing to do, we didn't expect that it would in any way affect the willingness of citizens to re-elect peace. And this table just shows that there's a covariate balance across the treatment and control groups. So there are no, so once we randomly divided citizens into these two groups, there's virtually no difference between them. And then we conducted a regression where we regressed the probability of peace voting on the treatment, which is our key variable, and also controlling for the age cohorts of that respondents belong in. So we looked at people in their 20s, their 30s, and their 40s, initially just as an intercept control. So the first thing to note here is that the treatment did indeed decrease the probability of peace voting, but we were very interested in what was driving these effects. So here's the last graph and the most important graph of this presentation that I'm going to show you. On the x-axis, it shows the x-axis represents the cohorts of our respondents by year of birth. So people born in the 1930s, 1940s, people born after the 1930s, after the 1940s, after 1950s, and so on. And the vertical axis shows the point estimate of the treatment. So it shows how responsive people from these age cohorts were to that treatment that told them whether the EU Court of Justice made a decision condemning the peace reforms. And what we see here is that for older cohorts of peace voters, their response is not significantly distinct from zero. However, as we move to younger and younger and younger cohorts, and those are the cohorts marked in red, their readiness to stop re-electing the peace incumbent becomes significantly smaller. So, for instance, in the late 1960s, 1970 cohorts, virtually all the age groups are less willing to re-elect peace after updating their beliefs about the plausibility that this is indeed a closet autocrat. So what we take this to mean is a sort of, I guess, mixed results for the future of Polish democracy. So on the one hand, it is true that the history, 4 decades of communism, have definitely desensitized some cohorts to undermining rule of law. But then we see that cohorts who came of age under democracy, so got high school diplomas, college degrees, maybe even started their careers in a new democracy, they are much more sensitive to the revelation of information, and they actually trust these external sources. So there's been a lot of talk in Poland following the controversies that peace has reached with the EU, that the EU is not trusted by peace voters because of partisan effects. Well, this suggests that it actually is still trusted as a source of, as a independent arbiter of compliance with the rule of law. So key conclusions from this talk: authoritarian backsliding can occur even if citizens are fundamentally opposed to authoritarianism. The dynamic nature of backsliding and uncertainty about the ultimate intentions of the incumbent are really key to this. And polarization is critical, although it requires both polarization of elites, so parties and candidates, and citizens. And how much polarization is required depends on citizens' preferences and uncertainty about intentions. This allows the closet autocrat to masquerade as a wolf in sheep's clothing. But unlike in other models of democratic backsliding, in our setting, genuine citizen regret is possible. So citizens, once they learn that they have in fact re-elected a closet autocrat, are willing to sort of update their, once they've updated the beliefs that the person they've re-elected is a closet autocrat, they genuinely regret their decision. And in the experimental evidence that I showed, we seem to be able to confirm that there are cohort effects for these regularities. So I will end there and stop sharing my screen and give Professor Flaherty a chance to talk. Thank you.
Thank you, Professor Nalepa. Thank you for this, helping us understand in such an interesting and scientific manner how the gradual destruction of the rule of law and democracy occurs. I would say it was fun if it wasn't so absolutely terrifying. And perhaps during the question and answer session, you might want to tell us how to reverse this thing. Or maybe we should invite you back again so you can draw another diagram. Now, our next panelist is Professor Martin Flaherty. Let me just introduce Professor Flaherty shortly. Professor Flaherty is a Leitner Family Professor of Law and founding co-director of the Leitner Center for International Law and Justice at Fordham University School of Law. Professor Flaherty is also a longtime visiting professor at the School of Public and International Affairs at Princeton. He is a visiting professor at Columbia Law School, an adjunct lecturer in a human rights program at Barnard College. Professor Flaherty has taught at China University of Political Science and Law and the National Judges College in Beijing and Queen's University of Belfast. Prior to teaching, Professor Flaherty served as law clerk with the US Supreme Court and the Third Circuit. Professor Flaherty also serves as a legal consultant at the 6th Committee of the UN General Assembly and is a live member of the Council on Foreign Relations. Professor Flaherty also has written numerous publications on human rights, constitutional law, international law. We are very happy to have you here, and the floor is yours. Thank you.
Okay, well, thank you very much. Can everyone hear me okay? Good.
Yes.
Good. So let me start sharing my slides and start the show here. And as I do this, first, let me thank the organizers and my former student, Eric Wong, in particular, for putting this marvelous symposium together. I regret that I cannot be there today, but I am actually very thankful that we have the capabilities of Zoom and that the organizers were accommodating in that regard. And the one personal thing I want to say in light of our discussion of Eastern Europe is, notwithstanding my kind of obviously Irish name, my mother was Ukrainian. And my current line about that is my gene pool consists entirely of small, feisty countries next to aggressive imperial neighbors. So I think it was overdetermined that one day or another I would start doing international human rights and international law. Well, I want to talk about some instances in which the rule of law has been challenged and in fact nearly extinguished with regard to things that I have been working on. This slide represents a number of the organizations that I am currently involved with, teaching in, doing work for, running, etc. But out of this kind of hodgepodge has recently come two focuses. One is a longtime focus on the rule of law and fundamental human rights in China. And the other is something where I got my start in human rights, which has all of a sudden and sadly come back on the agenda, which is questions about fundamental human rights and indeed even the rule of law in Northern Ireland. So let me get started. In talking about China, I will first talk about the promotion and the fate of the promotion of the rule of law in China proper, so to speak. But then we'll say something about recent developments in Hong Kong as well as Xinjiang. I then will discuss what has been going on more recently in Northern Ireland within the United Kingdom. And then throughout, not consistently, but throughout, a theme that unites a lot of this work and a lot of these concerns is one thing that backsliding regimes tend to do is to focus on the persecution of lawyers and human rights lawyers in particular, for fairly obvious reason. You persecute a dissident, you persecuted the dissident. You persecute a lawyer, and you persecute all of the dissidents that the lawyer represents. There's a multiplier effect. Authoritarian regimes know that, and more outside governments and NGOs are responding to that fact. So let me get started with China. This isn't China, of course, this is the White House, but this is a seminar, which at Princeton is known as a task force, policy task force that I've been teaching for almost 20 years about promoting the rule of law in China. In fact, Eric is a veteran of this. Another veteran actually is partly directing China policy at the National Security Council. So he is actually in the White House these days. And sadly, over the course of the 20 years, the goals and remit of this task force have changed almost 180 degrees. Back in the day, in the days that China hands call the days of engagement, there really were hopes about sharing best practices with regard to law and legal reform and promoting the rule of law and helping build the rule of law in China. Today, the space for that has closed radically. And indeed, one thing, as I was telling my students this week, one thing that we're going to be concentrating on more and more is defending the rule of law in the United States and elsewhere from assaults by China. In other words, going from offense to defense. So let me start about talking about how that transformation came about. The age of engagement, for those of you who know about China, started with the death of Mao, the end of the Cultural Revolution, and the rise of Deng Xiaoping, who consolidated his power, more or less in 1979, 1980. And China opened up to a lot of things, including legal reform. There was a brief and tragic hiatus because of the Tiananmen Square massacre in 1989, but things resumed in the 90s, and that really became the golden age. Why did Deng Xiaoping open the doors, of China to foreign legal scholars? This is a picture of one of my mentors, the great Jerome Cohen, who is one of the early people coming over to China and teaching commercial law, securities, as well as public international law, etc. And he's still at it. He's 93 going on 30. But this was an age when people like Jerry and others were virtually rock stars. China was soaking up all it could about outside and Western and Japanese legal systems. Why? Well, in retrospect, the why is much more clear, although it was fairly clear at the time, which is that the Chinese Communist Party, coming out of the Cultural Revolution, needed the law for order. The Cultural Revolution was a breakdown in any form of legal order. And secondarily, to build up a more modern and quasi-market economy, you needed some aspect of the rule of law for foreign direct investment. So from 1980 or so, where China has virtually no law schools and virtually no lawyers and virtually no legal system, today in China, this is a success story. There are something like 400 law schools. I think at this point, over 300,000 lawyers. China has built a legal system. But the question is, as we've heard, what is that legal system for? What is it doing? How is it being deployed? Well, the Golden Age continues. In fact, I was a partaker in the Golden Age. I went and taught at China as the 90s ended. But the eagerness on the part of the party and the government for outside legal input started to plateau not long before the Olympics and perceptibly dropped off afterwards. Why? Very complex reasons, but to simplify it, it became clear that it had become clear to the leadership that law had become a double-edged sword, that it could promote order, it could promote foreign direct investment, but it could also be used by those within China who took it seriously as a way to vindicate criminal defense rights, the rights of the disempowered, healthcare rights, etc. And without naming them all, these are some of the leading lawyers and activists, the names are there, Gao Zhisheng, Teng Biao, and Lu Zhan, who were all using the law in creative ways on behalf of disability, individuals with disability, to promote the use of the otherwise non-justiciable Chinese constitution, the Xianfa, as well as most provocatively in Gao Zhisheng's case, and which he paid for dearly, to defend the group Falun Gong. Well, what happens is these people start to become enemies of the party and of the state, and an array of persecution is deployed against them. Teng Biao is arrested twice. In 2008, he's tortured. He has been in the United States ever since. Gao Zhisheng, earlier than that, around 2005, was disbarred, tortured, arrested, and disappeared. And as far as we know, is in a prison in Xinjiang. Happier is the activist Lu Zhan, who is able to escape persecution and is in Queens, New York, the haven for many a refugee. And things get worse. And they get worse for a number of reasons, but one of the main reasons they get worse is the arrival, and it's not as clear in these slides as it should be, the arrival of, I gotta go backwards here, of Xi Jinping. Xi Jinping consolidates power in 2012, 2013. Even before that, there are further crackdowns on lawyers. One in 2011, coincident with the Arab Spring. But it's really not until 2015, after Xi has consolidated power, that you get massive systematic crackdowns on China. The most dramatic is what's known as the 709 crackdown, which stands for July 9th, 2015, where something like 300 lawyers, and one of the leading lawyers in that instance was a women's rights lawyer, Wang Yu, who were disbarred, beaten up, imprisoned, tortured, and otherwise silenced. And in a neo-Maoist turn, Wang Yu had to actually make a public confession on Chinese TV. Around the same time, the blind barefoot lawyer, as Jerry Cohen calls him, Chen Guangsheng, was made a dramatic escape to Beijing, to the US Embassy, and there was a deal cut where he would go to the United States. So basically, the space for any independent lawyering from China is closed, which is symbolic of the state of the rule of law in China more generally. But just to say a quick word about going on defense, How does the use then of the law, and in China scholars often call the rule of law in China not the rule of law that controls the government and party, but rule by law, law used as an instrument by the party and by the government, whereby the party and government float above the law. Well, now in all sorts of ways, they are using the law and foreign policy to present threats to the rule of law in the United States. I'll tell you a quick story at my home institution, which they love me telling. We were going to host that blind activist after he had spent a year at NYU. It was all set to go. And I get a call from the president's office of the university saying they're rescinding the offer. Why? They're rescinding the offer because they're worried about the effect hosting this fellow will have on applications from the business school. I was shocked. Everyone at our Human Rights Center and the law school was shocked. And eventually, and this shows the glories of tenure, the co-director of the Human Rights Center and I wrote a pretty nasty email to the president of the university, which ended with a statement: if you do not rescind the rescission of this fellow's offer, we are going to go to the New York Times and Congress. They rescinded the rescission for other reasons he didn't come to Fordham. But the larger point is the readiness of folks in the United States, in particular, university and college administrators, to cave when it comes to academic freedom and the rule of law, when faced with perceived pressures from China. Now, to very quickly go through two of the other manifestations of the turn to greater authoritarianism under Xi Jinping, if not, as Jerry Cohen himself would say, outright totalitarianism. One is basically the all but strangulation, although some would disagree with me on this, but the evisceration and ongoing evisceration of the rule of law in Hong Kong. As many of you probably know, once Hong Kong was handed back to Chinese sovereignty in 1997 under a treaty with the United Kingdom, Hong Kong was to have guaranteed a high degree of autonomy under the slogan, "One country, two systems." That then was implemented through a national statute of China into something called the Basic Law of Hong Kong, which would serve as a sort of mini state constitution, which established a chief executive, a legislative council, and would most importantly maintain the independent common law courts of Hong Kong, as well as guarantees of rights through the incorporation of the ICCPR. That worked, actually, for a fair amount of time from 1997 to 2014. There were problems and were demonstrations, which I will skip over, but things started to change again not long after the ascension of Deng Xiaoping a few years earlier. First with mass demonstrations in Hong Kong concerning the slow pace, basically, of the democratization that had been promised under the Basic Law. Mass demonstrations occurred again a few years later when the Hong Kong government introduced a proposal for an extradition treaty with China, whereby people in Hong Kong would be able to be tried in the very different Chinese legal system. And this, as you can see, is the response. By the way, this belies the notion of Asian values do not, commit people to democracy or the rule of law. Well, the response to all of this came suddenly and draconianly, if that is an adverb, in 2021, in the beginning of 2021, where the National People's Congress enacted the Hong Kong National Security Law, which all but shut down Hong Kong civil society and represents a dramatic assault on the Hong Kong legal system. It establishes several vague offenses: secession, subversion, ill-defined terrorism, and collusion with foreign entities. It sets up a sort of mini separate judicial system where the only judges in Hong Kong who could hear these cases have to be vetted by the executive. There is the option that the executive has to have trials under the NSL sent over to the mainland. And currently there is a challenge to the use and employment of foreign legal counsel by those who are facing charges in Hong Kong. So one country, two systems to a great extent is has been extinguished, notwithstanding the palpable support for maintaining and extending that system in Hong Kong. If anything, things are even worse in Xinjiang. I won't go through the details in most of these slides, but Xinjiang is that red province there in the map of China. It was brought into imperial China more or less in the 18th century under the Qing Empire, but it is historically different because of ethnicity. It had a majority population of Turkic Uyghurs who are different from Han Chinese and was primarily Muslim. Which is why one of the kind of Uyghur East Turkestan flags looks like the Turkish flag, only in blue. In the 90s, because it had always been seen as a potential area of unrest, the idea was a kind of subtle form of ethnic cleansing, the Hanification or sinification of Xinjiang, the promotion of domestic immigration of Han Chinese into Xinjiang, whereby they got most of the jobs, most of the government positions, most of the privileges. That created, not surprisingly, unrest amongst the Uyghur population. There were riots, to be candid, and there were, at least by the measure of some of the terrorist incidents we have been used to here in the United States, minor but significant terrorist incidents from 2007 to 2014. The combination of that unrest, that provoked unrest, again with the ascension of Xi Jinping, has led to perhaps the worst repression outside of North Korea that is occurring in the world right now. The architects are Xi Jinping and Chen Changguo, who is essentially the governor of Xinjiang. And the victims are the Uyghur people. These are two friends of mine who are Uyghur activists in the United States. I don't really have time to go into their backgrounds, but what I do need to, I think, reiterate is the level of repression, most notably and most famously and most infamously, the incarceration of 1 to 1.5 million, mostly Uyghur men, although women as well, in re-education camps throughout Xinjiang. But even outside of those camps, Xinjiang itself has become something of an Orwellian surveillance state, a state-of-the-art surveillance state, with cameras and facial recognition, biometric data collection, and in a more old-fashioned move, party cadres actually moving in and staying with Uyghur families to make sure that they are not practicing Islam or being otherwise disloyal or potentially disloyal to the party. In terms of international law, what is going on here? Well, clearly, and I won't go into the details, but clearly on the international definition of crimes against humanity, there are crimes against humanity taking place. Genocide, a closer question. I would say yes. There are those who I think could legitimately say no. It turns on whether there is actually an intent to destroy the Uyghur population in whole or in part, and intent is hard to prove. But even if the argument about genocide is colorable, that is indicative of the situation. What have been the responses? The responses have been frustrating in the UN. The Human Rights Council wouldn't even take up last fall the issue of Xinjiang. The US Congress has responded with Magnitsky sanctions and with attempts to regulate the use of forced labor in Xinjiang by trying to monitor goods that are made from forced labor. But let me turn, after all of that, if that isn't depressing enough, what actually is even more depressing to me is developments in the United Kingdom. I first got my start in human rights working on human rights issues during the Troubles in the 1980s in the United Kingdom. And one of the first cases I started to work on was the case of this individual, Pat Finucane. He was a lawyer who was murdered by paramilitaries in front of his family in 1989. And it turned out pretty quickly that there were credible allegations of collusion by the British government in his murder, because he had been a very successful civil rights and, more importantly, very successful international human rights lawyer. He had won some landmark decisions against the UK at Strasbourg, and he was killed. Now, much later on, after much pushing, David Cameron admitted and apologized to the family that there was collusion, but the family has still been trying to get a truly independent investigation into how high up British collusion went with regard to not just the Finucane killing, but a whole system of killings in which there was collusion by state actors of the United Kingdom. Well, it looked like there would be an attempt to deal with such issues, which go under the name in the region legacy issues, because there were 3,000 killings, some by state authorities, many by the IRA, many as well by Protestant paramilitaries. And it looked like the setting to have that issue dealt with would be a byproduct of the peace in Northern Ireland that was concluded 25 years ago, this coming April, in the Belfast Good Friday Agreement. It brought peace to Northern Ireland, it ended the Troubles, and it had some very it initiated some very successful reforms. The police were successfully reformed. It brought about, for the most part, a devolved government that had both people from the nationalist and unionist communities. And both the Irish and UK governments incorporated into domestic law the European Convention on Human Rights. What was deferred, frustratingly, was a Bill of Rights for Northern Ireland. And what was also deferred was this issue of investigations into political killings that occurred during the Troubles that go under the rubric legacy. Now, the Good Friday Agreement did indicate that that should take place, and the incorporation of the European Convention actually mandated that something like that would take place. There was lack of progress for various reasons, but it looked like there was a breakthrough with another agreement between the Irish government and the United Kingdom government in 2014, the Stormont House Agreement, which looked like it had set out the framework for ways to approach legacy killings. Well, what has happened since? What has happened since is what Chris McCrudden at Queen's University Belfast has termed, Britain's turn away from law generally. One manifestation of that arguably is Brexit. Incidentally, a majority of both the nationalist and unionist populations in Northern Ireland rejected it. But there was an economic catch-22. I'm not going to go in much into this, but the third rail of Northern Ireland is you cannot have a hard border reestablished between the Republic of Ireland and Northern Ireland, because that will trigger violence for reasons we could go into. However, how do you have a hard border between the EU and the Republic of Ireland without some form of hard border and hard border checkpoints? That's what the Northern Ireland Protocol has been trying to finesse. But even that agreement is something that the British government have been trying to renege on. But to get back to the legacy issue, what has been really shocking to a lot of people working in Northern Ireland was the introduction last year of the so-called Legacy and Reconciliation Bill, which basically, without going into the details, creates an effective amnesty for all political killings in Northern Ireland during the Troubles, and indeed shuts down virtually any independent mechanism that is already available to try to get to the bottom of who killed who, including civil suits, which in certain instances have been effective, as well as non-criminal inquests, which in certain instances have been effective, and all but eliminates the potential for criminal prosecution. as well as potentially restricting the public disclosure of information on national security grounds. This has elicited a united chorus of opposition, both inside Northern Ireland and outside. In terms of international law, there's a virtual consensus outside the UK government that it is a clear violation of the duty to investigate state killing under the protection of right to life under both the ECHR and the ICCPR. And as such has elicited widespread condemnation from Northern Ireland victims groups, from political parties across the spectrum in Northern Ireland, which is a pretty rare feat to unite Sinn Féin on the nationalist side and the Democratic Unionists on the unionist side, and has also drawn a chorus of condemnation from UN bodies and officials from the High Commissioner on down, as well as, again, another neat trick, bipartisan condemnation from members of the United States Congress and an almost unanimous condemnation from NGOs. So, concluding thoughts. Well, with China, obviously, how do you deal with an authoritarian, totalitarian regime when you lost the opportunity, because it has become powerful, to use the leverage that you could have used 10, 20, and 30 years ago? And there's no easy answer to that. In fact, this would be fodder for a discussion. Right now, it looks like the best we can do is buy time. This is a slogan of Deng Xiaoping. There are a lot of lawyers and activists in China who are laying low. And one hope I have is that by overplaying his hand in things like the COVID lockdown, Xi Jinping might ultimately be marginalized by more moderates in the Politburo, but I think even that is very unlikely. But if there is at least some internal moderation, there is going to be a whole groups who are going to try to re-engage in legal reform. But what outsiders can do is very challenging and problematic, and there are no easy answers. With regard to nations like the United Kingdom, authoritarian trending democracies, one thing that has been really striking is that in talking with high British officials, as I've been doing the last few months, there is really an indifference to the legal arguments being made, even when you point out that they are using legal arguments against China and Russia in international law, but are quite selective in not caring about the legal arguments made with regard to their legacy proposals. And so here, what is really going on and what international human rights advocates are depending on is the Biden administration using the prospect of refusing to negotiate a trade agreement with the United Kingdom, which the United Kingdom sorely needs post-EU, in part on the grounds of its actions undermining the Good Friday Agreement in Northern Ireland. Whether that strategy works, we'll see. But for the moment, the British government is pressing ahead. So hope I didn't go too far over my time, but thank you very much.
Thank you very much. Thank you very much, Professor Flaherty. That was fascinating. So clearly the pen is not working.
Okay, sorry about that.
Now, thinking back, I should have asked for a whistle. But it was so fascinating. I really didn't want to interrupt Professor Flaherty, and it was, thank you so much for your contribution. Now, our last, but certainly not least, panelist for today is David Carroll, who is Director of Democracy Program at the Carter Center. Mr. Carroll leads the Carter Center's initiative on developing standards and best practices in international election observation. He's managed and participated in more than 70 Carter Center projects to strengthen democracy and electoral processes around the globe in Latin America, Africa, Asia, and the Middle East. Now, I understand that as we have now circled the world, we're coming back to Atlanta in our focus. And I think Mr. Carroll will highlight some global trends in authoritarianism and democratic backsliding. So, Mr. Carroll.
So good morning, everyone. It's a great pleasure to be here, and thanks to everybody at Emory Law School and associated with the Thrower Symposium. I'm going to talk about, as Professor Tulibashka mentioned, the bigger picture globally and some broad trends and how the topics of today's seminar and symposium really fits into the broader picture. And the work on democracy that I'm involved with, how the rule of law is so integrally entangled with that. I'm going to speak with a big emphasis on democracy and elections, and also from the perspective of a practitioner who's been working most of my career on these things. So that's the lens that I'm approaching this. I want to start by just pointing out that for a good 35 years or so, we've all been operating in this framework that's based on a large international consensus about the centrality of democracy and human rights to the political legitimacy of governments. What do I mean by that? There is, in international law, international human rights law, a series of what are now recognized as standards for what constitutes a genuine democratic election. And those abiding by those standards, meeting those standards, is what gives nations political legitimacy in theory. Those standards, to oversimplify, they really come down to two core baskets: fundamental freedoms, freedom of expression, association, movement and assembly, and political and civil rights, the right to be involved in politics, to vote, to be elected, a number of ancillary things, but those are at the core. And this is an international norm, widely recognized, and it has dominated a lot of our work and discourse for decades. States want political legitimacy. They want to be perceived as legitimate in their operation. In parallel, and not by accident, over this last 30, 40 years or so, there has been a dramatic expansion of something that existed in history, but not so much really until the late 80s and 90s, and that is what I've been working on, international election observation. It has grown up alongside this kind of broader embrace of democracy and elections. It's part and parcel of the sense that what happens inside countries and their rule of law, their respect for human rights, is a legitimate concern of the broader community. And it makes sense, it's appropriate for there to be observers who come and independently look at an election process and objectively provide some information about that. And a little bit of a side note, in parallel to that work as an election observation, there has been also a development of a community of practice of the groups that do this kind of work. We're interacting more and more, sharing experiences and talking about the challenges we face in trying to provide that informational role that tells the rest of the world and host country audiences what we found when we looked at those processes. And one last side note, we've also become the object of academic study, we've found. There are lots of political scientists looking at us and kind of assessing what we're doing when we're assessing democracy in other countries. So that's been the framework that we've been in. I want to spend the rest of my time really talking about 4 or 5 major trends that I think are shaping everything that we're experiencing. I'll list them first and then go through them in a little more detail. Most importantly, I think we may not see it because it happens gradually, but there has been and there is ongoing important shifts of political power internationally around the world. And that's shaping everything that's happening. A lot of what's been discussed in the past presentations are focusing on the specifics of democratic backsliding, which is the second major trend I want to talk about. Democratic backsliding and the erosion of the quality of democracy. And part and parcel of that, the flip side, a rise in assertiveness of authoritarian states, non-democratic states. We'll see that is a trend line also across the globe. Changes in technology, extremely important. This is really affecting everything that we do, how we operate as societies, how democracies function, how the rule of law functions. And part and parcel of all of that, threats to the stability of norms and institutions of the liberal international order. The rules-based order that has been so stable is now facing more and more threats. Two other big trends I won't mention, but I think we're all familiar with them and they really permeate all of this, is global inequality and unequal levels of development. And I'm glad that Elizabeth Anderson spoke about the ESG as part of the topics that are concerned for rule of law. That's part of that. And then climate change, also part of ESG. This is, a ongoing threat that's going to outlast all of our lives, and the rest of humanity is going to be dealing with this. So on each of these in quick order, try to make sure I don't go too far over time. Shifts in global political power. So since 45, 50 until about 10 years ago, there's been pretty much a stable international order. Bipolar for a long time until the end of the Cold War, and then what people talked about as a unipolar hegemonic period, that the United States was the single dominant power. That has been changing for the last 10, 15 years. Gradually, we're moving into what is going to be a multipolar world. There's not a single dominant power anymore, and this is going to affect everything. This is going to affect everything, and we're just entering into this period of a multipolarity and how that's going to affect the rest of society. It's not just the relative decline of the US and the rise of China. There are also middle powers who are increasingly assertive and staking their interest on the global stage. And that is part and parcel of this threat to the norms and institutions of the liberal international order. Secondly, the democratic backsliding, which is really a lot of what we're talking about today. For a good 15 years or so, what had been the third wave of democracy that was rising since the 70s kind of leveled out in the mid 2000s or so. And now we see there's a decline. There's a whole series of indices that look at this in detail. The World Justice Project's index is a valued edition and really gets down into some of the specifics that are more in the nuts and bolts of rule of law and judiciaries and justice sector. What can we say about these? So it's not every country everywhere. There's some countries going up, but on balance, more are going down. One of the major sources that's been around for a long time, Freedom House does a State of World report. 2021, according to the report, was the 16th consecutive year of a decline in global freedom. They do a kind of a three-part series, free, partly free, not free. But 16 years in a row now, that trend line has been going down. Many more countries have declined than have increased. Elizabeth Anderson showed us the trends from World Justice Project. You see in a shorter window that kind of downward slope. And what I'm going to spend a little bit of time on now, if I can, I'm going to show you that slide, and hopefully I can go back. How do I go back? There we go. Oh, no, that's forward. There, okay. So I'm going to spend a few minutes talking about another set of indices, what's called the Varieties of Democracy Project, or VDEM. It's a global project that political scientists around the world, perhaps my colleagues who have been speaking today may be part of this, that there's people here at Emory who are part of this. They look at a wide series of indicators and measures. I will oversimplify, but they do a lot of different things. So one of the key things is regime types, and I've simplified on this chart here, and I will further simplify. Liberal democracy, electoral democracy, electoral autocracy, and closed autocracy. To make this crude oversimplification, liberal democracy, you have genuine elections, free and fair, and you also have these kind of diverse centers of power, and you have decent respect for rule of law and rights throughout society in general. We're simplifying. The distinction to move to electoral autocracy, electoral democracy, is they have that same strong element around elections and some of the core institutions connected to that. But between elections and some of the institutions in society are not necessarily doing as well. They don't rate quite as highly. And you move to the other side of the ledger, we have electoral autocracy. What's distinguishing things here is it's not just about those other institutions and protections that are weak, but even elections themselves become less really genuine. If there's de jure elections, you know, they have all the things that look like elections on the outside, but they're not really genuine, and they have those weaknesses throughout institutions. And then closed autocracy, I think you'll recognize what that's supposed to be. So here's a graph from 1989 or so to 2021. And this shows you pretty vividly, the blue line, that's good, right? That's liberal democracy. There's that kind of trend of the third wave kind of leveling off in the mid 2000s. And there's that 15, 16, whatever number of years of decline. These are on the left axis is the number of countries, and time on the x-axis, the horizontal axis. Green are those electoral democracies. So you'll see, you know, there was that steep increase in the early 90s, not so much improvement there. Now it's going up, but what that probably is reflecting is that countries that were in blue are regressing. So they're losing some of that institutional strength. So they're moving to that green line. And that kind of is part of this negative downturn. Red is those electoral autocracies. They don't really have, they have elections, but they're actually not really good. And they have very few of those other broader societal protections. And that was increasing while, you know, up until the mid 2000s, while also liberal democracy and electoral democracies were increasing. It's on a slight downturn now, but this is probably also the flip side of that increase in the black line, the number of closed autocracies that are increasing. So it's probably stealing from some of those red line countries that were electoral autocracies. Wrong way. Actually, I'm going to go back to this for a second. I do want to say a couple of things here. What am I doing? What can I point out? A couple of specifics. So since 2012, liberal democracies have declined every year from 42 to 34. We're back to almost where we were in the kind of 1989, 1990 level, roughly, in liberal democracies. Dictatorships and autocracies are increasing. They're up from 25 to 30 in just the last couple of years. 70% of the global population now lives in countries that are under an autocratic system. A record 35 countries have suffered significant deterioration in freedoms of expression. It was only 5-10 years ago. Another kind of odd point, but electoral autocracy still remains the most common. You see in the red line, 60 countries, 44% of the global population. So together with electoral autocracies and closed autocracies, there's 90 states, and you know, a clear overwhelming majority of the world's population is living in those kind of societies. It's important to note the United States has not been outside of this decline. In the last several years, since the mid 2015, 2016, most of the indices for the United States have shown a decline. We are also part of this global decline in the quality of democracy and weakens institutions here. And in particular, some of the norms about peaceful transfer of power, the acceptance of results, the recognition of the legitimacy of courts and elections and processes connected to that. And those things don't always show up well in indices. It's, you know, normative things are kind of less easy to show up in some of these indices, but they can become especially toxic. The third thing that I want to, address, just briefly, the rise and increase assertiveness of authoritarians. And I think the presentations we've seen by Professors Nalepa and Flaherty kind of bring out some of these aspects. There are authoritarian states that are trying to provide an alternative political model and also to become a center of gravity that is part of this threat to the global international order. They are increasingly working in coalitions with one another. They are attempting to insulate countries from external pressure as every way that they can and to blunt international criticism. And that's part of that threat to the rules-based international order. They really want to protect their national sovereignty and under the guise of national sovereignty, push back against this notion that what happens in their countries is a legitimate concern of outsiders. You can see on this chart here's, you know, on the top countries that have been regressing. First column, liberal democracy to electoral. Second one, electoral democracy to electoral autocracy. And then lastly, those countries that have moved to closed autocracy, and then some of the ones that have been moving in the opposite direction on the bottom. Yeah, and just so you can see, it's not all one thing. There's ups and downs, but the global trends are certainly moving in that direction. I'll just say a couple of things, and I know you want to save some time for lunch. I mean, for questions before lunch. See where my mind's going? I'll skip over all the examples of the kinds of things that autocracies do. You've seen a lot of the examples in the last presentations. I just do want to mention the other major trend that I want to focus on or talk about a bit is the rapid change in technology and the central aspect that is going to be in all of our lives. What information do people consume? What information do they have access to? How do they get that information? That's going to shape everything that's happening about the status of democracy in a country, the rule of law, people's attitudes about closet authoritarians. Where is that information? How do you get it? And what are the rules and the legal frameworks around those are really important. We all know about social media disinformation, the business model, content moderation, clicks, and the financial incentives behind all of that. But this is the challenge of the future is the integrity of information and the information ecosystem and information environment that all of this is happening in. And I'll just briefly mention the last two things. External cyber security threats are growing importance. It's going to be there for the future as we look ahead. Technology keeps creating new problems for us, like ChatGPT, which I hadn't heard of until like my Christmas break and start reading about it. And for the people like me who work in elections, technology is presenting a whole nother host of problems. So much about the threat of elections is bringing transparency so people understand what's happened in an election. And the more it gets embedded in technology, the harder it is to provide those windows of transparency where people can see and understand and then believe and have confidence. I will stop there because I know we want to have some time for questions.
Thank you, Mr. Carroll. So I will forego the prerogative of a chair and will not ask the first question, but instead I will open the floor to questions. There are, I believe, 2 mics which people can use to ask questions to our panelists.
Hi, thank you all so much for talking today. Each of your discussions was so interesting. I was so glad to hear Dr. Carroll mention there at the end about the rise of misinformation and the way that we rely on information, even in understanding or addressing some of these authoritarian regimes. And I was just hoping to hear the other speakers' thoughts on the rise of emerging technologies, the spread of misinformation and distrust of information, and how that affects our responses to regimes and democratic backsliding in general.
Professor Flaherty, Professor Nalepa, who would like to?
Sure, I'll start. Well, as probably will come as no surprise, China went from control of information to near total control of information. One aspect of the advent of Xi Jinping, although I should be clear, many of these trends were evident even before he came to power, as early as the aftermath of the 2008 Olympics. But the internet used to provide some degree of discussion in China. It has been sealed off even more. There was always what was known as the Great Firewall, which keeps outside information in. But things like Weibo and WeChat would allow citizens to have some discussions. But that space has been greatly constricted as well. And my colleague at Princeton, Rory Truex, is working on a project about the extent to which there is genuine support for the regime or not. And according to him, there is, and that's true of, I understand, many other political scientists. But the caveat is always, this is support based on very tight control and tighter control of information. The same process is happening dramatically in Hong Kong, There is still something, vestiges of a free press in Hong Kong, but to give you one very dramatic example, the most critical newspaper, the newspaper most critical of Beijing in Chinese was a newspaper called Apple Daily. Its publisher is a guy named Jimmy Lai. Jimmy Lai right now is on trial, facing various, both under the national security law and under older colonial laws, for all sorts of offenses. Apple Daily has been shut down. And in fact, it's Jimmy Lai's case that has triggered this issue about whether someone like him can retain outside counsel, in this instance from the United Kingdom, to argue in front of, these courts that still use British style law. So control of the press is growing exponentially, even as we speak in Hong Kong. In the United Kingdom, I'll just be blunt, it's kind of official lying, and the two examples of that are famously Brexit sort of misinformation put forward, so on Boris Johnson's bus. But what's also striking to me is, British officials just sort of misstating what people, want in Northern Ireland, as well as they misstate the law. Every victims group on record and in private opposes this legislation, yet we meet with high British officials and they assure us that no, behind the scenes, there is support, and, it's just not credible.
Yeah, can I speak too?
Of course, please,
Yes.
please go ahead.
So I wanted to sort of like make a different observation, that there's the relationship between censorship, surveillance, and misinformation is such that the three can't go together consistently, right? So authoritarian regimes, as we know, are closed regimes. And to the extent that they want to know what the societal attitudes are, they cannot have full censorship and propaganda, right? Because whatever the regime, whatever information from society does not float to the surface is not visible to the autocrat. So there's a limit to how much censorship and how much propaganda authoritarian executives want to put in place. On the other hand, technological advances, and keeping that in mind, technological advances serve both the autocrats and society. I mean, if you think about how difficult it was to coordinate protests or coordinate collective action before the rise of social media or before email. I mean, it was all done through telephones, word of mouth. It took much more than organization through social media. So technological advances sort of like serve both sides. And because it's against the interests of the autocrat to impose full censorship, those three phenomena will not be moving together. So this is just like I guess, a tone of less gloom and doom on like how bad things are getting. And also, I wanted to say that I regret that I wasn't able to see Professor Carroll's slides, because there are some very recent advances in political science on the VDEM data and on the global phenomenon of democratic backsliding. And this is a working paper by Professor Annie Meng from University of Virginia and Professor Andrew Little from the University of Berkeley, who note that actually, as a general phenomenon, globally, there is not more democratic backsliding happening. It just so happens that the countries that have been backsliding are the ones that are sort of like on everybody's mind, and because they're important empires and so on. But in general, as a phenomenon, it's not getting worse and worse. So I just wanted to put that article out there. And again, I regret I was not able to see the slides of Professor Carroll, because I'm not sure that this is a criticism of his presentation and his points made, but it's just, I wanted to highlight that there is a paper out there that sort of casts some doubt about this sort of like doom and gloom approach to where we're heading. Thank you.
Thank you. That was a nice positive remark. I think we have two more people who would like to ask questions. I would say let's just have one more question. And then I suggest perhaps the second question could go to the panelists through an email, or just an informal exchange during lunch. So one more question, please.
So thank you so much for this really outstanding panel. And this is Mary Dujek. I'm on the faculty. Special hello to Martin Flaherty, who I wanted to see here today. And I have a question really for anyone on the panel, everyone on the panel, but really inspired by David Carroll's slide, in light of Kim Shepley's work on the rise of authoritarianism and the threat to the rule of law, specifically within the United States. And really out of a special concern right now, I'll talk about some of those issues later, but right now thinking about voting rights and support for authoritarian forms of governance and right-wing groups within the United States. So I looked hard to find that, maybe I missed it, the United States on your slide. But I don't think it was there. And so I wonder, where would you put the United States on your slide, comparing different kinds of regimes and the rise of or decline of authoritarianism and protection of the rule of law? And do others on the panel have reflections on how we think about threats to the rule of law in the United States in light of your remarks? Thank you.
Sure. Is that on? Y'all hear me? Yeah. So on the question of where the U.S. is, it's still squarely in the liberal democracy category. So it would have been on that blue line. It wasn't in that table because it hasn't really moved from one category to the other. It's trending down on the indices though, and it's really been, mostly in the last 4 or 5 years that's the case. And I neglected to mention that because of our own concern at the Carter Center of what we've seen happening in the United States, we're actually for the first time in the Carter Center's history working on elections in the United States. And this is a dramatic departure. We never would have done that before. And all of our programs are expanding our focus on that. I would like to just say a quick comment in response back to Professor Nalep. I'm aware of the working paper that she's referenced, and its core criticism is that a lot of these indexes rely a lot on expert surveys, and a sense that maybe the expert surveys are then getting kind of amplified in the media, and that's leading to maybe a mirage of downturn. I think there's some good arguments made there, but I also think that the data that they use to show different trends misses a lot of things that don't really show up, like harassment and threats and toxic information and breakdowns of norms. The data that this other working paper that she's referencing uses, it might not even tell you that, the craziness that's gone on in Brazil and the legislature there. If you use the numbers that methodology says, Brazil still looks fine, but Brazil is facing serious threats. So I don't mean to be all doom and gloom, and I hope it didn't sound too doom and gloomy, but I am worried about the future where I sit right now.
Thank you. Would any of the other panelists like to address the question?
Yeah, I mean, I could just speak about the implications of our work, which are, the one of the key implications is that democratic backsliding is actually more possible where the general belief that any given incumbent is a closet autocrat is low. So again, this means that the countries that are most in danger are actually the established democracies. So if we think about the United States, if we think about Western Europe, or even countries in the global South that have been actually successful in maintaining democracies, that's actually where the danger lies. So, I mean, again, just to take a sort of scientific perspective here, there are global trends. And I think that when it comes to global trends, I think the Meng little paper is very convincing because using institutional variables, so basically using procedural changes, actual turnover in power, on average, that doesn't seem to be a whole lot of downturn. But I think it's a very valid argument to make is that the progress of democracy or authoritarianism around the world is not sort of are not changes in the global average, but rather there are some leaders or trailblazers, and then there are followers. And if we see that it's among the followers or the established democracies where this backsliding is happening, that definitely does not bode well for the rest of the world. So in that sense, I think that's a way to sort of reconcile the VDEM observations on the one hand that have been reiterated by Professor Carroll, and then the sort of like political scientists institutional analysis on the other hand. Thank you.
Thank you. Professor Flaherty, would you like to add anything?
Yeah, just super quick. One is to say hi to Mary and thank her for the question. I mean, for me, from my perspective, there's all sorts of comparisons to explore between the United Kingdom and the United States, especially from a comparative constitutional point of view, and not to mention political science. There are things that conventionally seem to make things worse in the United States than the UK, gerrymandering, the Senate, voter suppression, etc. Conversely, although it's out of fashion, are there things in the United States that cut the other way, like separation of powers and more robust judiciary, although the UK judiciary is becoming more robust. So I think both on a political science basis and a comparative constitutional basis, there are interesting comparisons between the UK and the US, and which one has the brighter or gloomier, path before it is not clear to me.
Thank you. Okay. This concludes the first panel. And I think the other two panels that are coming after lunch have their work cut out for them. This panel has, in a very interesting manner, identified the threats to the rule of law, both on the systemic level and also identifying a number of different places around the world where these risks have transpired. But now let's have some lunch.
All right, well, welcome back. We're going to get restarted. If everyone could take their seats, bring the wonderful conversations to a close, and we will get started. All right. Well, thanks again for everyone's patience with lunch earlier. We hope you had a great meal with different people. A quick reminder, if you haven't picked up a parking voucher yet and you parked at the lower gate east parking deck, please do so. That'll allow you to get out of the parking deck for free. So without further ado, we're going to start panel 2, defining the rule of law. And moderating this panel will be Professor Hadley Ludson, an adjunct professor here at Emory, a senior faculty lecturer here at Emory, a senior fellow at the Center for the Study of Law and Religion, and an expert human rights lawyer. Please join me in welcoming Professor Ludson.
So first, I want to thank the Emory Law Journal students and the Thrower family who put together this wonderful and important symposium for us. And thank you to Eric for roping me into moderating this panel. So I have the pleasure of moderating our panel titled Defining the Rule of Law, which will explore the different understandings of rule of laws and the different ways of measuring it. I've used the term rule of law liberally over 20 years of human rights practice and an almost additional decade of teaching human rights. And of course, I thought I thoroughly understood it. And just for the record, I now know thick definition of rule of law is my understanding, but I have these lovely panelists who made sure to disabuse me of any of my assumption that I had any sense of what rule of law was. And they have taught me both how rich and actually poor rule of law can be as a concept. So I will thank them for that. Housekeeping note, I will try to keep the talks to between 15 and 18 minutes. One of our panelists, Paul over here, authorized me to get a squirt gun or possibly just use my water bottle to, make sure they wrap things up. All right, so now let me introduce you to the first of our panelists, first of our distinguished scholars. We have Professor Mila Verstich. Hopefully I got that close to correct. What was it?
Pretty good.
Okay, excellent. So Professor Verstich is the Henry L. and Grace Doherty Charitable Foundation Professor of Law and the Director of the Human Rights Program at the University of Virginia School of Law, where she has taught since 2011. She is a brilliant and interdisciplinary scholar, having published over 60 articles and books in book chapters in legal and social science journals, including law reviews at Harvard, Chicago, Columbia, and in political science journals like the American Political Science Review and American Journal of Political Science. Some of our most cited articles include Sham Constitutions, The Evolution and Ideology of Global Constitutionalism, and the Declining Influence of the United States Constitution. Each of these articles, which masterfully blend theory and empirics, have been cited several hundred times. Her recent co-author book, How Constitutional Rights Matter, won the International Society of Public Law's Best Book Prize and the Best Book Award from the Human Rights section of the American Political Science Association. On the rule of law, Versteeg has published important data-driven insights, including in-depth analyses of the concepts, groundings, and correlations between qualitative rule of law indices and indicators published by the World Bank, Heritage Foundation, Freedom House, and there's one more, World Justice Project. Versteeg obtained her DPhil in socio-legal studies from Oxford, her LLM from Harvard, and all of that was after completing law school at Tilburg University in the Netherlands. Today, Prof. Versteeg will talk to us about our planned research surveying what ordinary citizens consider to be rule of law and whether those views match what experts tell us rule of law is. And in the Q&A session, because unfortunately we're going to lose Professor Versteeg, we will meet her co-author who I'll introduce at that time.
Oh, thank you so much for having me here. It's really great to be here. I usually talk about constitutions and constitutional law, but I took this invitation seriously and I thought I'm going to think about the rule of law and measuring the rule of law. I'm not going to be defining the rule of law, so maybe I should have come later in the panel, but unfortunately, as was just said, I'm going to have to leave a little bit earlier, but my co-author will jump in to answer questions. So I personally think thinking about rule of law in the abstract at this point in time, it's going to be hard to move the ball, in my view, because so much has been said. There's so many definitions on the rule of law. I was reading up on rule of law literature, and somebody said the rule of law is whatever your heart desires, and that seems. Sometimes, I mean, if you get a bunch of philosophers in the room, that may be your takeaway from what the rule of law is. We'll see about that. We'll see about that. Okay, this is the empiricist speaking. Sorry. In any case, so you're going to prove me wrong, Paul. That is for sure true.
We're going to get our conflict after all.
Yep. In any case, and I also strongly believe that we cannot assume that a rule of law is universal, right? It likely depends on time and place and may look different in one context from another. So what I thought I was going to do in preparation for this is think about, you know, what is the most progress we can make thinking about understanding rule of law empirically, right? How can we, like, understanding how do we actually create rule of law and how can we measure rule of law? Or I'm mostly interested in measurement. And I've done a lot of work with cross-national data, and I think that's obviously very important, but I'm proposing in the sort of paper that I wrote for here together with my co-author, that it may be very useful to look at do surveys and especially survey experiments to get at ordinary people's understanding of rule of law. So let me elaborate on that more. And first of all, let me say I haven't conducted these surveys. At this point, it's more like a research design, but I'd love to get people's thoughts on it. And the experiments that we're thinking about doing sort of says two things. It does take the thin definitions of the rule of law or the procedural requirements of what rule of law requires pretty seriously. But then second, makes this move that's increasingly common, and what we heard this morning, it's sort of a paradigm shift in thinking about a rule of law, is that ordinary people are very important to understanding rule of law. So, so let me elaborate on each of those in turn. So first, I think on the one hand, I just said there is a lot of disagreement over the content of the rule of law, and I think that's true. But if you limit yourself to thinner or more procedural account, like Lon Fuller's account, there's actually a substantial amount of this agreement as well. Joseph Raz, Lon Fuller, they all have a similar list. Law rules must be general, they must be public, prospective, clear, consistent. You must be able to follow them. They must be stable. There must be congruence, right? This list is pretty
canonical. In fact, I think the day started with this sort of classical list. Although for an empiricist, they are kind of conjectures of things that may or may not be true, right? These are important ingredients, but they're also hypotheses, right? You can think of them as a sort of, are they all equally important? What if they conflict? Do people value them to the same extent? So those are some of the questions we're interested in. The second, as I said, I'm repeating myself, but elaborating. I think that if you wanted to explore those further, looking at the perceptions of ordinary citizens is quite important. I think Lon Fuller wasn't first and foremost interested in ordinary citizen, though he had some reflections along the lines that citizens would not have a moral duty to follow the law if it didn't comport with those criteria. But in thinking about why ordinary people matter, I've been particularly inspired by a body of research, which is what some people describe as positive political theory, or some just political theory, but work by Barry Weingast, Gillian Hatfield, more recently Jens Meirenrich, that have sort of, well, let me explain the literature a little bit. I think it makes three core moves. So first, it starts with ordinary people. So the idea, and this is, as we heard, increasingly common, maybe when we're thinking about rule of law, we shouldn't start at the top with state and state institutions, but rather with ordinary people. And this literature observes, and there's a lot of interesting law and society literature along the same lines, rule of law can be found in places that do not have a coercive state apparatus, right? So there's ample examples, ancient Athens, medieval Iceland, merchant guilds in medieval Europe, but also informal legal systems that operate in the realm of customary law and not within the state, right? There can be rule of law without the state. Then second, it's important, some areas of law, there is no true coercive state power. And this is most notably true for constitutional law and international law and some other forms of public law. This may or may not be intuitive to you. I think it, but if you think about constitutional law, what it is in its essence is a series of requirements of what the state should do. Right, the state, or not do, should do and not do. But who is ultimately enforcing the Constitution? I mean, you can say, you're in law school, you say, it's the court. But really, like, what ultimately enforces a court decision, right? So can we ensure that a president follows a court ruling or follows the Constitution? There's no UN superpowers that will come in and say, oh, you violated the Constitution, I will take you out of office. For violating the Constitution, which in turn means, like, if President Trump enacts a travel ban, for example, and people get to the airport and get really angry, and there's like, then there's political consequences. And next time around, he'll be a little bit more careful because he sees, so. But the key insight here is in this line of research, and this is also a core insight from my recently published book, is that ordinary citizens are really important to enforcing constitutional law as well, because they can make it politically costly. It gets more complicated than that, but that's a basic insight. So that's the first move, right? We have to move away from just the state. Ordinary people are very important to creating rule of law. Second move in that literature, as I read it, is to think about, to use game theory to theorize this insight, and specifically to think of rule of law as something like an equilibrium of shared patterns and behavior based on law, right? The idea is we have to have shared understanding when something is legal or illegal, and shared expectations, what others will do if some actions, whether they're government actions or private actions, are legal or illegal. And if that's the case, we're in a sort of good look, then we have an equilibrium of governing ourselves, of coordinating ourselves under the law, right? The law helps us reach an equilibrium where we have shared understanding. So you can't do this. If you do that, we're all gonna get really angry, right? If there's no such shared understandings or shared expectations, what will happen to lawbreakers? It will be harder to have rule of law. Or there may not be a rule of law. So then the third move that this literature makes is that, but for law to coordinate and to create such an equilibrium, you actually need to have some of these procedural requirements, see Lon Fuller. I mean, the list, like the exact list differs a little bit depending on who you ask, but there is the sense that for people to coordinate on whether like certain behavior is illegal or legal, the rules need to be clear. They need to be published. They need to be announced, right? And if that's not true, then it may not be able to create, to get shared understandings and expectations of what the law requires. So you may not be able to get to this equilibrium. So the research design that we propose is to do something like a conjoint experiment where we give people scenarios, legal scenarios in the realm of constitutional law, torts, contracts, and others, without a state, and see if, like, depending on how you present the various characteristics of legal rules, if that changes people's understandings of what is permissible or not, or how they evaluate the law. I mean, conjoint experiments, like marketing researchers use those for washing machine. They have like 17 or 18, well, many different configurations of the same washing machines, and then they send them to the general public and ask them which one they like most. And it's like, turns out that if they open to the left and not in the right, people like it better, right? So you can do something similar with like presenting people with different sets of configurations of legal rules or characteristics of legal rules, and see whether they like one better than the other, or maybe whether they will agree more with one another, whether the rule is violated, and whether they have more shared understandings of what others will do in response. So I'm just going to give you one example where, again, this is very much the beginning of a research idea. But so this would be a scenario. It's on the slide, but where introduce something like you live in a cold weather part of the United States, not Atlanta, where it often snows throughout the winter. When it snows, the sidewalks are often blocked with snow. When and then it turns to ice. The government plows and salts the streets, but not the sidewalks. So hold on, I have a problem here. So the town plows and salts the street, but not the sidewalk. Your neighbors need to walk to get to the local grocery store, et cetera, and it is impossible to walk there. And then somebody got injured. You're part of a neighborhood group that formed to find a solution to the problem. I'm going to skip this one first. So, and actually we add, and then we're going to give them all these different criteria of what the rule is that was formed as a solution to the problem. We start with one that's not actually in Lon Fuller's list, but in other people's list, because we're not particularly attached to Lon Fuller. We're attached to procedural requirements of law that may or may not matter. So one is like, was the process open or not, right? So the open process was last winter, a group of residents gathered input from the residents over a 4-week period. They had several meetings, et cetera, et cetera. Contrast with not an open process. So what happens in a conjoint experiment, some people are randomly told one thing and other people are randomly told another. But at the end, they're all asked the same question, right? So do they give different answer depending on what they're told about the nature of the rule? Then was the rule public or not? So after the rule was enacted, the rule was announced on this group's Facebook page. It was versus after the rule was enacted, the president of the group forgot to notify anyone. Clarity. So then there's one rule that is very clear, and then it's not clear, although clarity is tricky because it often becomes specificity. So we're still wrestling with that a little bit, but within 4 hours, you have to clear the sidewalk. This may include shoveling, salting, hiring somebody. Failure to comply with this rule will result in a fine. And if you're not home at the time of the snowfall, that's not an excuse. You have to make arrangement. Versus you should all take all possible and reasonable steps, right? So that's less clear. Generality, the rule applies to everybody in the neighborhood, or some neighbors argue that the rule shouldn't be applied to them because they're not home much in the winter. Perspective, so the rule was could apply retroactively versus not. Stable, the rule has not changed since it was passed last year, or it's after the rule was passed last year, the neighborhood changed its group changed it several times, etc. The rule became less clear. Is congruence? Is there a congruence between how the rule is drafted and how it's been applied? So say last year when there was little snowfall, there was a little snowfall, but no fines were handed out, versus fines were handed out in the past. So something along those lines. And then contradictory, after the rule was adopted, some residents learned that this rule contradicts a prior rule by the neighborhood group some years ago versus they were not told that. The whole point is that different people get all sorts of different combinations of this. And then we can see statistically whether that changes their views. So then after they're giving some random combination of these, we'll tell them about a blizzard and somebody got injured, and then the neighbors have called a meeting to decide how to react to the incidents. And then it has been suggested that this person who didn't shovel their sidewalk should be penalized to prevent this from happening again. This requires a vote from the neighbors. And well, then the questions would be, first, what do you think of the rule? Is it a good rule or a bad rule? Right, depending, and then presumably you get different answers depending on these different requirements. Regardless of whether this person should be fined, do you think this person broke the rule? Right, and depending on whether, so the idea is to get at, do people have the same understanding of what rule of law requires? And how would you vote? And how do you think that others would vote? Okay, so that's the crux of what we're interested in doing. I don't know how I'm doing for time. I have like I have a half minute left. So we're not attached to this particular experiment. We haven't run it yet, but this would be the basic idea. So we're working on one that's a charter of a high school, which is kind of like a constitution without a state, right? So because we want to work in scenarios that are not state related, and then again see if this if it helps to get shared understanding. But the basic premise here is that, I mean, if we come back to defining rule of law, I guess the implicit definition here is that the rule of law is a pattern of behaviors, pattern of expectations of how other people will behave. And these expectations are not based on some other social mechanism, they're based on law, right? It's because of legal rules that we have certain expectations of what behavior is legal and illegal. And because of that, we will punish government officials who violate the Constitution, or maybe private actors in sort of other settings. But the idea would be to go understand how people react to or how people understand rule of law. We may have to take the state out of the equation to understand this mechanism. So to my knowledge, this hasn't been tested empirically, although reading the rule of law literature can be very overwhelming. But the people who've done the theoretical work here, they think of this as the micro foundations of the rule of law, not the foundations, but micro foundations, understanding ordinary people and whether or how they are able to create shared understandings of what legal rules require, something like that. Okay, I'll leave it at that. Sorry for my philosopher friends will now tell me you can now have a chance to strike back against the senseless empiricism. Thank you so much, Professor Versti. And I think that was a really important reminder to us that we feel rule of law every day and we really don't think about it. I think that was probably actually the biggest message I took from, I also had the benefit of reading her paper in advance, so that was what really stuck in my head. Our second panelist today is Professor Paul Gowder, and I realized I did not check pronunciation, so this is excellent. So Professor Gowder is the Professor of Law and Associate Dean of Research and Intellectual Life at Northwestern Pritzker School of Law. He has taught on constitutional law, critical race theory, legal ethics, and on statistics and programming for lawyers. I think he didn't get the message. Most of us come to law school to avoid math and statistics. In addition to his numerous law review articles, Prof. Gowder has authored 2 powerful books on the rule of law. His first book, The Rule of Law in the Real World, was published by Cambridge University Press in 2016, and it develops a conception of rule of law as coordinated state control of power that creates and preserves social equality in a state. His second book, The Rule of Law in the United States, an unfinished project of Black liberation, examines the history, ambitions, and tensions of American rule of law, investigating its intersections with race, Black liberation movements, capitalism, and empire. Note this book is free online at rulelaw.us, and the Emory paper copy is in my hands at the moment for anybody who wants that. Before becoming a law professor, Prof. Gowder was a legal aid and civil rights lawyer representing victims of police misconduct, predatory lending, employment discrimination, unlawful eviction, and domestic violence. He obtained his PhD from Stanford in political science and a JD from Harvard. Today, Prof. Gowder will provide us with his early thoughts on whether populist governments, which he defines as a type of illiberal government, can fulfill the requirements of rule of law. So please welcome Prof. Gowder.
Thank you so much. So this is very early stage because for the last few years, I've been working on an extended project that really begins with the premise that the ideas advanced by and associated with the interests of subordinated groups, especially those who've lacked access to the benefits of institutions like the rule of law and like democracy and have demanded inclusion in those institutions, have really substantial value in terms of sorting out how those valuable institutions and the underlying ideals that they instantiate ought to be understood. And so for today, I'd like to try out, and this is really tentative, I reserve the right, sorry, Eric, to throw the entire thing out and go a completely different direction for the print version of this symposium. But I'd like to try out an application of this approach, thinking about what we can learn from reflecting on Black-centered scholarship and activism in the United States for at least one question that has been particularly important in recent years, namely the possibility of what we could call illiberal legalism. So in the US Academy, for the professors in the room, this notion of illiberal legalism, that was a Freudian slip, is perhaps best captured in some of the stuff coming out of the, Adrian Vermeule's of the world and the entire Notre Dame law faculty, the sort of hard right, quote unquote, common good constitutionalism. But it's also, of course, associated with or perhaps implicated in, many of the far right movements in other countries, which although associated with legal backsliding, often claim, and I think this is a claim that we're obliged to answer, that some of their efforts are in defense of ideals like the rule of law. And so if we think about that backsliding context, whether in the form of Trump and Vermeule or in the form of far-right parties in Europe and South America and India and wherever else, I think that, particularly focusing on existing societies that have a significant amount of internal diversity, one of the things that the far-right illiberal movements in those societies actually suggest is, as I just noted, that actually it's the left, and in the US particularly, racial justice movements in the left that are supposedly the threats to the rule of law. So, classic American example from recent years, in a 2019 speech at the Federalist Society, then Attorney General Bill Barr claimed that the left sees, quote, politics as their religion and follows an end justifies the means strategy, which leads to, quote, the systematic shredding of norms and the undermining of the rule of law. And while this claim seems like hyperbole, it's consistent with the claims of far-right elements and that, we call them patsies, particularly criticizing Black liberation movements. Who can forget the Supreme Court's infamous scolding of civil rights activists in Walker versus City of Birmingham? Or who can forget the contemporary characterization of Black Lives Matter activists demanding protection against lawless police violence as rioters? It's particularly telling and troubling to me, admittedly I'm self-interested here, that among the specific ideas that Tennessee teachers at least are forbidden from teaching K through 12 students under the state's anti-critical race theory statute is the proposition that, and again I quote, "The rule of law does not exist, but instead is a series of power relationships and struggles among racial or other groups." Arguably, the unfinished part of the title of my last book entails that my own last book is in fact prohibited by that statute. And you know that I thought about suing until a kindly civil rights lawyer mentor of mine explained to me how unsympathetic a plaintiff I would be. But I think we can actually go the other direction. In other words, I think that in response partly to these challenges and to the broader challenge of illiberal backsliding, we can go the other direction and leverage insights associated with, among other things, critical race scholars and the activist movements whose ideals those scholars have partially expressed, to suggest some conditions for the satisfaction of the rule of law that illustrate the tensions, perhaps even contradictions, within the project of illiberal legalism. So for today, I'd like to start us with one of my favorite articles by one of the founders of critical race theory, an article of Patricia Williams's that was part of what fed into the Alchemy of Race and Rights book. But the article is called Alchemical Notes. Actually has a much longer title. And what Williams does there is Williams gives what I read a little bit aggressively as a racial justice account of the value of the rule of law, and particularly the value of the rule of law, which she expresses in terms of the existence of individually enforceable rights and a focus on those rights. You know, Williams says that the rule of law in this interpretation provides particularly subordinated peoples, particularly Black Americans, with a relatively robust social identity, what she calls an autonomous social self. And this is a contrast to a social self that's not autonomous, that's dependent or subordinate to others. And for Williams in this article, that social self is constituted from formality, which should immediately trigger in the rule of law people some thoughts, right? Of this idea of arm's length relationships in the political context, even in the market context. And it's that feature of formality and abstraction that I want to start with first. You know, for Williams, the core idea seems to be that even a person who had experienced a legacy of unjustly denigrated social status could, in a legally organized society, interact on terms of trust and at least local equal standing with other members of society. And so this flavor of social identity, with its strong formalist, generalist, and abstract character, already seems to hint at a tension with both one popular, you know, sort of call us the like Joseph Raz version of the rule of law idea of general law, which purports that you could actually write ascriptive groups into general law categories so long as they were sort of expressed in like vague terms. But also, more importantly, with one common currently popular category of illiberalism, namely the illiberalism of the nationalist, who understands the state to be a project of and for a nation defined by ascriptive identities such as ethnicity, rather than by more abstract legal statuses, right? So I take Williams to be suggesting an objection to the illiberal nationalists, to be saying, well, actually, if membership in a political and social community is in part constituted by these ethno-national kinds of identification, then it can't have the kind of generality and abstraction that provides these goods to socially subordinated groups. Of course, you might have two worries here. One worry you might have is, oh wait, Gowda just suggested that nationalism is in tension with equality. No shit. Right. The second objection that you might have is, well, wait a minute, haven't you just radically undermined a lot of other pieces of sort of contemporary political life? Does this push you toward questioning citizenship itself? Does it push you toward, for example, human rights cosmopolitanism? To which the answer that I'm inclined to say is, yeah, sure, wait for the next bit. It's no coincidence that many Black liberation activists through history have also tended toward internationalism and cosmopolitanism. But, the point being that I think we can start with having a pretty serious objection to the nationalist. What about the other kind of illiberal legality that we see right now, right? The other one is what we might call, borrowing a turn of phrase from Rawls, comprehensive doctrine illiberalism, such as, for example, the resurgence of Catholic integralism, see Vermeule again. And so, in response to the comprehensive doctrine illiberal, who claims that their version of illiberalism could be conducted consistent with ideas like the rule of law, I'd like to start again by focusing on Williams and on Williams's suggestion that part of the autonomous social self is this capacity to engage in things even like market transactions in terms of equality and independence. And one suggestion that I'd like to offer is that, this is something where I think Brian might disagree with me, I'm not sure, but might suggest that one of the things that the rule of law does is it trains people to operate in this kind of independent, autonomous, we might even call vaguely individualistic approach to interactions with their fellow citizens or fellow persons, which, again, it seems to be implicit in Williams's argument, and I'll say a bit more about where else it's implicit in a minute, amounts to the claim that the rule of law as an aspect of liberalism more generally, or in addition to liberalism more generally, trains people to demand something better than because I said so, or because of this pre-existing social hierarchy, as a justification for being ordered about. And for that reason, the rule of law and individualistic liberal forms of social organization tend to reinforce one another in a way that poses serious trouble for, at least in societies with substantial pre-existing diversity, societies that started out liberal in some sense, projects like the Integralist Project, that is, projects to set on a foundation of law, a narrower conception of the good. And I want to actually try to connect this to, this is a bit of a reach, but lately I've been thinking a lot about the problem of police violence and the Black Lives Matter movement and the way in which, the broken windows policy of arbitrary power is what licenses the interactions between police and individuals that lead to so many of these killings. And I can't help but think about how the bridge between these policing strategies and the killings so often is a police officer screaming at a motionless Black person held on the ground, "Stop resisting! Stop resisting!" And the stop resisting is a kind of a trope, right? In part because it's meaningless, in part because it's so often shouted at people who aren't resisting at all. It's just sort of like the invocation of words meant to justify the next thing you're gonna do. But also partly because the implicit concept of it is really based on this kind of relationship of command and of hierarchical authority that is in radical tension with the sort of notion that the person facing a police officer is like in any way thinking for themselves or has their own interests that are at all at play. It's this sort of relationship constituted by commands in the context of the refusal to give reasons. And so obviously this isn't the same thing as like Catholic integralism or other forms of non-liberal legalism, right? Obviously it's not the same. But when I think about, for example, how a law against same-sex intercourse or the revocation of same-sex marriage rights or whatever must seem to a gay person when that law is rooted in something like a religious project for social life, it seems like it has to land not dissimilarly to how the orders of the cop in the segregated neighborhood land. That is, as a form of command unattached to an effort to reach into the capacity of the person commanded to respond to reasons. And one last, I don't know, I'm probably very badly on time. I'm doing okay on time. I'm doing okay on time. And I think that even the obvious distinguishing point that comprehensive doctrinal liberalism, unlike obviously police violence, the latter is rooted obviously in this long-standing pernicious system of white supremacy, the former isn't. But one of the things that I think is striking about the world, and it's something that I'd particularly like to hear Mila's thoughts on, as whether this is sort of empirically plausible, is that when comprehensive doctrine, illiberal governments and even illiberal scholars seem to have this really striking tendency to start to shade into the nationalist kind over time, right? When comprehensive doctrines take power, it seems very often that what they actually do at some point sooner or later is, one, abandon the project of persuading others to follow what they see as reason or revelation in favor of substituting force for agreement, that is, give up on addressing reasons to others, but two, tend to suppress underlying social diversity in order to do so, tend to ally themselves with nationalist movements that effectively define the demos for purposes both of political power and legal standing as people who happen to think like them, often associated with membership in ascriptive social groups. It's no coincidence that all the Notre Dame people are flying back and forth between Indiana and Hungary to hang out with Viktor Orban. Because I think the suppression of diversity seems to be instrumental to the project of rule by illiberal doctrines in a liberal state. And so for those reasons, I think by reflecting on these notions of autonomous social identity and of the experience of command giving that's pervasive in, particularly, for example, in segregated communities with policing, I think tentatively we can get a bit more analytic leverage on thinking about what's exactly wrong with illiberal projects from the legal perspective more generally. I think I might be completely off base.
So there's a lot to unpack there in a 1-minute summary of that wonderful early thoughts on illiberalism and whether it can follow the rule of law, whether it really turns into nothing more than the suppression of diversity, and also have us really think about when we expect governments to offer reasons for its actions, what reasons can be acceptable. All right, so I'm going to turn us to our last panelist. We have Professor Brian Z. Tamanaha. Again, did not check pronunciations. He's the John S. Lehman University Professor at Washington University in St. Louis School of Law. He's a prolific and powerhouse scholar in jurisprudence, law, and society. He has delivered countless keynote named and public lectures. He has authored over 75 articles and book chapters. He has published 10 books, almost all of them by the presses of Oxford, Cambridge, Princeton, and University of Chicago. Many of his books have been translated into other language, and many have won prestigious awards, including the IVR Book Prize, the Dennis Leslie Mahoney Prize in Legal Theory, and the Herbert Jacob Book Prize. In 2003, 300 law deans and professors voted Professor Tamanaha to be the #1 most influential legal educator for his famous book, Failing Law Schools. That'd make for an interesting talk. His recent books include Sociological Approaches to Theories of Law, which was published by Cambridge University Press, Legal Pluralism Explained, History, Theory, and Theory Consequences, published by Oxford University Press, and A Realistic Theory of Law, published by Cambridge University Press. Professor Tamanaha obtained his JD from Boston University, and then after clerking and practicing for several years, obtained his SJD from Harvard. Professor Tamanaha will take a deep dive into the vertical and horizontal aspects of rule of law and illustrate how nuanced the concept of rule of law is in application.
Thank you, Hallie. Before getting into my talk, I want to make 2 points in direct response to the theme of the symposium. It's been a great symposium. So the theme is the future of America's efforts to promote the rule of law abroad. So the first point I want to make is that we should stop promoting the rule of law abroad, or at least declare a moratorium, and actually focus on the rule of law in America. And the reason I say that, and this was alluded to by a number of speakers before, but for example, there was a lot of focus on China today. America talking about the rule of law is, I believe, if you pay attention to other societies, seen as hypocritical lecturing. You may not have noticed the passing, but just a few weeks ago was the 20th anniversary of the opening of Guantanamo. We now have several dozen prisoners in Guantanamo, almost all of whom have never been charged and have never been tried. And yet they've been there for 20 years. Also, I need not emphasize that we committed torture, and that was waterboarding. But in addition, if you listen to the Chinese government, they're well aware, for example, of the things that Paul mentioned about a system of policing in our society where Blacks are disproportionately stopped, arrested, and killed. But we can talk furthermore, and the Chinese have raised this, about the fact that we have mass shootings almost every day now in our country, and not to mention, or I will mention actually, that the last president tried to stay in power with support of over 100 congressmen on fraudulent fake charges about a fraudulent election. So we have really quite significant problems in our society. And I want to try to occupy their position for a minute and listen to what we're saying when we say, hey, you need the rule of law. By the way, I want to mention something about Poland, and I'm not apologizing. Everything that was said about China is terrible. I totally agree. Poland was sanctioned by the European Union, or at least called out. The sanctions haven't been specifically imposed yet, for manipulating courts to stack the courts for political views. And of course, that's what happened in the United States when Senator Mitch McConnell refused to hold a hearing on Garland for 8 months, and then confirmed Justice Barrett 8 days before the election. So everything that we look out at, I think we ought to turn that critical focus back on ourselves. And then when we promote the rule of law abroad, what we say will have much more credibility. So that's the first point about the theme of the symposium. The second point, since I know no one's going to listen to what I just said about the first point, the second point is that when we talk about the rule of law abroad, I think starting point number one is that we have to take societies from where they are. Too much of our rule of law promotion is about, you have to become like us, which I just suggested maybe isn't all that great in some ways. All of the criteria for the rule of law, everything we do is imposing a particular template on every society. And if you don't match our template, then you're deficient in relation to the rule of law. If we expect advances in the rule of law, and I think the rule of law is fundamentally important, we need to understand where those societies are, what kind of society it is, what its views are, its social arrangements are. Okay, so that was very quickly just 2 responses. Now I'll get to the paper, which will be much less blunt and interesting than my preliminary comments. So the title of the talk is Horizontal and Vertical Dimensions of the Rule of Law. This terminology has been used by many people, myself. I started using it 15 years ago. Paul's used it. So a number of other people have used it, but I've never seen it really analyzed in any kind of systematic way. So I'm going to propose to do that for you. And I think it's a really illuminating way to understand some of the some aspects of the rule of law that I think are often lost. So let me just very quickly identify each dimension. So the vertical dimension is the dimension of state and society. And so this examines the top-down relationship between government actors and private actors. When I say private actors, think citizens, corporations, and so forth, in relation to how the ruling regime, the polity, treats or interacts with citizens. This includes the construction of the government itself, but also the governing powers, taxes it impose, fees, seizures, arrests, draft, its treatment of citizens, drafts, military and policing activities, arrests, imprisonment, execution, banishment. It also includes laws that protect governments, for example, sedition and treason, demanding cooperation with officials. It also includes laws restricting criticism of the government and the like. So these are laws that deal with, or the rule of law focusing on how the government and the ruling regime in particular deals with citizens. The horizontal dimension, on the other hand, examines the side-to-side relationship between private actors on matters of everyday social and economic discourse. So this includes contractual relationships, commercial transactions, property ownership and exchanges, debt, intentional and accidental injuries, property, marriage, divorce, child rearing, inheritance, all of the basic things that people's lives revolve around. Now, this distinction is just a heuristic. It's a conceptual distinction. It's a framework that helps us see things. There's obviously overlap. It's just a metaphor. But I'm going to apply it later on and show you that it's a very useful way of looking at things. The bulk of attention in the rule of law discourse is actually on the vertical dimension, on how government treats citizens and restraints on government. I want to suggest that the horizontal dimension is at least as important, and I'm going to say in some respects more important. Okay, so now to avoid getting bogged down in theoretical disputes about the definition and concept of the rule of law, much of which has been written about, I'm just going to stipulate that the rule of law exists when government officials and private actors are largely bound by and abide by the law. It's just, this is the rule of law. Or put negatively, the rule of law does not exist when government officials and citizens are not largely bound by and abide by the law. Now, I say largely because no society has perfect law compliance. Now, this isn't a definition or a conception. It's just a description or criteria for the existence of the rule of law. Okay. Now let me shift to functions, because this is another big topic in the rule of law. So among legal philosophers, the functions of the rule of law most often or the purpose of the rule of law most often are identified in terms of 2 different things. One is, and I'll quote Jeremy Waldron, the whole point of the rule of law is to secure individual freedom. And this is the idea that individuals' liberty is secured when we know in advance the legal rules that will be applied to our conduct, and we're free to do anything that's not disallowed. Another favorite of legal philosophers is that the rule of law, and I'll quote Martin Craigier, the rule of law traditions have particularly focused on the arbitrary exercise of power, often using precisely that word. So from their standpoint, the telos, the purpose of the rule of law, is to restrict arbitrary power. Now, there's lots of debates about the purpose or point of the rule of law. I am actually skeptical of that argument because the rule of law is a tradition stretching back 2,000 years, raised by all kinds of different theorists in all kinds of different settings. For me, a more useful way to talk about it is in terms of the function. So function is not a telos or a purpose. Function is just about an effect or a consequence of the rule of law. And let me add a third. So even as a function of the rule of law, you can say the function of the rule of law is to secure and enhance liberty. The function of the rule of law is to restrain arbitrary power. But one thing less often emphasized, although it's out there in the literature, is that another important function of the rule of law is to bring a stable social order, to bring security and trust within a society. Now, anytime I say anything, there's much more to say. There are other functions. Paul talks about bringing equality. I've talked in the past about the constitutive function of the rule of law, but I just want to focus on those three, because those three have a particular relationship with the vertical and horizontal dimension. So let's go to the vertical dimension now, which again, I defined as government treatment of its citizens. So the enhancement of liberty and the restraint of arbitrary power, the first two that I mentioned, are primarily oriented to the vertical dimension. So I'm going to read Friedrich Hayek's definition of the rule of law, which evokes this specifically. Stripped of all technicalities, this means that the government in all its actions is bound by rules fixed beforehand and announced beforehand, rules which make it possible to foresee with fair certainty how the authority will use the coercive powers in given circumstances and to plan one's individual affairs on the basis of that knowledge. So that's the idea. And again, I'm suggesting this is the vertical function. Plato, here's a quote, where law is the master over rulers and rulers are slaves to law. See, all of these are oriented to cabining rulers within law. I have many more examples, but I'll leave that out. Let me shift to the horizontal. The third function, and that is social order, security, and trust, primarily focuses on the horizontal dimension of social intercourse, social and economic intercourse between private actors. Now, most liberal theorists don't focus on the social order function. I'll just give you two brief reasons. One is because liberalism itself is about paranoia of government and individual autonomy. But the other reason, which I think is really important, is that all of these theorists live in societies in which they take social order for granted. So it was never an issue from their standpoint. So they just didn't focus on that. Now, all rule of law talk goes back to ancient Greece. I won't quote it for you, but there was a contemporary of Plato, his name was Anonymous Iamblichi, who talked extensively about the trust and security brought by order, a social order governed through law. Some great quotes, you'll have to trust me, read the article when it comes out, which are amazing. And he even talks about economic development. People are more engaged in economic activity when they don't have to worry about holding on to their property and hiding it under the bed. Now, what that involves in modern society, so I'll bring it up to the present, think about how much laws affect our lives. Contract laws are involved in all of our employment relationships. Criminal laws protect us from violence. Property laws allow us to accumulate property and exchange property. Family laws create rights and responsibilities, marital unions. So all aspects of our existence are affected in these legal rules. And importantly, we just take this for granted. It operates in the background of our existence. We just assume that these rules are in place should anything go wrong. Now, to appreciate the significance of that background, imagine if we're exposed to a high risk of assault or robbery, properties taken, that the injuries happen and people don't recover anything. This have no remedies. This would be a life of insecurity. Okay, so now I want to make one quick point and then move on. And this, I think, is often lost sight of as well. When we talk about the vertical relationship of government to citizens, we also forget that the government itself participates in the horizontal order. And what I mean by that is one of the biggest employers in the United States is the government. And how does the government work? It has contracts with employees. The government holds property. The government enters into leases. So one key point I'm making about horizontal and vertical is that although government is seen as a vertical relationship, it also, like all other private parties having private rights, operates within the horizontal arena in very significant ways, and the government benefits from the security and trust provided by this as well. Okay, so now let me shift to the rule of law demands differs depending on these two dimensions. So I'm going to read a quote from a really great recent book, and recent, I mean a couple months ago, by Gerald Postema, terrific philosopher, in which he says that the rule of law recognizes, and this is just a standard view out there, but he articulates it quite nicely, an asymmetry in the demands depending on government and citizens. So here's the quote. From law's point of view, ordinary citizens in a polity may do whatever is not prohibited. So we can do whatever's not, whatever the criminal law says I can't do, I can do it. But for government officials, however, may only do what is authorized by the law. For the citizen, anything not prohibited is permitted, but for officials, nothing is permitted unless it is specifically authorized. So this asymmetry, he suggests, exists because ordinary citizens have moral value. I'm going to suggest there's a different reason for it, because this is an old asymmetry. And that reason is the worry, the concern about the overwhelming coercive power that government is able to impose on us. Like, governments can seize you, take your property, imprison you, exile you, and kill you. And this has been a concern for over 2,000 years. So that's why the rule of law says ex ante, government, if you're going to act, you must have legal authorization for your actions. Meanwhile, citizens don't pose the same concern to one another, right? The rule of law in relation to citizens is just about facilitating our intercourse with one another. Okay, very quickly, I want to shift to the horizontal and vertical dimensions of the international rule of law. So the international law is about horizontal rule of law in the sense that international law is analogized to as domestic societies or societies of citizens. International law has always been seen as a society of states, an international community of states. And this community of states is understood to exist within the legal order of international law. So, and I'm just going to read the UN 2012 Rule of Law Declaration, unanimously adopted by the UN General Assembly, which says that legal relations in international community, quote, are guided by the rule of law as it is a foundation of friendly and equitable relations between states and the basis upon which just and fair societies are built. So there are very strong parallels between domestic rule of law on the horizontal arena and international rule of law on the horizontal arena. On the vertical arena, on the vertical dimension, the international law is very underdeveloped precisely because we don't have strong institutions of lawmaking. There's no coercive government. There's no body of law. Okay, I'm going very quickly, but I want to get to the examples. I've got 3 minutes. Okay, very quickly then. I'm going to have to talk even faster than I'm already. I just want to say something about China. So everything that was said earlier about China is absolutely correct and it's terrible. On the other hand, what commentators about China fail to emphasize often enough is that the Chinese government in the last 20 years has significantly increased legislation, the legal profession, courts, the routine bulk of cases. And so here's a quote from a scholar who's criticizing China. They don't have the rule of law, they just have rule by law, but, and then we have to admit, there have been considerable efficiency gains in resolving non-sensitive legal disputes, those faced by the majority of Chinese population. In other words, there have been significant horizontal development in the rule of law in China. Everything else is bad, but that is fundamentally important. And so our analyses, when we say China's rule by law, China's bad, 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 I think is a too one-sided and a more nuanced assessment is that the rule of law vertically is weak or non-existent, but horizontally is increasingly robust. And that's a very important thing. Okay, so let me very quickly, and this is the last one I'll raise. I won't do the other. I had 4, but never mind. The next one is customary law in post-colonial societies. Today, many post-colonial societies live by customary law. I'm going to just very quickly quote a World Bank report. In large parts of Africa, customary law is heard by 90% of the population, governs the interaction between 90% of the population, and then it gives specific countries and so forth. I want to contrast this with with all due respect, I thought I would use that phrase today, with the World Justice Rule of Law Index. So the World Justice Rule of Law Index uses 8 factors, but it lists a 9th factor, and that 9th factor is informal justice. And the Rule of Law World Justice Project recognizes that customary law and religious law play a large role in countries and jurisdictions where formal institutions are weak. Nonetheless, quote, the complexities of these systems and the difficulties of systematically measuring their fairness and effectiveness make cross-country assessments extraordinarily challenging. For this reason, the informal justice factor is not included in the index scores and rankings. Now, if there are a bunch of countries out there that have 80 to 90% of their disputes and even property ownership, marriage, all of these fundamental things, debts governed by customary law, and you are not taking those into consideration, the ranking has a systematic bias in favor of societies without customary law. In fact, it's a major and gaping omission. I think there are a couple ways you can account for this, but we can maybe talk afterward. I'll say at the very least, you should have either a boost in their scores or you should put an asterisk next to their names, suggesting that it's under-recognized. And I'll stop on that.
I want to thank my panelists for not making me pull out that squirt gun. We have another person to introduce who's going to be appearing by Zoom. So let me pull. Oh, that didn't work. All right. We have Dr. Kevin Cope. He is the co-author with Professor Versteeg, make sure the pronunciation's right. And he's offered to fill in our Q&A session for her while she had to run to the airport. So Dr. Cope is an associate professor of law at University of Virginia Law School and an associate professor of law and public policy at the Batten School of Leadership and Public Policy at the University of Virginia. He has published a variety of articles in Journal of Legal Studies, Journal of Empirical Legal Studies, Michigan Law Review, and the American Journal of International Law. Dr. Cope also has had short articles appear in the Atlantic, 538, the Washington Post, Monkey Cage, and Slate. I actually had to go look and see what the Monkey Cage was. Prior to joining the law school and public policy school faculties at UVA, he served as a judicial clerk on the U.S. Court of Appeals for the Ninth Circuit and for 2 federal trial courts, and he worked in private practice at Skadden and Arps. Dr. Cope received his JD from Northwestern and his PhD in political science from the University of Michigan. So one more welcome. So fortunately, again, thank you, my panelists. I actually have a chance to start off our discussion with a few questions. So I'm going to take that opportunity. And my first question, and this is based on Dr. Anderson mentioning the concept of people-centered justice, as well as the work of Dr. Cope and Professor Versteeg, who might be Dr. Versteeg now that I'm thinking about it. How much should individuals' perceptions of what constitutes rule of law or what they identify as their justice needs and wants inform how we define, measure, and ultimately address rule of law? Anybody is welcome to speak first. Do you want to go ahead, Paul?
Yeah. So I'm very much not an empiricist, but I think that the history of social movements can give us some more useful insight from a non-empirical standpoint. And if we think about this sort of informally for like 30 seconds, particularly in countries that have begun with substantial degrees of ascriptive inequality, but which have also featured really vigorous social movements claiming access to things like the rule of law on the basis of the observed benefits to relatively more advantaged sectors. Epistemologically, I would suggest that those movements are much more likely, A, to have a realistic assessment of the benefits of the rule of law or of similar institutions, but also B, if we think about the kinds of institutions like the rule of law as also politically loaded in the sense that they never exist in isolation from the capacity of interest groups in a society to claim them, that the political awareness experienced by successful inclusion movements gives us really strong, at least initial hypotheses about the conditions necessary to actually sustain institutions like the rule of law.
Dr. Cope, do you want to respond?
Sorry, could you repeat the question real quickly?
Yeah.
I missed just
Okay.
part of it.
Sure. How much should individuals' perceptions of what constitutes rule of law or what they identify as their justice needs and wants inform how we define, measure, and ultimately address rule of law?
Oh, great, thanks. Yeah, I think it's a great question. And our project is kind of motivated by the notion that people's perception of law and how the government is serving them is, if not the best predictor of rule of law, at least a very good one, and one that hasn't gotten much attention thus far. In fact, I don't know if Mila would agree with me completely on this, but I might go so far as to say that it's, obviously philosophers have attempted to define the rule of law, have debated. We have definitions from Lon Fuller and Jeremy Waldron and others. And all of those, for the most part, are sort of a priori based either on normative or positive accounts of what rule of law is, derived from other principles. But rule of law is one of those terms that there's really no consensus on, and unlikely to be consensus on the future, such as, what a planet is, whether Pluto is a planet or whether alcoholism is a disease. Ultimately, we can really make the most progress, not by debating a priori what rule of law is, but by defining a set of measurable outcomes and then seeing what elements of a legal system accomplish those outcomes. And so that's sort of what motivates our project. Some of the things that we ask people are, and we're still tinkering with the questions and looking forward to all of your feedback on this, but we're interested in, does this system of rules that we're presenting people with, does it make them feel like they're in a system, they're being served with justice? Do they have a sociological feeling of justice? Another one, and probably the more interesting one, is, can people predict the legal consequences of their behaviors and of others' behaviors? And then related to that, what Brian talked about at some length, is there, to what degree does that promote social order and security? If somebody behaves in a way, if someone acts in a way that infringes on a right or that injures me, by not scraping the sidewalk or by robbing me or injuring me in some other way, can we reliably predict that I will be vindicated by the law and by the government? So those are all things that we can measure. At least we hope that we can in some small way. And then at the end of the day, we can say, this system of rules accomplishes these tasks, which we seem to think is what rule of law is, and this other system does not. But ultimately, this is all going to be driven by ordinary people and their belief in how the law is serving them. So I think that that's an excellent metric, if not the only one, an important one in defining and measuring rule of law.
I have a second question. Both Professor Tamanaha and Professor Gowder see rule of law, and hopefully I'm not speaking too much over Professor Tamanaha's perhaps objection, see rule of law as an inherently liberal concept. No group, whether a populist movement seeking majoritarianism or religious or cultural group seeking enforcement of religious or cultural law against reluctant members, is permitted to subjugate other individuals to their will, because rule of law protects the idea that all individuals are equal. This, by the way, would be a thick definition of rule of law, I've now learned. Is rule of law then potentially a form of cultural imperialism that forces societies that wish to be illiberal to conform to Western standards of liberal democracy?
Yeah. So yes. I don't think it's a coincidence that if you look at, and it's not just the World Justice Project Index, but it's all of them, the heritage, and there are a few non-Western countries, but by and large, Norway, Sweden. So what is that? Well, it's the package. It's our package. It's a liberal democratic package. By the way, I love that package. I'm glad I live in a society like that, but I also understand, and I lived in a developing country, YAP, for 2 years, that there are completely different ways of life And that package does not fit their life. And I do not believe that it is a useful exercise to insist that every society has to become like ours to get the rule of law. If we think the rule of law is important, and I do, and frankly, they do, then it has to be tailored or at least understood in ways that are not require them to become us, because they're never becoming us. So I actually do have lots of hesitation about how we, and this is a part of the promotion of the rule of law exercise. By the way, what was mentioned earlier about us attaching conditions to loans, I don't see that as a good thing. I actually see that as coercive. And not just coercive, but undemocratic, because these societies are forced to undergo reforms that don't take within society, that the society isn't consulted. Now, again, I like lots of good things about the rule of law. I'm just saying that I think this approach that we have is too template-based, too Western-based, and too heavy-handed, and it creates backlash, and it's not successful. I do not believe it works well, and there are lots of reports saying it's not working well, so that's not just me.
So I want to actually propose a high-level principle, and I literally am just pulling this out of thin air right now. But nonetheless, I think there's something to it. It is that we ought to understand a prohibition on the forcible suppression of diversity to be a core feature of the rule of law, essentially for the reasons that I gave in my sort of main presentation. Now that principle, if you accept it, plays out differently in the domestic and in the international context, right? So in the domestic context of any state, what that suggests is a sort of minimal liberalism. Minimal liberalism meaning not necessarily incorporating all of the stuff about markets that people who call themselves liberals like to do, and not necessarily incorporating any particular religious or secular commitments, but incorporating a good degree of deference to existing groups and individuals within that society that rules out, for example, things like illiberal projects in countries like the US. But in the international context, that principle also would, I think, lead to a strong endorsement of what Brian just said, right? That is to a recognition that by importing an extremely US-centric, developed country-centric, Western world-centric conception of the details of how well-organized legal orders play out in cultures that have different foundations for what they understand as binding commitments and effective methods of enforcing them. Again, we're engaged in a fundamentally anti-liberal exercise in that sort of thin sense of liberalism that incorporates this prohibition on the suppression of diversity.
Dr. Cope, did you want to add anything before I go and ask for?
I'd just add one thought, and I'd maybe push back a little bit on the notion of liberalism and rule of law as two sides of the same coin, if that's how it's being characterized. I think that there are some, we'll just take Lon Fuller's elements. There are a couple elements there, and obviously there's not consensus that these are the elements, but there have been widely used and cited. There are many elements there that can operate without or in an illiberal society, but most of them do not require that. So you can have laws that are clearly announced, that apply to most everybody, that make sense, that provide predictability, and where people understand and can predict the legal consequences of their actions. You can have all of that in an illiberal society. You can even have that in an authoritarian society. And so empirically, that may not be likely, but conceptually, I think it's possible to have a society with high rule of law that is authoritarian and thus illiberal. Now, the question is that a stable state of affairs? So is an authoritarian high rule of law society likely to stay that way, or is its illiberalism likely then ultimately to devolve and to erode the foundations of the rule of law. And I think that history has shown often, yes, it is. But conceptually, these are two separate things, both desirable things in my view, but they don't necessarily go hand in hand. One of our examples, one of our vignettes in the experiment deals with a homeowners association. If you've ever been part of a homeowners association, I've heard more than a few people refer to them as authoritarian regimes. And yet it's kind of their dedication to the rule of law that makes them that way, and that is perhaps one of their most defining features. So just with that, I wanted to throw that out there.
Can I add something? Because I want to give a concrete example, and I'm not talking about illiberal and authoritarian societies. I want to talk about customary law for a minute, because we have these assumptions about the procedural elements of the rule of law. Of course, that's universally good. So in many of these societies, for those of you who don't know, in the customary law system, the laws are not written. They're actually customary law. And when events happen, and these laws govern property, they govern injuries and everything, village elders come, and often the community comes together. And so this isn't an unbiased decision maker. And the objective of the proceeding is to come to a consensus, reconciliation is a better word. So what I'm saying is, in these societies, the whole orientation is fundamentally different from formal legal systems. It would not satisfy any of the procedural requirements. But now let me just flip to the United States for a minute. I think something Director Anderson said. Did you hear that on access to law in America, it's what, 115 or something? Well, in these societies, the people go to their customary law system because it's right there. They have immediate, if you talk about people-centered justice, they have immediate resolution of disputes. There's a reconciliation ceremony, everybody comes together. And yes, there are bad aspects of their system too. But what it does provide that ours don't is it provides dispute resolution in ways that, happy or unhappy, more or less, there's a resolution. So I want to even push a little bit further on our assumptions about there only being one kind of legal order. It's Lon Fuller's 8 elements of justice. That's the rule of law. If you look at the rule of law in terms of legal order, security, and trust, that's what they do. That's what they have. And they have it in an immediate sense that they can understand and relate to, in a way that I think in the United States, and I believe the UK as well, it's incredible how many people in legal disputes do not take it to law, do not have legal assistance out of cost and lack of information, but cost is a big issue as well. So why we would think their system is bad and has to become like ours, and I'm looking at ours going, wait a second, is once again me saying, maybe we should not just assume that our way is the only way, or even our way is always a good way.
Thank you. All right, now is your opportunity to ask some questions. We have microphones on both sides of the aisle, and thank you, George, for making sure that nobody's going to be waiting in a pause. So if others would like to line up, and you can go ahead with your question. George, you want to ask a question? Oh, you're looking for it?
I do, and I doubt to remember the question that I've been cogitating on for the past 20 minutes that has now escaped in front of mine.
All right, so Dr. Anderson.
Okay. Thanks very much. And I just thought I'd jump up and maybe disappoint Professor Tamanaha by agreeing with more of what he said than disagreeing. But I take the point on informal justice. The reason that we developed that module of the index was to actually see if there would be a way to capture all the good that you're describing. We think we have a methodology, but we can't use it in a globally comparable way. The asterisk is a good idea, but the most important thing is in the methodology of the index, by using outcome indicators that are asking people about how all of these systems in all their variety are playing out in their lives, is that we capture much of the good that you're describing. And that's why the US is 115th. And, some of the societies that you're talking about are, perhaps higher in the index specifically on access to justice. And the other thing I wanted to say was, to the extent that there's any suggestion that the index methodology is prescriptive of a specific template that needs to be implemented. I just wanted to disabuse anyone of that impression. Again, what we're looking at is outcomes in people's lives, and then leaving it to individual societies to think about ways in which they can, true to their culture, history, existing institutions, and political system, achieve those outcomes more effectively.
Yeah, it's not, that's a modest stance to take, but it's not quite consistent with something you described, but something that exists in general, which is that, as you mentioned, certain international institutions are looking at the rule of law index and talking to governments about whether or not they're going to be eligible for loans, for example, and that they have to improve. So you may not have it as a prescriptive goal, but it's certainly being utilized in a prescriptive way. And it's utilized based on the assumption that your index has authority, that it is capturing something real about the world, and real in two respects: real about what the rule of law is and means in one sense, and then real about what that society, what that particular society has in relation to the rule of law. So yes, but no. And the no part is when it is utilized as a condition for loan or for putting pressure on governments, it's having immediate and quite significant prescriptive impact.
All right, now I'm gonna see if George has managed to pull up his question. Yeah,
Not sure I understand the question.
I think he's looking at, he's trying to determine, I think more on a US policy level, where we try to promote rule of law and where we don't. And if there's something behind a particular geographical focus or on particular countries. I don't know if you know.
Let me give an example. So the USAID was involved in a rule of law project in Ukraine. And I know about it because they asked me to come and join them. And the people I spoke to were incredibly enthusiastic. There were judges, professors, lawyers. I think that's perfectly acceptable. They were invited in. And they were focused on institutional reforms that the Ukrainian people wanted. And legal educators wanted it. So when you're invited in, when they are expressly reaching out and saying, this is what we want to be, I think it's absolutely something that we should do. And they sought out assistance from the USAID. So I'm not, totally against the whole thing, but that's not the circumstance everywhere. And I think lots of things that were being done in general terms, the Heritage Foundation, all of these things are not like that. Those are simply putting themselves out there. I was, just speaking of America, I was at a talk at Singapore on the rule of law, and the president of the ABA was giving a lecture on the rule of law and how Singapore rule of law, and the Minister of Justice got up and said, well, look at the US. So this is what I mean. If it's perceived as hypocritical lecturing, it's just not going to work. If it's perceived as you have something we have to offer and please help us, it's going to work. And that's a big difference in how it is these projects are put out there.
Might want to like to say something a little bit diversionary, but I think can sort of help us think about this problem as well, which is that in a lot of ways, the
field of rule of law advocacy is really two fields, right? Field number one is what we could call the economic development rule of law advocacy field. And, participants in that field, love to focus on things like property rights, oftentimes, how shall I say, very well funded, and oftentimes associated with, the program of, I've never still figured out what neoliberalism means, but to the extent it has a meaning, it could probably be reasonably well applied to that program. And that description, the description and the sort of the vision of the rule of law captured by that program, I think tends to be, number one, focused on the kinds of institutions that are congenial to multinational firms. And the kinds of institutions that are congenial to multinational firms tend to be, the more formal institutions, the kinds that are easier for multinational firms with roots in countries like the US to work with. And I think, it's easy to have international development efforts that go the wrong way. The second rule of law community we could sort of more or less casually characterize as the human rights community. And I think, the human rights community itself has posed a variety of problems because the human rights community is not obviously immune from parochialism. But I do think that, at least relative to the other rule of law development program, that the human rights community has shown a stronger tendency to focus on things like the genuine needs and expressed wants of people in countries that are the recipients of rule of law projects.
So in your view, is it?
Hold on.
Oh, sorry.
I want to give somebody else, I'm not even sure we have time, otherwise I'll let George finish. One more minute, I'm going to go ahead and give one other person.
I can ask you.
Sorry, George. Go ahead.
Hi, thank you. Question for Professor Gowder. I've read some of your work about immigration and expedited removal and how that relates to the rule of law. I'm curious if that maps on to your conversation about illiberalism before it all.
I think it absolutely does, because and this maps onto what I was hinting at in my sort of what's the one part of the next project is, the reasonably to extremely subordinated legal status to which immigrants in the United States, and particularly to which sort of putative immigrants in the United States, those formally subject to the plenary power doctrine in the US, are subjected. I think there are two things about that. One is that, at least on its surface, it requires some significant argumentative work to reconcile it with either the idea of legal equality or the idea that at a bare minimum, access to process, even for the adjudication of hierarchical legal rights, is required by rule of law ideals. But I think second, and more importantly, and I go into this in chapter 6 of my last book in some length, is I think we can see a meaningful and important continuity between the forms of the exercise of power that the legal system adopted and corrupted itself with to address people such as the enslaved, Native American nations, the subjects of the other kind of plenary power in the United States' colonial adventures, and those who present themselves at the border in the immigration context. And, we can, if we think that our conception of what the rule of law is has to be responsive to our observations of the world, then we can observe that techniques that are used in these manifestly lawless contexts, such as slavery and Indian removal replicating themselves, is at least a significant red flag for current legal doctrines around things like immigration.
All right, I think our time is up. So I'd like to thank each of our distinguished panelists, including Dr. Versteeg, who's not still with us. And I think we're off for a break. So thank you.
We're gonna get started. All right. This is our last panel and third panel, Advancing the Rule of Law. And I'd like to welcome the moderator of this panel, Ms. Hillary Forden, the Senior Associate Director of the Rule of Law Program at the Carter Center. Ms. Forden has over 15 years of experience in rule of law development work, and she's a lawyer as well. So please welcome Ms. Forden, who's going to be introducing our panelists and moderating the panel.
Thank you so much, Eric, and thank you to the Emory Law Journal and to the Thrower Committee for inviting me to be here today. I'd like to take this opportunity to thank the Thrower family for their generosity in making this event happen. I've really enjoyed it. And I think our final panel, we're going to take the topic of the symposium head on and really discuss the history of U.S. rule of law promotion abroad since the Cold War, and use that as a jumping off point to talk about the future of U.S. rule of law promotion, looking both internally as well as externally. And our panelists, several of them will draw on their own personal experience advancing rule of law abroad as well as domestically. And so without further ado, because I want to leave time for the remarks and for questions at the end, I'm going to introduce each of our panelists now and then invite them to come up one by one to give their opening remarks. So our first panelist will be Mary Dujek, who is the president's and I'm sorry, she told me how to pronounce her name. I don't know if I got it right, but trying. All right, great. So she is the President's Humanities Fellow at Emory's Fox Center for Humanistic Inquiry and the Asa Griggs Candler Professor at Emory Law School. She is past president of the Society of Historians of American Foreign Relations and an honorary fellow of the American Society for Legal History. Among other honors, Professor Dujek is author and/or editor of 6 books and many articles on the intersection of civil rights and foreign affairs, the culture and politics of U.S. war, and other topics. Her courses include 20th century U.S. constitutional history and seminars on law, war, and society, and Emory's civil rights history. Our second speaker will be Bill Ide. Mr. Ide is of counsel at Ackerman LLP and the former president of the American Bar Association. He was actively involved with the ABA Central Europe and Eurasia Law Initiative, or ABA CELI, and its successor, the ABA Rule of Law Initiative, or ABA ROLI, for 30 years and chaired both ABA ROLI and ABA CELI. He was also formerly general counsel of Monsanto, a global company, and executive committee chair of the East-West Institute, a global NGO. Mr. Ide is also co-founder of the Georgia Legal Service Program. And finally, we'll hear from Judge John Smybert, who was with the Department of Justice as its attaché in Albania and Kosovo from 2006 until 2019, when he returned to Atlanta to be appointed as a judge. Judge Smybert was part of rule of law development in both Kosovo and Albania, as well as in Moldova. He was part of constitutional and legislative drafting in Kosovo as it became independent, and was a leader in Albania's 2016 amendments to 1/3 of its constitution and numerous major legislative changes to reform its judicial system for EU secession. Secession. And he teaches rule of law and comparative constitutional law here at Emory Law School. And you have thorough bios for all 3 of them in your programs. And with that, I'm going to introduce Professor Dujek. Thank you.
I'm so happy to be here with you today. Can you hear me? Some people are having sound issues. Okay, if I forget to speak up, just like stand up and I'll try to raise my voice. It's such a pleasure to be here. I'd like to congratulate the Emory Law Review on yet again putting together such a wonderful and successful conference. And I'd like to thank everyone who traveled to be here with us today and share your thoughts with the Emory Law community and especially with our students. Special thanks to Eric Wang, Executive Symposium Editor. And I would like to say to Eric, I don't know if he's here, but not only do you deserve a day off, but a good night's sleep. He was getting slides from me at night and all sorts of things from everyone. Now there's a special lots of challenges coming at the end of the day. Not only do we need to keep you awake when you're tired, but so many things have been said over the course of the day, and we don't want to be repetitive, so we'll have to kind of maybe be creative along the way. And meanwhile, the slides were due yesterday, so here you go. I'd like to talk about I'm a legal historian, and I'm a historian of U.S. foreign relations and the U.S. role in the world. And I'm really going to look at that intersection between the history of legal issues and how that intersects with the role of the U.S. in the world with U.S. foreign relations. And there have been so many very important comments about the fact that we can't effectively promote the rule of law elsewhere without protecting it at home. And my remarks really go to sort of the dimensions of that, because it's not just a matter of, oh my heavens, we look hypocritical. I mean, the U.S. has looked hypocritical in certain aspects of U.S. foreign relations and global relations for a long time. You know, when the U.S. promoted democracy in the Cold War, the finger was pointed back at us. Why are you segregating school children? So now I've sort of given away the whole talk before I got to the slides, but let's just sort of look at this. So when the U.S. doesn't protect the rule of law, it does more than frustrate international rule of law efforts. It harms the U.S. image in the world in a way that affects U.S. diplomacy, U.S. foreign relations. And this is what happened in the Cold War, and it's not something that we need to speculate about. The archival records from the Cold War era are just packed full of palpable ways American diplomats said to each other, you know, it's killing us overseas, you know, this segregation, the brutality against civil rights demonstrators, it's harming us. And so we can see from that history, which has been written about not only by me, but by many historians, including Carol Anderson, who's a leading figure in our American Studies department at Emory. There's the history is copiously documented, and it's worth everyone paying attention to that when we think about what's happening in America today, not just the recent news about Tyree Nichols, but other forms of lawlessness that have been broadcast around the world. And I'm not going to show any contemporary violent images. I have one slide from the civil rights movement. So President Biden, you know, just said the image of America is at stake with the Tyree Nichols murder. Whether or not we are a country, we say we are, that we're a country of law and order. And in some ways, he's just sort of, it's the same kind of remark that was made over and over again during the civil rights movement when civil rights demonstrators were brutalized. So how does this matter? The Tyree Nichols killing is one entry in a long history. The U.S. encourages other countries to adhere to the rule of law, and then the image of the U.S. ends up being as a lawbreaker, and it's the police, right? The people who are charged with protecting and enforcing the rule of law, who are the ones who are perpetrating these heinous crimes. With the Tyree Nichols murder, oh, and I forgot to thank Andrea Quinn in the library at Emory who helped me with some quick international media research. But all around the world, there's coverage of the Tyree Nichols murder. Right now, it's principally, at least as of yesterday, demonstrations in the United States that are news in other countries. But in some countries, there's also this reflection on how the Tyree Nichols murder should cause here Canadians to reflect on their own racist practices. Now, the most prominent example of something similar was, of course, after the murder of George Floyd, which became a global event, the reaction to it. And this is a mural that was painted quickly in Berlin. There were demonstrations all over the country and all over the world in protest of the murder of George Floyd. And one of the things that's interesting about that is sometimes protesters would point the finger at their own country's practices. And that's what you're seeing in Italy. And sometimes it would be a criticism of other kinds of US practices. And so the South Korean photograph is South Koreans critical of the US military presence in South Korea. So it becomes a sort of generalized reaction to the role of the United States in the world. So why does this matter? It's not just that it's hypocritical that we're promoting the rule of law and not protecting it, but it has certain palpable impacts. It can it stokes international outrage at the US. It can frustrate efforts to promote the rule of law abroad. Why should we follow your example? Many countries said during the Cold War, when look at how you're treating your own people. And it can legitimate the abuses of foreign governments. Now, the negative impact of domestic abuses on international relations can give activists actually some leverage. It doesn't make it a good thing, obviously, but out of something terrible can come some political leverage, and that's part of the story of the Cold War, and that's what my first book focused on, where clearly the Secretary of State, Dean Rusk, testified on behalf of what became the Civil Rights Act of 1964, talking about how racism in the United States was damaging the United States and its international relations, and the willingness of some countries to pay attention to the US and not Soviet Russia in terms of who they wanted to ally with. It was at a moment when countries were becoming independent, especially newly independent African countries, and who were they going to ally themselves with? In 1950, a Dutch diplomat pulls an American aside and says, our people, we don't pay attention to this garbage from the Soviet Union, except when it comes to racism, because we know there's so much truth to it. So American racist practices basically reinforce international criticism of the United States, even from our people who are our adversaries. Now, the story of race discrimination and racial violence, et cetera, in the United States is a well-known global story. So when incidents happen, it fits into a narrative that the rest of the world already knows. The impact of racism on US foreign relations during the Cold War was so important that the Justice Department quotes from the State Department. This is quoted from Secretary of State not Dean Rusk, Acheson, that discrimination against minority groups is having an adverse effect on our relations with other countries, furnishes grist for the communist propaganda mills, et cetera. So basically, it took a lot for them to get there, but American diplomats finally paid attention to the problem and raised it, because they said, we have to do something on civil rights or we can't accomplish our foreign relations objectives. The movement was tremendously important to this.
right? Because it was the movement that kept the issue. It wasn't just lawyers and litigation. It wasn't just that there was segregation. And so the movement put the issue in the public eye. Sometimes these children, the Children's March in Birmingham, getting thrown down by high-powered fire hoses and chased by dogs. The photos of this were broadcast around the world just at the same time that Africans were coming together for the first time to form what would ultimately become the Organization of African Unity. And they departed from their agenda to debate whether there should be a break in US-African relations. So they ended up saying, well, not exactly a break, but we're keeping an eye on this. So this was really having an impact on what the US was trying to accomplish diplomatically in the world. The US couldn't save the world for democracy if the US actually wasn't protecting democracy at home. And this gave the Soviet Union a powerful anti-US weapon that was effective. So the US is having to deal with this all the time. So this is just a quick way of saying the clearest way to promote the rule of law is actually to start by practicing it. And if we don't practice the rule of law, then our ability to promote it, whatever we imagine the rule of law to be, is hampered. So what do we have to do to be in a position to protect the rule of law? Because everyone is looking at the United States still. Stem police brutality. Let's not have another Tyree Nichols murder or George Floyd murder at the hands of the police. We can't control everything, but for heaven's sakes, let's at least get legislation through to deal with police immunity. Protecting voting rights. You know, if I bring water to a long line of voters, I'll get arrested in Atlanta. So if we can start by protecting democracy, we can promote it elsewhere a little bit more effectively. And surely these days there can't be anything more important among all these other things that are equally important actually than prosecuting political corruption, including insurrectionists at the highest level. I mean, really, for heaven's sakes. So we have no business promoting the rule of law elsewhere if we're unable to protect it at home. I realize I'm reading my slide, but that's my message. Thank you so much.
Thank you so much. And I'd like to next ask Bill Ide to join us and offer some remarks.
Randolph W was a great lawyer. I had the honor of practicing law with another firm, but at the same time. And we went to the ABA together. And for those of you who want to be lawyers, he always had a noble purpose in mind. What can I do to make the world better? Well, at the same time, I can make enough money for my family, and you can do it. So I never burned out on the practice of law, and I hate to tell you how many years I've been doing it because of people like Randolph W that inspired me. But for you movie buffs, I'm your Back to the Future panelist today. I don't look like Michael J. Fox, but I lived through two futures, and I want to share with you that. The big factor in winning the Cold War with Russia was rule of law. And we made great strides in rule of law over 50 years, and I'm going to tell you about that. But today, in this future we're facing with the Cold War, second Cold War, we have those that would threaten, autocrats that would threaten all the progress we've made. And they would try and revert the world back to it was at the first Cold War, autocrats and rule by law. So let me go to the past, to the first vision, then we'll get to the future and talk what we're going to do about it. And my education on rule of law started in 1961 when John Kennedy was elected president, the youngest president we've ever had. And he was so inspirational, he just captured the imagination of our country. It was a magical time. And his "don't ask what your country can do for you, but what you can do for your country" grabbed all of us. And that launched a big movement to expand the Bill of Rights, to expand rule of law. And sadly, his assassination occurred in 1963, but it strengthened the resolve. And for decades, you saw Congress and you saw our Supreme Court expand rule of law. Very different after 50 years than it was when JFK first came in office. And I give him a lot of credit for that. There was a national spirit that we had. And that's how we started. And it was a magical moment. A few of us law graduates in our second year practice helped form the Georgia Legal Services Program. It's still in existence today, providing legal aid. So if you reach farther than you can touch, it's amazing. It sort of works. And that's sort of the spirit we had. Now, the reality of how the rule of law works came to me when I clerked for Judge Griffin Bell. And I observed firsthand the reweaving of the Southern social fabric from one of segregation, which we had, to one of full integration. We oversaw the integration of schools, police departments, Mississippi, Alabama, all those places where it was the justice system providing equality and the justice system. And also we dealt with restaurants and private enterprises that were serving the public. The Ku Klux Klan burned their crosses, and there were billboards everywhere calling for the impeachment of Earl Warren, our Chief Justice. But the justice system marched on and greatly expanded rights. So by the time the Berlin Wall fell, was another magical moment, in 1989, the US had an integrated democracy, human rights, and rule of law into a governance model that was a beacon of hope for the rest of the world. It was an incredible move forward. But good governance alone doesn't work. You have to have an economic system. You have to provide for the needs of the people. So the answer to that for the US was to create democratic capitalism. We combined market capitalism with rule of law. And that was a winning combination that propelled the US to be the economic leader. And then we had thoughtful people after World War II said, how do we make sure this never happens again? So they created the Marshall Plan, the IMF, the World Bank, the United Nations, and many other efforts for global peace. And those resources enabled the US to bring along many other nations into democratic capitalism. And the democratic capitalism ended the Cold War. With the fall of the Berlin Wall, as the autocrats' rule by law model failed. And by the way, rule by law will always fail. Corruption, cronyism, poor decision-making. Just a question of how long does it take? And we'd rather not have to wait and see the decay. So to give you examples of how all this moved, in 1978, in his trip to Atlanta, Deng Xiaoping, the China leader, announced to our host committee that China wanted to adopt market systems like we had. Our ABA delegation was hosted in the Kremlin by 1990 by President Gorbachev, discussed bringing democratic capitalism to the Soviet Union. And this led to a 25-year rule of law global growth where rule by law combined with market capitalism was viewed as the way for a country to move forward. And we were viewed as the inspirational beacon. The way we did that was US aid programs abroad, I'm talking about how we did it abroad, and great leaders. Sandra Day O'Connor, as Betsy well knows, was a driving force for rule of law through the ABA. I expect she hit almost every Soviet bloc country during our time together. And it makes a big difference. With the US government funding, Betsy and our rule of law program to open offices in most of the former Soviet bloc countries. We hired local reformers, and we worked to establish rule of law focusing on independent judiciary, independent bar association, independent law schools. Because the way you did it back then before we showed up was you had to bribe to get in law school, you had to bribe to advance. And then telephone justice was when the judge was told by the party how it should come out if it was a controversial case. Now, make no mistake, rule by law loves laws because they want stability. So they want traffic laws, they want enforceable contracts. But if it's anything political or anything with the rights of people, they want to be above it, and they'll decide what they're going to do about that. I saw that firsthand in Haiti, where we were talking about rule of law. We went down and we looked to a commercial court with all their French collars and robes on. And there they were doing contract disputes, even though it really was a rule by law place. Now, as we made this progress, it was a hard sell. We convinced, I've forgotten which country, probably in the Balkans, Betsy would know, that wearing robes was a good thing because it would give some stature. But the next thing we know, they're wearing their robes around town on a 24/7 basis as a power move. So we had some problems to deal with on that. But in the KBG, the Secret Service of Russia, when I was in Moscow, they wanted to switch cards because they want to be lawyers tomorrow, because that seemed to be a power place instead of being the Secret Service. So it was interesting. And bribes and lies were a big way of life, unfortunately, the Soviet system. But the Eastern European scene was much better. And by the end of the 20th century, the carrots of EU membership produced adoption of rule of law in most Eastern European countries. And there were other successes. The Ghana Bar asked me to come speak as president of the ABA, to the head of the legislative, executive, and judicial branch. Flight Lieutenant Gerald Rawlings was the dictator at that time in Accra. And I gave a lecture on, which fortunately my professor that taught it wasn't there. He probably would have corrected me. I did Madison versus Marbury. Thereafter, the Ghana Supreme Court ruled favorably on freedom of speech and freedom of assembly. And Flight Lieutenant Gerald Rawlings went along with it. But at the same time, as the economic side started improving, the autocrats started showing up and their cronies. And when I was in Haiti with the ABA delegation in 1994, we met with President Aristide's Attorney General. He was a lovely man. We talked about rule of law, very inspirational. A month later, he was assassinated. Tragic, but rule of law was still there. So over time, democratic capitalism did great economic process, but the autocrats started showing up, and they wanted to divide. They wanted the market system, but they wanted to put rule by law instead of rule of law. And so we started seeing that, and that has turned into the second Cold War. And it is a Cold War. First Cold War, when I was a kid, we were taught to get under desks because there might be a nuclear attack. We had the Cuban Missile Crisis. It was a very scary time. But make no mistake, there is a second Cold War going on right now. Technology has changed it. But the autocrats are very threatened by the principles of democracy. And for the past 10 years, Russia, in alliance with other autocrats, has been weaponizing social media to disrupt the US and Western democracies. They're after chaos. They want to design and encourage the rise of strongman autocrats by manipulating elections and control of the legislative and judicial process. And this tactic has been used to get into the democratic process and get elected, and then start leading to autocracies by suppressing independent voices and independent institutions. And that's what happened in Russia, China, Turkey, and Hungary. The sacking of the US and Brazil capitals are stark evidence of such rule by law tactics to thwart the public vote. And it was to my great surprise and distress when the 2016 election in the United States revealed an unprecedented rule of law versus rule by law struggle, which is still underway. Now, we've had populists before in this country, but they always operated within the principles of rule of law. Today, populism has been hijacked by deep pool money to back what I call the alt-right movement. The alt-right seek to install a strongman rule of law system using tactics outside rule of law and justify the means as far as they're concerned. So how we deal with that challenge will greatly influence the global future of rule of law. And for us to prevail in the second Cold War, we have to walk the talk. We have to regain being beacon of human rights in a democracy. And that's the challenge that we have. And the world is watching. Until we resolve that, we will not have the essential beacon of democracy, resources, and credibility it's had. So, are we back to a second Cold War? just like JFK faced with the first Cold War, or are we just dealing with a slight bump in the road? You've heard we're sliding down in democracy in our ratings. And that's in many ways deal with gerrymandering, lack of civics education, social media, disinformation, and dark money funding. And you probably know the January 6th House report shows a national scheme to change the elections despite the popular vote. That failed, but there are other strategies underway. There's an effort to have a constitutional convention that the alt-right's pushing, and they have 28 of the 34 states already approving, calling the constitutional convention. And you could bet the alt-right will be looking after the progress we've made with rule of law and seeking to pull it back, using nostalgia, using fear. So here we are. Abraham Lincoln warned us, well, he warned the people at the time, excuse me, right before the Civil War, and I quote, "The founders were the pillars of the temple of liberty, and now they have crumbled away. And that temple must fall unless we descendants, you and I, everyone here, supply their places with other pillars, hewn from the solid quarry of sober reason." Now, our democracy rose to the occasion of the Civil War. We sacrificed people's blood in World War I and II, and we resolved Watergate. We stared down McCarthyism, and we ended racial integration. That is our rule of law legacy. We've been there before with the future. We can do it again. And that spirit is what we have to have as we move forward, dealing with the alt-right efforts here and leading the West prevail in the Second War. I'll leave that with you, and particularly you new lawyers coming in. This is really something that lawyers are particularly hewn to do, but you have to have that noble purpose in your mind and grab it. Thank you very much.
Well, I guess our panel's racing right along. Over to you, John. Our next speaker is John Spivert. Thank you.
Can everybody hear me? Good? All right. Well, being a federal employee, I first must start, unlike everybody else, by saying that none of my remarks reflects any position of the United States government or any department of the United States government. Believe me, it doesn't. And I have the inevitable position of being the cleanup hitter at the end of the day, reflecting on all the different things that have been said in this panel and previous panels, things I want to agree with, things I don't want to agree with. I want to throw this out and talk about that. But I'm going to press on with what I want to say, which is regarding my experience in Eastern Europe when I was working for the Department of Justice and rule of law development for the past 2 decades. And you've heard, rule of law development has gone through a lot of evolution over the past 20, 30, 40, 50 years. Collapse of communism, events in Rwanda, Bosnia, Kosovo, wars in Iraq and Afghanistan, the global war on terror. All these, among all the other things we can say about them, they've led to a rule of law development profession that is focused on rebuilding. And rebuilding implies an optimism that things will get better. The rule of law efforts have usually had this aura of optimism and this goal of improvement. And the international community has always wanted to make things ever upward. The metrics expect upward movement from funders and others. Projects tend to focus on incremental improvements oftentimes, such as laws and trainings, capital investments, building networks. This was an optimistic era that I'm going to call rule of law 1.0. But I propose, and I think you've heard from all the different people talking, that times have changed. Rather than optimism and seeking improved states, which can happen in some places, the profession should be considering also having another role. And we can be bulwarks against backsliding systems as we're out there doing rule of law. And to speak to Professor Tamanaha, I actually think that there is probably, maybe we can have less rule of law out there and more meaningful rule of law work being done. But that's not my not my role to say. Except for I do have the DS now, so I guess it is my role to say. A primary goal in the rule of law, all the other things we've talked about theoretically, one could say is to constrain the arbitrary power, and one way is doing that is by balancing the different powers in the state. And the burden to restrain the arbitrary exercise of power oftentimes rests with the judiciary. Systems that are backsliding often tend to focus on this first. And we've heard from the World Justice Project and from the VDEM data, this is happening. I don't think I'm going to be introducing any new information if I say there's a lot of systems that are backsliding. One thing I'll point to is the 2015 to 2022 68% downward trend in the constraints on government power. And I think that's an important thing to think about. There's all other aspects of the rule of law we can talk about. I've been in systems where they've also had customary systems of rule of law, where customary systems of justice outside the formal systems that have dealt with things. That's useful, but I think there's still something about that vertical relationship between the people and the system of government. So what's often the target? As I said, the judiciary. And this is something I think that has been going on. We've seen in slides. I don't have to go through what I've written since probably about 2006, 2005, 2004. This has been a trend that's been ongoing for quite a while. Previous speakers have talked about Kim Lim-Shepley's pattern that she calls autocratic legalism. And that's where an election is won legitimately, and then the winning party then starts to dismantle courts and other institutional safeguards. And then we see that in places like Hungary and Poland and other places that have been going on, Turkey. And I believe she's accurate when she says that this has been something that's been following a plan that's been passed around, and nascent authoritarians have been developing this plan and using it. So authoritarianism, she says, is no longer being achieved with tanks in the streets, but with teams of lawyers. What she says and what I've seen, those teams of lawyers have a playbook. So while we've been developing rule of law 1.0 and doing that in the world, this has been this other playbook that's been in operation: autocratic legalism. So it's clearly easier to dismantle than to build, and we've been building and they've been dismantling or co-opting. So we've entered this era where the rule of law, democracy, constitutionalism has been subject to a kind of a planned decline, and our development strategies, rather than doing what we've been doing in some places, needs to start addressing that. We need that playbook. And this approach requires new priorities and strategies and expectations and tools. So what kind of tools do we have? We've heard some people talking about some tools that could be used. I think, this idea of what ordinary people, justice, and how they would see legitimacy in something from having a people-centric justice system, that's actually something I think can be quite meaningful. People talked about the ESG movement and the role of corporations as they go out. That could be something as well. What we've been doing has been a lot of trainings and promoting independent judiciaries and legislative drafting and the like. But we have a system right now where there's a lot of funders, and those funders have different priorities. We have diplomats out there from different countries, ours included, with conflicting priorities, depending on what's important to that country and what's important to them with that relationship they have internationally. And that frames oftentimes expectations of what rule of law projects are going to do. So there's no consensus in the rule of law community what to do when something backslides. There's no consensus on what to do when it reaches the end of the backsliding. And we see that some of those responses has been like sanctioning in the EU. Poland and Hungary have been sanctioned by the European Commission, well, sanctioned, they have a Article 7 procedure against them. And that has resulted in the EU cutting in Hungary $6.3 billion from the EU's funding that goes to them. And that's one response. That's one tool. It's reactive. It's not something that keeps things from sliding. It's something that gives us something to say that that was bad, but doesn't use our efforts overseas to do something to keep it from happening or slow it down. So my major work overseas was doing constitutional development, Kosovo, Albania mainly, and we built many institutions, by invitation with their efforts. And I'm a firm believer there's no cookie cutter response or no cookie cutter way to build something. You have to do it in a way that makes sense for that area. And some of those institutions we built were what we would call fourth branch institutions, which is something outside that normal three branches we talk about. And executive, legislative, and judicial. In many of the places I worked in, there are parliamentary systems. Parliaments and prime ministers oftentimes share the same fate and agenda. So really, it's really two systems giving balance. So the judiciary is a clear target. And that's one thing that when you're building these fourth branch institutions, that can include things like a constitutional court as opposed to ordinary courts, or election commissions, ombudsperson's offices, human rights commissions, specialized anti-corruption agencies, or auditing agencies and the like. And what we built in Albania, I just want to talk about. How much time do I have? 10 minutes, I got you. 5 minutes. So I'm going to talk about three things we built in Albania that were these fourth branch institutions. One of them was an institution to vet judges and prosecutors. And I'll talk about that because that sounds dangerous, and it is. We built a constitutionally ensconced anti-corruption prosecution office and court. And then we built independent judicial and prosecutorial councils and other things, but I'll talk about these three. Vetting was the most risky. You can imagine vetting of judges and prosecutors sounds like a very quick way to have them captured. And so we were very worried about this, but Albania had a very long history of deep corruption. The Venice Commission was one of the participants in this process, and it considers judicial independence to be quite important. But it also said, and I quote, it recognized a paradox. Constitutional guarantees have been bestowed on judges who are not yet independent and impartial in practice. That led to widespread corruption and lack of professionalism. So they recognized the issue and the problem. We recognized the issue and the problem. The Albanians recognized it. They wanted EU membership. So the Venice Commission approved of this, but said it had to have some conditions, such as it had to be temporary. It had to have appeal rights to another body that was temporary, that was judicial, that we were part of, and had to have international monitoring. And these are things we were promoting and proposing anyway. We also built this thing called the SPAC, S-P-A-K, which is constitutionally mandated anti-corruption, anti-organized crime court. And this also had prosecutors and investigators, and it's not part of the normal system, it's independent. And it's in the Constitution, so it can't be damaged. And then we also removed from what was normally in the judiciary and the prosecution controls over them from politicians. And we created new judicial prosecutorial councils that didn't have ministers and politicians, but had representatives from law schools and civil society and professions like judges and prosecutors. So why did we do this? Well, because of the corruption and the issues that they had, but also because of the ties to organized crime that were present, and the need to get into the EU that they wanted. In Albania, these are working. As of October 2022, the vetting of judges and prosecutors, which was looking for mostly wealth that they couldn't explain or ties to organized crime that they couldn't explain. They reviewed 554 out of the 800 judges. 64% of those resulted in either dismissals or resignations. So that 64% of the judges and prosecutors, in essence, either were dismissed because they had money they couldn't explain or ties to organized crime they couldn't explain. I guess I'm not going to get to the other two things that we talked about, but I want to just say is I got 2 minutes to spend to sign up. This is the most dangerous one. That's why I want to talk about most, and why when we have this dangerous thing we're proposing, we wanted to future-proof this against being captured. We wanted to future-proof all of these things from being captured. And what did we do? First, we worked with our national counterparts to really understand the political history, what was needed, what was important for them. We were realistic, and we did the drafting of the constitutional amendments. We had international partnerships for all these institutions, and including this international monitoring body. And that was something that was with agreement and an agreement between the EU, US, and Albania. We created layered checks and balances. What do I mean by that? Instead of it just being checks and balances between the things at the top, the courts and the executive and the legislature and all this, the appointment processes also had checks and balances within it as well, so that not any one body could really dominate the appointment process. And we also created clear mechanisms to clear up deadlocks. There's a history of a person intentionally trying to deadlock the process so that they could keep a constitutional court from being filled and having a quorum, or having some other body that's important be filled. So we created mechanisms to stop that. Okay, I'll just conclude really quickly. Okay, so the important thing was that when we were doing this, we were looking at future-proofing this and looking at trying to keep these things from being captured. We didn't think that the government was going to be tending towards autocracy, and they were going to be legitimate in their moves towards the EU, but you never know. And you had to be careful. And we wanted to make sure that we were not going to be creating a situation where we were giving them tools to more quickly capture the country. So the lesson I really want to say is, when we're doing this kind of work, and again, I agree with a lot of the things that were said today, but we need to start thinking about having a rule of law 2.0 toolbox. Maybe not what I just said, but in each country, thinking in a way that makes backsliding more difficult, that we have diplomatic priorities, that backsliding shouldn't occur, that we work with them to create a system that works in the system they are doing, and not just translate and cut and paste from one place to another. So we do need this new approach, new toolbox that can be used when we're doing rule of law work overseas. And just remember, there is a playbook out there that is working to undermine these. And if we have more attention paid as we're trying to think of new ways to do this, we can have a playbook where we're not cutting and pasting out of, but approach that we actually have to try to forestall the backsliding in the places that we've already had successes. Thank you.
Right. Thank you all so much for your remarks. And fortunately, we have reserved quite a bit of time for questions, which I'm hoping we'll be able to take thorough advantage of. So before I open it up to the audience, I have a couple of questions of my own that I'd like to pose to the panel. So to start with, we've been hearing quite a bit today, including in Betsy Anderson's opening remarks and the keynote address, that much of the conversation in the rule of law community today is around people-centered justice, or putting people and their needs, not institutions and processes, at the core of justice. So looking at this in light of some of the remarks that you've made, do you see a people-centered approach being applied to rule of law strengthening in the United States? And if so, how? And if not, how might we use a people-centered approach to address some of the rule of law challenges our country is facing today? And I open that up to any of you who would like to respond.
Well, I'll tell you from an ABA point of view, it's frightening how little access to justice there are for most people. And as we went through COVID, and after 2008, more people sank down economically. And we cannot get the reformers to deal with it. Lawyers are terrible. Bar associations, oh, well, we can't have non-lawyers doing some of that stuff. And you can't get it done without technology and non-lawyers. The medical field has learned that. And then when you want to get more funding for the Legal Services Corporation, politically that gets blocked. So it's been a real problem. And it was way back when, before you've all ever heard about rule of law, the Watts riots, there was a commission report that said one of the reasons we had the riots was lack of access. People felt so isolated, and we run that risk again. So this is one, we got to get our own house in order, and we're not there.
So this may not be directly responsive to your question, but the question is important because we really need to be talking about, I'm not sure the best, is that better? Okay. We need to talk about the grassroots. We need to talk about the people upon whom, towards whom the rule of law is being directed and imposed. We need to think about it in the United States. We need to think about it internationally. I have to say, during a lot of the discussions about the rule of law, and I'm the historian here, and I'm not the practitioner of the rule of law, but from a historian's perspective, you know, it ends up looking a little bit like some of the practices of the colonialism era, right? The US took the rule of law to Hawaii by taking Massachusetts code there in 1893 when it overthrew the Hawaiian kingdom and imposed moral codes on a country that had different practices. So all of a sudden their family groupings and sexual relationships were illegal. So then law enforcement gets imposed upon them. I mean, the sort of the relationship between a rule of law project and the people who are ultimately subjected to the rule of law is tremendously important. And so I on some level have a question for the rule of law practitioners. I mean, on some level, you know, how do you take the people into account? In the civil rights era, when the US was trying to promote the rule, you know, trying to enhance the image of the United States overseas when it was devastated by civil rights abuses in the United States. You know, once African countries became independent, sometimes the calculus changed, because what the US cared about in Kenya was, do we have basing rights, right? Can we put our, you know, our weaponry in Kenya? Not, is Kenya protecting the rights in its nicely formulated constitution that, you know, Thurgood Marshall helped them to write, right? And so I think if I was sort of thinking about rule of law issues, I'd maybe less about backsliding, because is the backsliding coming from, if it's coming from social movements, if it's coming from an opposition to a particular model of law that doesn't fit with local or indigenous practices. So that's sort of one of the questions I have, just thinking about the way that, again, historically, the rule of law, the idea of the rule of law
has sometimes meant imposing a set of practices on a culture that doesn't sort of map out on it. And US interests are ultimately driven by what's in our diplomatic interests, what's in our military interests, what are our sort of overall international objectives. And the rule of law is a tool of that, right? As opposed to being an independent, you know, the rule of law wouldn't be prioritized unless it was conceptualized as being in service of more core U.S. objectives in the world. That was certainly the case in the Cold War and other eras. But the people part of it, and then I actually would have said more earlier, but I had no idea I was under my time, which has to be a career first. But I didn't have a watch. But the issue of sort of people power is tremendously important. And it was the civil rights movement that enabled some level of rule of law reform within the United States, because when American leaders were getting tired of it, the movement, including uprisings in Watts and Newark and other cities around the country, objecting to police violence back then, that those uprisings helped put certain kinds of social justice initiatives on the agenda. It didn't necessarily mean rule of law, right? Unless it's a strong civil rights movement that has enforcement capabilities. But what's happening there is achieving some level of justice that sort of reaches the ground level, as opposed to how pretty does the legal structure look, right? So just a sort of a long way of saying, whether we're exporting a rule of law or encouraging the enforcement of a particular rule of law, or whether we're thinking about practices at home, people have power. We see that in other countries. It's sometimes horribly suppressed, but the bravery of Iranians, oh my, and the bravery of civil rights demonstrators in the United States during the civil rights era, facing horrible violence, and you know, it's on some level, it's the people power. And it's the bravery of local people who have, you know, for leaders, I would say, you know, being attentive to that voice helps make sure that you're not essentially applying a template that's just a matter of sort of, you know, government power. We want things to be tidy. We want people to behave. But instead is trying to achieve sort of a set of ideas that go to core ideas of justice that should really be at the heart of whatever our rule of law might be.
I think I'm going to answer the original question, which living overseas and working overseas and then coming back to the United States, I don't think that, especially as we're here in a law school, we're practitioners, we're steeped in this legal, you know, system that we're in. We don't realize that it's overly complicated. It's got many inefficiencies in it, and you know, if you would compare it to another country, a lot of other countries, you would say that it's not people centric. You would say that, oh my goodness, this is, you know, many people who come here who are from a foreign system are just amazed at how, you know, I mean, this judge and that court and this process. So I do think that we do have a system that is, you know, by history and by nature and by overly complicated and is not giving itself to being people centric. And I think what you said about, you know, as a profession, we're not addressing it very well, and as lawmakers are not addressing it very well. And I think that's true. And I think it's a missed opportunity that we could really address here.
Thank you all. Before I open it up, I think I'll ask one more question of the panel. Professor Dujak and Mr. Ide, during your remarks, you both indicated that for the United States to credibly advance the rule of law around the world, we must first embed and protect the rule of law here at home. And so my question would be, from a practitioner's standpoint, is it possible to marry rule of law reforms here in the United States with international rule of law promotion? And how would you advise the next generation of rule of law practitioners to approach international rule of law promotion, recognizing the challenges we face at home?
Well, you've got to get a movement going globally. And we in the US can't show up in any other country and start lecturing them. But what we found at the East-West Institute, which I was very active, was we did track 2 diplomacy, where we would back channel into influential people in the country to discuss reforms. And that's what you want to find. Now, the International Bar Association does a great job, and they cooperate with the ABA. Europeans would be much more knowledgeable about Africa and other places than we would be, and they would probably have more contacts. So we have to do what I talked about earlier. We have to do our reformation, but there's so much to learn. And I watched Justice O'Connor and Justice Kennedy spend time in the summer talking to Europeans, and then they come back. In India, you can quote US precedent. And so a global answer is, where you form a network. So bar associations can do that, but NGOs can do that, because to succeed in the country, you've got to identify a reformer there. They can explain to you how it works. I was in a meeting in Nigeria where we were trying to persuade a group of government people with Andrew Young, actually. And when I left, I said, I don't get it, because the person that had the highest stature in government would constantly look to this other person who didn't. He said, well, you got to understand, he was a Muslim and he wasn't not. And so that's the way it works in Nigeria. So you have to get a global movement going, and it helps us here and it helps us abroad.
So I have to say, I always feel a little awkward because I'm not in the sort of rule of law literature or sort of those activities. So I'm coming at this from a different perspective. But in thinking about the relationship between building the rule of law in the United States and internationally, one example of how to go about it is the relationship during the civil rights era. There were many relationships between civil rights activists and emerging new African governments. And, one example is Thurgood Marshall ends up getting invited to help draft the Independence Constitution of Kenya, and had a, not very meaningful, although and very intense during a limited period of time relationship. Some others, Kevin Gaines has written about African Americans in Ghana during the independence era, and Polly Murray, the tremendously creative and important civil rights lawyer, isn't as famous as the civil rights icons, but she worked in Ghana, actually ended up getting thrown out at one point because of differences over rule of law related issues. But establishing relationships between movements can be really important, but you see, it can't come from the government. But perhaps the government or nonprofits can fund it and support it and provide avenues of communication. I mean, that was certainly happening in Kenya with Thurgood Marshall when he was at that point he was he was still at the Legal Defense Fund, not yet a judge. Yeah. I think it would be great to
Do you want to?
I think one thing just to say about having been overseas and working and trying to explain maybe that we don't do things that way, and things are not maybe so good in the United States on that topic, but we're working on it, is a powerful statement to make. When you can't even say that we're working on it, that's a powerful statement to make.
Thank you.
I'm going to add one thing, that South Africa is a good study, because there the Sullivan principles, where enough pressure was put on major corporations to pressure them against apartheid. And so there are examples where you try and get the business community, because they're multinational, and you try and do that. But I guess I can tell one story out of school. So I was with Andrew Young, and we were in South Africa, and we did a courtesy call to Mandela. We walk in the door and he says, "Andrew, we've got to get the king's daughter in the University of Indiana." And that's sort of the way it worked. And during apartheid, a lot of the children of those people were educated in the United States, and civil rights people are the ones that created great connectivity.
Excellent. Thank you so much. And so now I'd just like to encourage people to line up at the microphones and ask questions of the panel. Yes, we have a question over here.
So I'd like to address my question to the historian on the panel. Yes, Dr. Dadziak?
Dujak, yeah.
Yes. So for most of human history, might makes right seem to be accepted, particularly in international relations, going back to the days of ancient Rome and Greece and before that. And it seems to me that we have had a golden age of the rule of law since about 1945. But now there's been backsliding and a big challenge. And Mr. Putin is trying to drive human history back to the days of might makes right, and that is yet to be resolved. So my question to the historian and anyone else who wants to respond to this is, to what extent do you think that human nature and the trait of tribalism, the trait of fear of the other, is driving this backsliding and what seems to be a very troublesome acceptance by many Hungarians, maybe many Poles, many people in my native country of Romania, hearkening back to totalitarianism. And as a footnote to my question, and I don't have a solution. I think back to the Greek philosophers who talked about the political cycle between democracy and oligarchy and totalitarianism. To what extent is this backsliding that we're witnessing today a reset of human history? I hope I'm wrong in suggesting that, but I would like to hear your opinions.
Well, you asked my opinion, so I think historians would we'd have some fights about, have the years since 1945 been the heyday of the rule of law? I mean, what do we mean by the rule of law? I was telling the story about the civil rights movement, which was a terrible violation. The sort of abuses were a violation of the rule of law, of any conception of justice, and that was eased over time. But what else happened during that time period? Well, 1941 was the last year in which Congress passed a war declaration. Nevertheless, the United States has been militarily deployed and at war every year since then. And a major war in Korea was the US engaged in that war against the objection of many members of Congress without even asking Congress to declare it. That helped unleash the sort of tradition of completely lawless, from my perspective. Now, the lawyers who do national security of law, of course, would object to that. There's a whole legal structure relating to the use of force, but the basic democratic principle, the underlying constitutional principle that the government, that the president can't do it on its own, that there has to be democratic buy-in, and that should happen before you put troops in the field, because after you do that, Congress is going to line up and appropriate the funds. So before you commit the troops, there has to be a war declaration. So we have this sort of essentially, I would argue, violation of the American rule of law all through that period. That's and that legal infrastructure, that the sort of all the Office of Legal Counsel opinions saying yes, it's okay, it's okay, it's okay, building upon themselves. That's quote unquote law, but it's in tension with the underlying constitutional principles. So if that's an era of the rule of law succeeding, I'm sorry, I would have to argue that it hasn't been succeeding within the United States. And so we can't just look at a foreign leader like Putin and say he's the one who's lawless, because we have plenty of lawlessness to look at within the United States.
I might just say, I think one of the things you were asking was whether fear of the other was a cause of that. I think for people who are trying to seek power and hold on to power, especially looking at Eastern Europe with the Syrian refugee crisis and the pressures among people to build, their own walls to keep people out, gave a reason, but wasn't the reason for the totalitarian tendencies. It was just an excuse.
I would just add that Putin's all about nationalism and fear. If young people are still taken to parks where there are old burned out German tanks and told that we protected you from Mother Russia protected you from the Nazis, he uses that same kind of fear thing on the West, but his economy is terrible. So if you talk to most people I talk to, Russia did us a favor in a way because it pulled the West together over the Ukraine, and we'd been sort of shattered by gold alone earlier. China is the big question, and we just don't know where that's going to go. The business community is starting to pull out of China as rapidly as they can because they think that there probably will be a Taiwan incident, and they also, the supply chain was such a problem with the COVID restrictions. But there's a possibility that there'll be two systems operating. There'll be the autocrats, the Russians and the Chinese, and then there'll be the Western side. And if we can get away from the warfare side and get on economic competition, that's the goal. And it's just not clear. Not clear. It's clear what Putin's doing. He just wants to stay in power. And I think that ain't going to work in the long run. But China is much more complicated.
Thank you. Do we have any other questions? Please.
So Mr. Ide, I really enjoyed your talk, and I guess I wanted to comment about the way we talk about America, like America's backsliding and the rule of law, and we talk about it in general terms. And I think if we're really committed to the rule of law, which I am, I think it's a brilliant thing, and I fear our country. I think we have to be specific. That is, when we talk about Putin, in America, it's not that America's backsliding on the rule of law. And you mentioned the January 6th Commission. If you read, I recommend it to everyone. Read the summary. Chairman Benny Thompson and Chairwoman Liz Cheney specifically talked about a violation of the rule of law. Both of them mentioned it in their preliminary comments. And what they're talking about is a violation of the rule of law by President Trump, by the lawyers around President Trump, by the congressmen who supported this effort. So we can go on and on. If we talk about gerrymandering, let's be specific. The Republican Party in Wisconsin got less than half of the vote, and they hold 2/3 of the seats. Let's talk about legal aid. You talked about the problem with legal aid in America. Well, the problem with legal aid is that the Republicans keep cutting legal aid. So I think if we're going to come to grips with it, the conversation has to be a little bit less polite and very specifically directed at where the problem lies. Let me add one more thing, by the way. I'm not a Democrat. I don't like either party, and I have lots of bad things to say about the Democrats too. But on the rule of law in particular, and I'm going to repeat something I said when I was on the panel, it wasn't America that didn't hold a hearing for a Supreme Court justice for 8 months and then rammed one through 1 month before the election. And by the way, the justification for not holding the hearing is it's an election year, let the people decide, which somehow didn't matter when the Republicans were in control. So anyway, if we're going to come to grips with America's problems, I think we need to be specific. Just as we talk about Xi Jinping and we talk about Putin. By the way, I'll say one other thing about Liz Cheney. She was declared persona non grata within the Republican Party. That is her punishment for taking a stance on behalf of the rule of law. I admire her. I think it's incredible bravery that she did. And I hope that more Republicans come out and oppose the tendency within their party. And I'm not just talking about extreme elements, because Mitch McConnell's not extreme, that have sacrificed for their ultimate political vision some of these long-standing American legal institutions. And then I'm just commenting on it because I really liked your comments, but I don't ever hear responsibility being placed specifically. This is not America. It's a particular agenda that's been aggressively implemented. And I hope we can get to the point where we start talking about it like it really is. Okay. Thank you.
Thank you. Before I hand it over to the panel, I think just for the sake of time, I'm going to also take the question over here so then the panel can address both at once.
Sure. Thank you so much for a great talk so far. My question is directed at the two of you who explicitly mentioned the idea of preserving or increasing US rule of law to effectively signal it abroad. It seems to me that as part of that formulation, there's not only the element of the protection of civil rights and other aspects of the rule of law in the United States, but also how that's communicated to other places in the world. So for example, in Russia, it needs to be translated into Russia, in Turkey, into Russian, it needs to be translated and broadcast in Turkish media, and so on and so forth. I wonder if you can comment on what might be successful rule of law communication strategies that ensure that when those efforts are being undertaken in the US or other global leaders that countries might look to for examples of the rule of law, that it's being effectively communicated and maybe not manipulated by those in power in the particular places with poorer rule of law who might have incentives to manipulate how the US is perceived.
Let me just sort of take up that point and then pass the mic on to my colleagues. The Cold War example, I think, is helpful here, and basically this is where I think the U.S. government is already geared up. I'm sure, even though I don't know about their current practices, I know about their practices in the 50s, 60s, and before. But you know, the U.S. During the Cold War established libraries in other countries. The U.S. prepared materials. Actually, there was a pamphlet called "The Negro in American Life." It was a propaganda pamphlet. It basically said, "Look, from slavery to freedom in 1950." Blacks used to be enslaved. Now they're bank presidents. Now they go to college. They were segregated schools, right? But this was a good news story. The state of Black America in 1950 was a lot better than it was under slavery. And so that was a way of responding to Soviet propaganda. And those materials were made available in the languages of the other countries. So the ability to sort of get the word out to other countries is certainly there, and the U.S. American diplomats, have the language skills. I think what I would like to see is, I do think that there's so much promise in, the sort of the ground level sort of activist to activist, people to people, sometimes outside of the control of, federal government programs. But, the federal government doesn't want to support that, but too much, because they want to make sure that a particular kind of message is communicated, and that you're not feeding into sort of Russian propaganda and oppression. So I think that that's something that the federal government, I worry a little bit about, is the rule of law that's being promoted responsive to the local population, in an area, but I'm not worried about, can the U.S. government communicate effectively to local people, because they're geared up for that.
Well, Radio Free Europe was the old way, and it's gone. Now we're into social media, and it's very confusing because the government doesn't control a lot of Microsoft and Amazon and those folks, AT&T. They control the pipe. They control a lot of stuff. So when you get down to content, but the Russians, they snuck up on us. They really worked on social media before we realized there was a Cold War going on. And but I think we're playing a lot of catch-up ball. But one thing that's interesting is the military talks a lot about soft powers. They said, we're in a world now, you tell me to go in Afghanistan, take over a village, I could do that. But if you don't take care of those people, you're wasting your time, because the Taliban will come in right behind. So we still have some thinking to do of where we spend our money, and how do we best influence people.
I'll just say is, being on the other side of the world when something happens, it used to be, and there is still, Voice of America and these sort of things that do play every once in a while, but there's so many sources of information in the United States. It's so easy to get that any version of the story that we have here, depending on which side and which version you want, can be plucked, and then they can say this U.S. newspaper or this U.S. web source is, says this. So it's very difficult to actually shape an American message overseas, because there's so many American messages out there.
Great, thank you. Well, since we're essentially at time, I think I'm going to end things there. So can I ask everyone to join me in thanking our distinguished panel? And thank you to everyone, all the previous speakers. It's been an excellent day, and I will.
Thank you all so much. And I realize we're at the end of the day, and I'm the only thing standing between you and the reception. So if you'll bear with me just a few more minutes. I'm Rita Sheffy. I'm the Assistant Dean for Public Service here at the law school. And thanks to Eric for asking me to make a few concluding remarks. And they'll be very brief. I just have two things I want to do. But before I do those, I want you to help me give another round of applause to this panel for a great session. So the two things I have to do, one, and you've heard some of this earlier today, but one is to give thanks to some people for making this such a successful program. And the other is to give you some suggestions about how the conversations that you've had today, how those can be continued beyond today. Because it's been a wonderful symposium today. And Patricia, I have to think that your dad would have been very proud of the conversations that we've had, but he also would have wanted to know that it didn't end today. So first of all, let me do the thanks. Special thanks to all the panelists and the moderators for their diligent preparation and their thoughtful insights today. We're honored that they all spent their time with us today to make this such a success. And of course, they're all welcome back to campus anytime. But I also want to thank all of the attendees today, because you're part of what makes this successful as well. So thank you all for spending time with us. Thanks also to those who have worked behind the scenes. That includes our technology staff who took care of the video, the sound, and the lighting. And I'll especially call out Brandy Williams, who's back in the booth, for keeping us on track with the technology today. Our operations, cleaning, and security staff who have allowed us to gather safely and comfortably, and so many of my other Emory Law colleagues who provided invaluable support. And I'll thank them in advance for the catering staff from Emory Catering, Nicole's Catering, and Oakhurst Markets, many of whom are out preparing the reception that you're going to enjoy shortly. And next, I want to thank particularly Eric Wang, but also all the students on the Emory Law Journal for their hard work and dedication over so many months. And I really think this is so important that with all of those students who've been involved in this, would you please stand up so that we can thank you? I know many of you have been involved in putting on conferences and symposia and things like that, and you know that it does not happen without a village, but it takes some leadership at the top. And for students to take the leadership on this and do such a great job is really remarkable. So I really applaud everything that they've done, and particularly under Eric's leadership. And of course, last but not least, I want to thank the Thrower family, Patricia Barmeyer, Wilson Barmeyer, for your generosity in making the event possible, and to the Thrower committee for their loyalty and faithfulness to Emory. So now some of you may be wondering what next, and how do we carry the conversation beyond today? And so again, thanks to Eric for helping me pull together some of the thoughts that we have about how you might do that going forward. So first of all, the keynote and panel recordings, as well as with previous symposia, will be on the Law Journal's website symposia page. And some of our speakers today will be submitting pieces for publication in the Emory Law Journal. So stay tuned for volume 73 next academic year, which will likely be published in 24. These scholarly pieces will expand on their remarks both descriptively and prescriptively, and through their footnotes will provide an abundance of other rule of law sources you can explore. I'll just mention briefly some of the panelists. We won't restate everything you've heard today, but you can look up these panelists and moderators and read and engage their works. You'll find all their names and biographies in the printed program, and their biographies are hyperlinked on the symposia website. Check out their faculty or practitioner profiles. These speakers have published or led the publication of a wealth of books, articles, reports, essays, and so much more. And they've given talks all around the world. And there was no way they could encompass all of that in their brief remarks today. But just a few examples, you might read and use the World Justice Project's Rule of Law Index and watch Ms. Anderson's other lectures online. Read Professor Gowder's second book, The Rule of Law in the United States, an unfinished project of Black liberation, which is entirely free online at rulelaw.us. Check out the literature published by Professor Nalipa's Transitional Justice and Democratic Stability Lab at UChicago, or by Professor Veersteg's Human Rights Program at UVA. Read one of Professor Tamanaha's prize-winning books, watch one of his named lectures, or for starters, read this helpful and well-cited A Concise Guide to the Rule of Law. And you can also read Professor Flaherty's book, Restoring the Global Judiciary, recently published by the Princeton University Press. So beyond all of that with our speakers, there's lots of opportunities at Emory Law related to the rule of law abroad. You might check out events from Emory's Center for International and Comparative Law, led by Professor Martha Feynman. And the center just hosted Dr. Kim Lane Sheppel, who gave the annual Henry Biederman lecture entitled Destroying Democracy by Law. Also check out events from Emory's Center for the Study of Law and Religion, led by Ms. Whitney Barth. The center is one of the leading, if not the leading center of its kind in the world, and it publishes a wealth of literature on theological and philosophical foundations of concepts related to the rule of law, human rights, human agency, freedom and dignity, justice, and agape love. Emory students, of course, you've seen the course lists, and you could take a course with Professors Dujak, Smybert, Ludson, or Tulabaka, all of whom were involved today. And of course, I would be remiss if I didn't mention Emory's longstanding partnership with the Carter Center, which is a short drive from Emory and has robust programs focused on the rule of law, human rights, and democracy, and tons of opportunities for students to get involved. And we often have students who work as interns there. Of course, you had Dr. David Carroll earlier as the director of the democracy program at the Carter Center. Ms. Hillary Forden is the senior associate director of the rule of law program. And last year, you might know, Emory celebrated 40 years of this partnership with former President Carter, once calling it a marriage that has worked out quite well. And I'd say we think so too. Beyond Emory locally, we have the National Center for Civil and Human Rights, which curates informative and incredibly moving exhibits on rule of law related issues abroad and America's own rule of law issues at home. And with Mr. Ide, a former president of the ABA, we invite you to check out the ABA's Rule of Law Initiative, ROLI, and their persistent and global work. And you might read a recent ABA book, Building the Rule of Law, Firsthand Accounts from a 30-Year Global Campaign. And of course, we encourage Emory Law students to be invested in the bigger picture, and there's many ways that you can invest in the rule of law and more broadly to steward the tools of the legal profession for public good. It can be a career in the public interest, or it can be through pro bono work. And both Mr. Ide and Ms. Anderson spoke about the need for legal services and the lack of legal services for a lot of the people who need it most. And I have to say, after listening to them, I'm even more optimistic because what I see every day are the students in this law school who are engaged in pro bono work while they're in law school, public interest internships, and are looking toward futures. And they're going to be the ones who are going to help us bring this forward into the future. So I'm optimistic because of what I see every day with them. So as I close, I would be completely remiss if I didn't invite all of you to our next big event in this auditorium, which is next Tuesday evening. This is the Emory Public Interest Committee's Inspiration Awards. This is a signature event for the law school where we raise money for summer grants for all of those great students I mentioned to have some stipends when they're working in these unfunded public interest and government positions for the summer. This year, we're going to honor the executive director of the Georgia Asylum and Immigration Network. We're also going to honor Emory Law Professor Emeritus Charlie Shaner, who among other things was a co-founder and director of the Emory Volunteer Clinic for Veterans, and Drew Early, who served as the director of that clinic for nearly 8 years. This also marks the 10th anniversary of that clinic. You can register on the website, or I put a poster just outside the door with a QR code that you can scan and register as well. So we'd love to see many of you next Tuesday evening. And finally, this symposium happens every year, and it's a great CLE opportunity for attorneys. And this year, thanks to the Thrower family, the cost is exactly the cost that the bar charges a provider of CLE credits to offer them. So we appreciate that. So now, please join us for refreshments and have conversation with these panelists and the others who are with us, and also with the students, and give them a chance to relax and enjoy a little bit. And make sure you have your parking validation before you leave us this afternoon. And again, thank you all for such a great attendance today, and I hope you have a great evening, and we look forward to seeing you again soon.